Welcome to Baker's channel where stories unfold, covering trials, dramas untold. Grab your seats, settle in, start the show. Courtroom clashes, the fun we bestow. Baker's channel, action's hot, dramas and fun, all we got. Discuss, debate, break it down. Baker's channel, just the best in town. Lawyers smart, tensions high, sparks fly. We laugh, we learn, dive into the why. Join the chat, have your say, it's your place too. Every twist, we're here for you. Baker's channel, action's hot, draws and fun, all we got. Discuss, debate, break it down. Baker's channel, just the best in town. Join the crowd. Baker's channel, we're live and loud.
Good morning, good evening, good afternoon, wherever you are, whoever you are. What, if anything, Skype might be? Or reindeer? Yo. Hey, Corina. Ellen from Holland. Kickboxing mom. Hey. Not Josie. Jody. Venus. Irish. Hey, Brian. Celestial. Carla Birkiewicz. Joe. Well, I will try to keep you entertained while you're working. Brigitte. And Toy La Carissa. I have to remember to put this up. Welcome, everyone, to day 5, which I believe will be the last day in the defense part of the case. We don't know if that expert was allowed to testify that they had Dorbert hearing about Friday. So that's going to be interesting to see. And I still believe it's a mistake they didn't finish with her on the stand, especially the way that cross-examination turned out. I think that would have been a perfect trial strategy, perfect way to end a defense part of a case, because that prosecutor really, I think, shot herself in both feet. Sammy spills the tea. Morning, Baker and crew. Let get me through this workday. We will try, and hopefully it won't be a day of sidebars. I have a suspicion, because every witness the defense will pull up, I think that the prosecution will argue against. So I'm afraid it's going to be a whole lot of sidebars today, but I hope Father Time has been home and thought about it and figured out that he probably shouldn't waste too much time, maybe work more on his closing to talk about the state of mind she was in at the time, instead of, I'm sorry to say, that expert they had the Dorbert hearing on, he was a rambling fool. I think he will bore the jury to death. So again, I think his trial strategy is wrong. Cape Breton Island. Hey, Holly Mac. And Monsieur Fedorowski. Special K. Rain Man. Calgary. They have an ice hockey team. I know that. I think a Dane played for them once. TLA. Hee hee hee. Do I still have my buddy with you? We just had a crisis because apparently some other people in my cul-de-sac is dog sitting, so we have been fighting over territory. It's been a whole. She was barking like crazy, but she's back sleeping on her pillow, ready to protect Bakerhead HQ. Participation trophy wife. So good to see you again. Molly, I told you, it's almost like Jamie's dogs. Yeah, the angry spinster sisters are horrid. Yeah, but I think imagine sending it to the jury right after them seeing her going through that. Hallo, Schöner, wie geht's? If the snarky prosecution keeps objecting, it could go in another 2 days. Yeah, if we're gonna deliberate hear everything, court starting early. Nope. Nothing's really happening. Normally he'll start at 9 and ask if there's anything, and then we'll waste an hour about nothing. Hyacinth, good to see you. Well, Zach, go work or fish or something. Toots. The cross-examination might seem harsh, but if you know the case, then you would know the amount of lies Ashley says. Not sure if prosecution had proven it all yet, but might be brought together in rebuke. Well, that's because you have followed this case a long time. I didn't. I watched 2 pre-trial hearings, and that was it. And what I have seen in court, which is what the jury have seen in court, is a prosecution not proving much, no motive, no reason why she should have done it, and then an angry attack on a woman who completely broke down, in my opinion. So, and I think a lot of people need to know this case isn't what you saw in a paper a year ago. This case is what's been presented the last week. That means if you didn't hear it in court, the jury don't know it. Then you can know all about how she was a gold digger uh, who apparently was engaged to some other man, and she ran a string of, I don't know, but you know that. The 6 important people in this case don't know that. And I think a lot of people need to remember what a trial is about. It's what's been proven in court. I said the same during the Karen Reed trial, where everyone was trying to force their opinions on people. Said, I'll wait till I hear what they put out in trial. Yeah, but you got to know that this. If it's not in court, if it's not in court papers, it doesn't exist in the mind of the jury. They're talking about that it was to keep a report out of the eyes of the public, which still was being released. And he just said, you saw how she broke down. I think he had a way better case. We always winning. Hey, Sebastian. You should be excited. We're going watching old ships, remembering the good old days where we ruled the world. Hey, Patrick. Hey, Nick. Yeah, and when you come over here, Nick takes the flight the other way because he doesn't want to see the mighty empire of Denmark rise again. As a Swede, he's afraid. It's a shizzy raid. Welcome, shizzy raiders. Hyacinth, where's Richard? Bouquet in the house. Thank you, Grumpy Grandma. If it hasn't been brought in during the trial, the jury doesn't know. Yeah, and I think a lot of people, because I know these high-profile cases bring in a lot of stuff. It's the same with the Courtney Clenny stuff. When that finally gets going, or the Sarah Boone, we probably will have some knowledge where we are sitting there saying, but she did this and that. But if they don't put it in court, ain't gonna matter. Hey, Boosh. Thank you, Driama. Jenny and Pookie, I'll grift you any day. Guten Morgen, Susanna M. And I am totally fine with that. See, there's no forced participation on this channel that you must believe someone is either way. Even if you thought Karen Reed was guilty, which I couldn't understand on the factual basis, you were more than welcome here. It's just I didn't do a deep dive in this. We didn't follow the many pre-trial hearings like we did with the Karen Reed, and I still got flagged because I didn't want to pronounce 100% that Karen Reed was innocent, because I wanted to see the evidence. Because again, that's how the jury rules. Yeah, but it's hard because we hear the sidebars. We hear the ice cream trucks. Yeah, I don't know if you can hear the bell ringing, but we hear all the stuff that the jury doesn't hear. Yeah, I felt it was too aggressive. Hey, Tim Swoop. Hope everyone went back and watched the Stand Your Ground pre-trial of Ashley. Witnesses explained a lot. Well, I watched it that time. We watched it last Monday, Tuesday, Monday, sometime. No, I didn't go back and watch it because, as I just told Seth, if it's not in, it's not in. And the part about I might get confused now because my back is a little bit sore today, so my brain isn't working as well. Did they get the brother to no? That was in the Stand Your Ground hearing, the testifying about the text message about knocking the dog unconscious. We only have Ashley's evidence from the text she found while going through his old iPads, right? I can't remember right now. Jackie McGee. Me and Jackie McGee. Okay. Hey, Renee. The doctor's report was bad for Ashley. Which doctor? That, well, I found out that what I said when I saw that Dr. Benner, whatever his name was, that it felt like she was just in Denmark we call it put oil on the water to calm it down. She didn't want to erase a stink, and she wasn't honest to him, but she was honest to the doctor. To me, that could indicate she was afraid of him. Could also indicate she was a manipulator. I don't know. I didn't feel that doctor's report was that bad, and I don't get what that doctor's report had to do with the evening of the incident, because we know from her attorney that it wasn't to be discussed on that day that the defense, the state claims.
All right, good morning, everybody. We're back on the record in state. This is Ashley Benefield, 2020 CF 3014. Thank you for your patience as we've gotten started this morning. First thing, we had early this morning, a juror call in that there was some car trouble. Juror was running late. My understanding is all the jurors are here and they've been brought up. And then obviously I've had computer problems this morning. So we'll just get going. Anything you need to bring up before we resume with the defendant's case in chief?
Judge, the clerk notified me on Friday that we had not actually entered states 103 and 104. So I would like to go ahead and enter those. I don't know if the defense has an objection. We can do it in our case in rebuttal if we need to, but we did talk about them during testimony. I just didn't say the magic words.
I just don't know what 103 and 104 is.
I don't either.
Modeling picture and the mugshot.
Oh, actually, yes, we do have something to say about that.
All right, so you're just going to save that until your rebuttal? Okay.
Yes, and then just to put on the course.
There's a discovery issue with respect to those two photographs. We were never provided them.
Well, the mugshot.
All right. So I'm making a note that we have to have a Richardson hearing on that issue then.
And also just to, for scheduling purposes, at some point, hopefully before, right at lunch, I would like to have a discussion about whether the court would allow the state to introduce evidence from Dr. Broder that we had previously talked about before. I just wanted to get a ruling from the court so I know whether to get him here or not.
Okay. I don't know what evidence it is, so I'll just wait for you to bring it up.
Okay.
Defense, any issues before we resume?
No, sir.
All right.
Ready.
State, you ready?
Yes.
All right. You said ready.
Yes, sir.
Yes, because it's if they haven't given the other part the evidence they want to introduce into the case, that's a Richardson hearing. I think it's other states calls it a Brady violation because they have to disclose all the evidence they want to put into the case. Just go back to Thursday where the state was yelling that they weren't provided with text messages that in the end it was given to the defense by the state. So again, if they haven't turned it over and there's a Richardson, they shouldn't have been allowed to show it in court. And again, a modeling photo, we don't know when it was taken compared to a mugshot. Why?
All right, just want to make sure. Are you feeling all right?
I don't think so.
Yeah, picked up a little cold, but I'm good.
Same here. So I understand. Okay.
Of course.
All right, go ahead and have a seat. Welcome back, everybody. Good morning. I don't know who had car trouble, but I hope everything worked out. You've had time to kind of calm down from that. So we get started, and we left on Friday, the state was presenting its case. Do you need to ask you though before we get started, because we just had a couple of days off, did anybody discuss the case amongst yourselves in any way? Did anybody discuss the case with anyone outside of this jury? Did anyone do any research or watch any coverage at all about the people, places, things, or legal topics we've heard anything about? Everybody says no. Mr. Taylor, call your next witness.
Thank you, Your Honor. Defense calls Bruce Ferris.
Well, then they were allowed to bring him in. And I really hope they have prepped him so he doesn't give those long-winded answers.
stand with one, sir.
Certainly.
Face the person, raise your right hand and be sworn in.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Thank you. Morning, Judge.
Morning, sir. My name is Judge White. I'm going to be presiding over this case.
I just
Have a seat, make yourself
I
comfortable
hope
in that
that
chair.
they taught him
Get yourself
to
about 12 to 15 inches from that microphone.
be short.
It's pointed straight up, but it does adjust down, left, right, up, down, whatever you need.
Well, he can't talk about DV because they didn't put DV as a defense, but he could talk about battered spouse. I didn't think we had a ruling, so I don't understand. Ashley's coach witness. I don't know, coach witness. Yeah, but I really hope they have told him, shut the F up. After 10 words, just stop talking.
You just speak directly, a loud, clear voice into the microphone. It should pick up everything.
I will.
Good morning.
Good morning.
Will you tell us your full name, spell your last name, please?
Bruce Eric Ferris, last name Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor.
And how long have you held that position?
I've been doing that for 14 years. I've counseled individuals I just recently counted 1,000 clients, not including group work I've done. I also am a consultant in domestic violence and testify as an expert court witness in domestic violence.
Let's talk about your education for a minute.
Okay.
Please enlighten us.
I have a Bachelor of Science degree in civil engineering. I graduated from the Police Academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
And do you have any specialized education or training in a specific field?
Yes. Been to a lot of training seminars and certifications and various conferences. In my curriculum vitae, I'll call it a CV, my resume. There's about 100 items listed of trainings that I've been to over the years.
For what specific field?
In domestic violence and mental health and trauma to children and trauma in general. And I could go on, but that's the general focus of all my work.
Let's talk about your work experience for a moment.
Oh, okay.
Tell us about
What is he reading off of? He did the same thing Friday. He's not allowed to read off stuff.
it, please.
So as a counselor now, my day is spent seeing individual clients. I specialize, like I mentioned, in domestic violence victimization, both men and women. I also see generalized mental health issues and typical things that a counselor would do, but I have a focus on domestic violence and family problems.
There was no result of the Daubert hearing. It was just they discussed if he could talk about DV or only battered spouse, and then he wrote it on a piece of paper and didn't say a word. So I don't know what he's allowed to talk about.
I also counsel adolescent boys, most of which are going through the foster care system or adoption or divorce of their parents, etc.
All right. And what position did you hold prior to that?
I was a police officer in Gainesville, Florida for 20 years. I graduated the Police Academy in 1993, got sworn in 94. I retired in 2013. The last 10 years of that career, I was a detective, uniquely running. I was the lead detective of what's called the Domestic Violence Unit of the Investigations Bureau at the Gainesville Police Department. Over the course of that time, when I retired, I looked back and did a little search, and I had arrested or filed charges or got warrants on 500 different abusers over those years.
Mr. Ferris, give us an idea of your professional credentials. Lightly.
Sure. I have I'm licensed with the state of Florida, like I mentioned, as an LMHC or licensed mental health counselor. I have to keep up with education, et cetera, keep my license active. I'm certified as a Batters Intervention Program facilitator. In case anyone doesn't know it, Batters Intervention, which I'll refer to as BIP, is a 6-month class given to abusers who are found guilty or on probation or could be part of their injunction order. And it's a curriculum based upon the Duluth Power and Control Wheel. And it's a psychosexual type, not sexual. It's a type of therapy that involves some counseling and some ownership and learning. And also was a certified police officer, I mentioned. I also have certification as a domestic violence danger assessment and level of danger scoring system developed by Jackie Campbell out of John Hopkins University. And I also have a certification as adoption competency training, mental health for mental health professionals out of Rutgers University. I'll stop there.
And briefly, have you been the recipient of various awards and recognition?
Yeah, I have.
Just a brief idea.
Okay. The Alachua County Board of Commissioners had nominated me to Governor DeSantis to be part of the Children's Trust Fund of Alachua County. I received the 31st Annual Martha Varnes Award for Outstanding Achievement in Prevention of Domestic Violence Against Women. I had recognition for valuable contributions in what's called crisis intervention team. I train officers how to de-escalate confrontations with citizens. I did receive the 2010 Distinguished Victim Service Award for recognition of outstanding contributions to crime victims for National Crime Victims Week by State Attorney General Pam Bondi awarded that to me, and Governor Scott at the time was there for the presentation. I'll stop
Who
there.
cares?
There's a few more.
Have you been recognized as an expert on domestic violence in various courts of the state of Florida before?
I have.
Approximately how many?
So I've been involved in 60 some cases as either consultant or expert witness. 50 of those I've been recognized by the judiciary as an expert in domestic violence, mental health, batters intervention, effects of DV on children.
All right. And when you say you've appeared before approximately 60 times as an expert witness, was it for any particular side in a dispute? That is to say, for example, in a criminal case, was it always for the prosecution, always for the defense?
But both. I worked for the state attorney's office and worked for defense. And a majority of my cases have been in civil court, though I have worked in criminal court also.
Would you, Mr. Ferris, tell the ladies and gentlemen of the jury what another definition of domestic violence is?
Well, so there's the criminal statutes of domestic violence, which are typically, we all know it's battery, assault, ag assault, false imprisonment, sexual abuse, et cetera, person crimes involving a family or household member against each other. And that has another definition, that's spouses or family members living together, or it could be a couple that had a child together and have never lived together. It doesn't include, let's say, cousins who've never lived together and aren't intimate in any way. But through my experience, I've realized that there's a greater, that's umbrella, and that has to do with power and control. The abuser needs to control their victim. Now, they'll use the criminal things, hitting, et cetera, all those things. But in a greater sense, there's also this, I referenced it earlier, the Duluth Power and Control Wheel that DCS accepted for the BIP class. I'd like to explain the Power and Control Wheel, if that's okay.
In fact, with the court's permission, we can perhaps have the screen come down and the lights dim. Mr. Ferris, you have a laser pointer in front of you. The little star in red will provide you with
Okay. Judge, may I stand here and pay attention to the mic as I talk?
Any objection?
So as I mentioned, there's the criminal definition,
Was
and
there a question, objection, was there a question?
Go ahead with the question.
Yes. What
No, we are just going over his CV, and now he's going to talk about that 5 wheels of abuse or whatever it's called, power wheel of abuse. And if Molly starts snoring on my table, I might fall asleep because I think he's the wrong witness at the wrong time.
is it that's on the
Right.
screen?
so what I'm,
Mr. Ferris?
okay, so,
Mr. Ferris,
yes,
would you please tell us what is on the screen?
I will. So this is what's referred to as the Duluth Power Control Wheel. And so there's physical violence and sexual violence. Those are the criminal things I talked about. And then there's these power and control aspects. And the nature of the power control is repetitive. It's a way to get control. So up at, we'll call it 1 o'clock, using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons would be an aspect of intimidating your partner, again, to gain control. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy, playing mind games, humiliating her, making her feel guilty. Then isolation, controlling what she does, who she sees and talks to, what she reads, where she goes, limiting her outside involvement, using jealousy to justify actions. Then a big one that I see often is minimizing, denying, and blaming, making light of the abuse, not taking her concern seriously, saying abuse didn't happen, making shifting responsibility for the behavior, saying she caused it. Another one is using children, making her feel guilty about the children, using the children to relay messages, using visitation to harass her, threatening to take the children away, male privilege, testing, treating her like a servant, making all the big decisions, acting like the master of the castle, being the one to define men's and women's roles, using economic abuse, preventing her from getting or keeping a job, making her ask for money, giving her an allowance, making her ask for money, not letting her know.
Do I seem irate and in a negative mood today? No, I'm just my back hurts, so I'm not in the mood for long descriptions. And I agree, don't gender stuff like that. Men are, you said it yourself, 2/3 of the cases you have was men, so it must be a problem. So don't gender it. Domestic DV against men is a big, not talked about problem that we should be open about, because they suffer the same.
Or have access to family income. And the last one is coercion and threats, making or carrying out threats to do something to hurt her, threatening to leave her, saying that he'll commit suicide, reporting her to the government, making her drop charges, making her do illegal things.
I have a couple of questions I'd like to ask you about that wheel that you demonstrated for us. Is this something that you created?
No, this was created by, up in Duluth, Minnesota, there was a domestic violence advocacy group and also researchers, and they looked through police reports, they interviewed victims of domestic violence who come through the shelter, and through a period of time, they developed these 8 items and created the power control wheel. This wheel is used around the country and actually internationally. Like I said, it's the base curriculum for the Veterans Prevention Program class I talked about, and it's taught quite readily all across America and by used by domestic violence shelters, et cetera.
How long has this wheel, if you will, been in existence?
Yeah, probably, I'm guessing 30 years or so, could be a little more.
Are there any agencies within the state of Florida that predicate their decisions upon the Duluth Power Wheel?
Yeah, the DCF accepted the power control wheel for the curriculum for the VIP class.
That's the Florida Department of Children's and Families.
They were the ones who were controlling the VIP class when it started up. Also, a lot of federal money, domestic violence, against women act, things like that have always promoted the power control wheel bill, and also.
As I said the other day, it's a 4-legged guy. I don't know. It's not my dog. She's cute anyway. So and she comes when I call her Molly. I don't have to say if she's a Shih Pei or a Great Dane. I'm a man. I don't know. I can hardly remember my kid's birthday. But she's a cutie pie. I think she needs an ice cube because It's a little hot here today, and she seems warm. So I'm gonna get her an ice cube she can chew on because my little baby is hot.
Giving out grants and education money.
Are the majority of abusers male or female?
Majority are male, but there's certainly a percentage that are female. I'd say it's at least 2/3 male at least. And in my practice, I have male victims.
And what about on the other end, the victims of domestic violence? What's the percentage of males and female?
So again, there's some different statistics. Somewhere between 2/3 and 3/4 are men, and
Are men as victims of domestic violence?
2/3 to 3/4 abusers. So that on the other side of that, they're 1/3 to 25% male victims. And I just got a male victim this past week.
Okay, so look,
Okay, I'm done.
I want to make sure we're clear on this.
Sure.
You told us that the percentage of abusers that are male is approximately 2/3, is that
At least
correct?
2/3. There's some statistics that make it actually higher.
Would you tell us, please, what percentage of domestic violence victims are female?
Somewhere between 2/3 to 3/4.
All right. Now, I want to ask you if you would educate us, Mr. Ferris, about whether or not there are common characteristics that abusers share.
And I certainly can do that, Mr. Cheller. Can I make one closing statement about the Duluth wheel? And
Sure.
Power and control. So I think it needs to be said, maybe I didn't say it, that the whole idea of the use of the wheel is to get compliance by the abuser with their victim. So they're looking to control them, and either they use those criminal, the battery, or they use emotional abuse or intimidation, or use different techniques to try to control them. So the victim of domestic violence is placed with wanting to have the least harm to them. So they get to a compliance, I call it equilibrium type of status mode, where they seek to get along, to go along. They don't want to poke the bear. They don't want, they believe that this is certainly a danger to be involved with this person, their mate, their spouse, etc. So they comply. They get this compliance mode, and they can certainly appear to society that nothing's going on, but there actually is, and they're afraid to display that because of the retribution that might happen.
All right, so this wheel then is the product.
It's a
if you
thing
will,
they
of
do a
the
lot
Science of domestic
on
violence
one and
over
trim.
the past 30
Right.
years.
And throughout my entire practice, the thousands of people that I've counseled and even the 500s I arrested, I see this repetitively be true.
All right. Now, would you please tell us,
I do. Thank you.
I need you to make sure you keep your voice up so that
Yes,
we
sir.
can hear you. Would you now tell us, Mr. Ferris, whether or not there are common characteristics that abusers share?
They can be anyone from all socio-economic stratas, and that's been my experience also. And I said, like I said earlier, predominance men, but also females.
What's the motivation for their behavior, abusers?
They want to control their partners. I find often an ownership type attitude. They want to control them.
How do they treat generally pets in the household?
Pets. So statistics have shown that abusers abuse pets well above average, more than average citizens would. And so I have two theories about that. One is that they're missing some empathy, or they tend to see things as objects. And so,
Objection, not responsive.
okay. Can I explain why they abuse pets?
Yes.
So if a pet belong to the female or their partner, the victim,
I'm going to object.
Can you approach, please?
This is the problem with this witness. He want to tell a story when he's not supposed to tell a story. I can understand why, to make it clear what he believes, but with as bad as the mood has been between the state and the defense should really rein him in, and that's why I said I hope they had coached him over the weekend. That's my opinion. That's a position you could have too, Russian, but don't believe it was warranted, but you think in her mind it was. It could be. It's cotton de Tulia. I don't know. It's fluffy. I don't know. I'm gonna have my other brother's dog in 2 weeks, and it's roughly the same size, but just twice as big. it's massive. So I don't think he'll be as much of a cuddle monster as Molly is. Yeah, and it'll give the prosecution an option. They'll give them the possibility to constantly interrupt. Yes. Well, as a talker, I know that too. It's because we are so interesting to listen to. We keep talking. Have three.
Mr. Ferris, would you describe for us what
Wide.
the term
This is wide.
coercive control means in a domestic violence
Sure.
relationship?
So coercive control,
Paul, if you didn't know, I'm kind of retarded.
acts of aggression, assault, threats and harm, punish, frighten the victims. And that fits in with creating fear, and it fits in with this whole continuum of power and control, a pattern that is developed to control the victim.
Do offenders always behave violently, or does the abusive behavior happen in cycles?
They don't always act violently in what common term of a battery or an assault. It can be accomplished just by threats and fear. And in terms of a cycle, there can be a violent or emotionally abusive state, and then a honeymoon side of state, and then it cycles back. In the field, we talk of a model of kind of like rain and sunshine. And
All right, and let me ask you, Mr. Ferris, does the victim always appear to be afraid or act like they are afraid of the offender?
Definitely not. Oftentimes, the motivation is to hide the abuse from friends, family, law. There's lots of repercussions if it's disclosed. One could be fear that the oppressor, the abuser, the husband, the boyfriend, the wife, whoever is the abuser, will harm them. So they're very scared. The other is they might not even understand that they're victims of domestic violence. Quite often, when I get clients, people don't know those definitions.
How common is it, Mr. Ferris, for a victim of domestic violence to smile and act happy in the company of the abuser?
Very much so, and also in terms of even in public or with family.
Why?
Because they're afraid. They found this least resistance. They're trying to not poke the bear, as we'll say, or we've all heard the term walking on eggshells. They're trying to avoid aggression by their partner because they've grown to believe that there's a threat here.
So could we characterize that as an appeasement?
Totally appeasement. It's something I see quite often. And
what is the victim trying to accomplish by engaging in the appeasement behavior?
Not encourage him to be abusive to herself, or if there's children involved, she's putting up a front to again create a type of stasis or minimum amount of aggression. So they don't want to poke the bear. They're afraid of the repercussions.
All right, now give us some insight into this, if you will. Does the introduction of a child change these dynamics at all?
Yes.
Tell us how and why, please.
Okay, so it definitely ups the ante, we'll speak.
Objection. I have the same objection as at the bench.
I'll overrule on this one.
So yes, definitely, if someone is single and they're being abused, certainly they want to incur least amount of abuse. But when a child's involved, now they're concerned, and if they have a strong maternal instinct, now they're concerned about their own safety and their child's safety. And abusers will use a child as a manipulation tool to try to get at the victim. So the victim, that's even a further degree of way to pacify. Oftentimes women will stay in marriages because they want to protect the child, even though it's detrimental to themselves.
A couple of questions about abusers, if I may. How do they generally rate on the scale of ability to charm and deceive others?
Quite highly. Those 8 years I taught domestic violence crimes, I got to know quite a few, and some were individual therapy clients also. Many of them, I used to say, have the gift of gab. They were very personable, friendly. Not all of them, but a large percent definitely were very much the charmer. They'll hide the abuse, and they use it as a strategy to influence or control their victims.
Is there a pattern? Excuse me. Is there a pattern, Mr. Ferris, of denying, rationalizing, minimizing, or blaming the victim in these relationships?
And I can say a very high percentage, well, I don't know, over 90%, I'd estimate, of all my cases involve minimizing, denying, blaming. In fact, on the power and control wheel, I guess it's gone. It's one of the 8 categories is minimizing, denying, and blaming. And it's all a technique that she made me hit her. I didn't really do it. It wasn't that bad. They're always trying to minimize and talk their way out of their being abusive.
Would you explain to the ladies and gentlemen of the jury, Mr. Ferris, is there a particular time in these relationships when violence is most...
I have a pet peeve. If you drink out of a plastic bottle, learn to drink so it doesn't make a sound. He's squishing the bottle. You don't need to do that. You can just open your mouth and pour it in, especially when you're in front of a microphone. That's especially when we have to listen to it. And then when he's sinking. Thank you so much, Rubia. Thank you for streaming this trial. Well, thank you for watching. And thank all y'all for hanging out and discussing. I can see today we are very split on our belief in this guy. So it's nice to have you here.
most likely against the victim?
Yes, very much. The most dangerous time statistically is when a woman or a victim of domestic violence is leaving their abuser. And if the abuser's there, there's a high fatality rate, high incident of danger to them. I've been trained in this in my evaluation with John Hopkins' work. This is a really dangerous time. As advocates for domestic violence, we oftentimes have safety plans. Those plans, part of those plans, you never leave.
All right. I'd like to ask you, Mr. Ferris, if I may, a couple of hypothetical questions.
Certainly.
Involving the hypothetical abuser and a hypothetical victim. First, I'd like you to tell me, would the following acts be consistent with an abuser? And allow me to finish, and then you give your opinion.
I'm going to object to that.
All right. Do you want to approach?
Yes.
Wasn't there talk Friday that he was allowed to ask hypotheticals? Well, it's just I've always had it, especially on movies. I don't know if any of you watch Justified. Every time they drink of a beer bottle, they overdo the sound, the sloshing sound, and it throws me off. It's I don't know. I might be sensitive. I just hated that audio thing. Yeah, he is reining him in, and he's getting better at it. She didn't say she was leaving him. She was stringing him along. Yes, she wasn't telling him she was leaving him. Well, he is supposed to generalize. because he can't comment on this case because he didn't do a investigation on this case specifically. He had 100 and what was it? He said between 50 and 150. No, how many days was it? He said he had with Ashley, but he never did an investigation into this case. So he has to talk in broad terms. Yeah, it's a sound department issue, but it's just that sound department guy who thinks that the beer must always sound like it's almost empty. It annoys me. I have a brother who it annoyed me to high heaven when he ate cornflakes. He always chewed with his mouth open and it just amplified the sound. Well, and they, but that's the thing that makes me flip flop on this case. It's they were together. They got together. He had the vasectomy reversed. They had the kid. She moved away. They moved in close to each other. And as I understand it, he moved down to her, which I can understand to be close to the baby. And I thought they were moving to Maryland together, but apparently they're moving to Maryland separately. So I think the jury could be as confused as I am. Yeah, it looks like Gary Busey.
So, Mr. Ferris, I'm going to give you a series of hypotheticals, and I'd like you to tell us if it's consistent with abuse.
Yes, sir.
Yes.
Shooting a gun in the kitchen of a home in an effort to intimidate the victim to stop speaking. Throwing the loaded gun at the victim. Cruelty to pets. Punching a dog in the face hard enough to knock the dog unconscious. Throwing a cat down the steps, placing a tracker on the victim's car, an illegal tracker, throwing things, breaking things, yelling, screaming, belittling, cursing, humiliating, declaring such statements as rid the earth, being in a murderous mood, kill all the bad people, take them out, being caught at night, peering into windows of the victim's home, violating a no contact order by sending a package, driving from South Carolina to Florida to be able to follow the victim, suicidal threats.
Well, we had another victim tested. No, that was in the Stand Your Ground hearing. That dog had told him that the dog had jumped on his bare legs and he had pushed it down a little too hard. But then there's some text messages about punching the dog unconscious. So again, it's if you believe Ashley, you believe that happened.
If the victim leaves,
Yes.
more than 30 years age difference, and finally, prior marital history whereby the prior wife explains how she was beat up on the honeymoon. Would that be consistent with abuse?
Absolutely. And not only absolutely, but those are checklist points right off the Duluth Power and Control wheel and right off my experience, they're stereotypical abuse techniques.
All right, and now my last question for you, Mr. Ferris, is I'm going to give you a hypothetical. And tell me if this would be consistent with someone who suffers from abuse. Sending texts that are conciliatory with friendly emojis, accompanying the abuser during child time sharing ventures, acting deferential and subservient in joint therapy sessions, but decisively different in individual sessions, fearful of the abuser finding out the victim described him as controlling, manipulative, and abusive, and being exposed to threats, intimidation, pushing, holding down, humiliating, cursing. Would that be consistent with a victim of domestic violence?
Without a doubt, these are again techniques of compliance, not wanting to poke the bear, walking on eggshells, trying to minimize harm to themselves and their children. They'll put up a front. They don't want anyone to know, and they don't want their abuser to be angry by them disclosing. So yes.
Lastly, one other factor I neglected to mention: would a video of the abuser and the abused at a restaurant with the child and another adult, whereby they are all acting happy, be consistent as well?
Well, certainly, if you're asking, they're acting happy, is she still a victim of domestic violence? Definitely. And it also fits with this whole idea of appeasement. We have to remember that the domestic violence comes in layers through the years of events. So one incident.
Judge, I'm going to object to non-responsive.
Ooh.
So that behavior isn't just a spot image right then. What's going on inside her? Why is she acting that way? That's what I would ask clients. That's what we're looking for. And if it's truly a victim of domestic violence, she'll be in this appeasement mode to try to please him and not disclose the abuse to get along sort of description.
My final question, as it relates in general to domestic violence. Assume, hypothetically, there were several violent or semi-violent acts of domestic violence, and then there was a break in the chain of events for, let's say, as much as a year or two, and then it started up again. Does the victim remember, and is the victim affected by the earlier acts of abuse?
Without a doubt. I've got clients who tell me about
Sustained.
Yeah, just
so yes, definitely they don't forget the abuse that's occurred to them, trauma lasting. Adults remember childhood trauma, let alone something from several years ago. Like I say, layers of impacts of behavior.
Thank you very much. No further questions from Mr. Farrell.
State, Cross.
Thank you, Judge.
This is going to be interesting to see how they're going to attack him.
Good morning, Mr. Ferris.
Good morning.
Mr.
Okay.
Oh. I want to ask you give you some examples and ask you if this is consistent with a victim mentality.
Sure.
Minimizing the abuse.
Now you're asking me if the victim would minimize?
Yes. Like what I mean by that, and maybe I said it wrong, is like covering or taking blame for the abuse, covering for the abuser, taking blame.
Yes.
Making excuses for him.
Definitely.
Or her, I guess, but not reporting the abuse.
Right.
Dropping charges if they were filed.
Yep.
Not standing up for themselves.
Yes.
And not leaving.
Yes.
Okay. I'm going to put that wheel back up, and I want to talk to you about the pie sections each.
Sure.
Okay. Sorry, Judge. While she's fixing it, and I know you're familiar, and do you have a copy in front
I
of
do.
you?
I
do too.
I went
do
right
too.
in front of me.
Okay. And so I want to talk first about the use of intimidation. Would you agree that if somebody, this says making her afraid by using looks, actions, gestures, smashing things, destroying things, her property. We talked about a break. If those things weren't occurring for years, would you, but had allegedly occurred prior to that, would you still consider that part of this dynamic?
Yes.
If it's been a distance in time?
Yeah, I think the distance can be totally irrelevant.
And there's a section on here about the economic abuse.
Mhm.
Would you find that if a hypothetical victim was living on her own for several years, had no monetary dependence on the alleged abuser, and lived in her own home in another state for part of that, and there was no monetary connection, that would not apply to a relationship?
Could you restate the
Yes.
question?
So if in this wheel,
Right.
hypothetically, when I'm talking just about using economic abuse,
Right.
would you agree, would you say it still applies if the victim was living on her own for several years with family and independently sufficient economically?
Mhm.
No financial dependence on
Mhm.
the other person. Would you agree with me that economic abuse would not apply to that relationship?
From the scenario you give me, it doesn't sound like it would apply.
And for isolation, would you agree that if it's the same facts, living on her own for several years with family, so I know it says isolated from family, I think. Living on her own with family and having some periods of no contact for over a year, and then being back in contact, but living separately and having her own cell phone, having her own car, having her own home. Would you agree with me that that's not a situation where there was isolation?
Well, you have to remember, under the isolation also comes jealousy and justifying actions. So in terms of isolating, not letting their partner or the victim go to work or see family, in that sense, what you're saying is true. But a component of isolation could also be extreme jealousy, possession, your mind, those sort of things.
And I didn't add those facts. You're adding those facts, right?
Well, under the power and control world, the last item, I don't know if you actually mentioned it, using jealousy to justify actions.
And if that was not a factor, that's not a factor. for my scenario.
Then isolation component may not be part of that, component for the scenario we're looking at, the couple we're looking at.
And why do you say may not? What part of that would apply?
Well, would not be.
Okay, thank you. Using the children.
Mhm.
If the hypothetical victim had custody of the child and attempted to terminate parental rights, and the hypothetical abuser had to seek court intervention to get the child,
Right.
would that be a factor in your consideration of whether children were being used? If she had sole control of the child.
So you're asking me if I could just reframe that the alleged abuser is not he's not using child against their alleged victim, then they're not necessarily guilty of using the children.
I'm not asking if it's guilty. I'm just asking if that would apply. We've talked about how these
Right.
things apply.
It may not apply. It would not apply. But I think if I could mention, you're missing the point of the power control wheel. This is about pattern of behavior.
I'm not missing
Okay.
it. I'm just asking hypothetical
Okay.
questions. How about the using a male privilege? If that hypothetical abuser was not having any control over her big decisions or did not live with her, so was not being the master of the castle, was not treating her like a servant because they lived separately, and was not defining their roles, in fact, was offering to purchase things, get her anything she needed, those kind of things. Would you agree with me if those were the facts of a relationship, male privilege would not apply?
No, I wouldn't agree with you.
Okay, can you elaborate?
Yeah, the men's roles. And when you say purchasing things, I would want to look into what is that a concept of what the role is. I'm the man. I purchase things. I control things for you. I decide what to get, et cetera. So that could be a male privilege issue.
Okay, and I understand that, and that was a poor fact scenario in mine. I think it kind of goes with the economic abuse. And what I should have asked is, if she's asking for, can you stop and get me boxes, or can you stop and get me tape, or can you stop and get me something else? And he is, yes, of course, and he does it. That's what I'm talking about, not him telling her what she may have.
So in terms of him buying things for her that she's asking for, I wouldn't consider that to be domestic violence.
Okay, you would not.
No.
Okay. And so
Mr.
that's,
Blunt,
other than that caveat, then male privilege wouldn't necessarily apply to the cycle that we're in, under my facts.
The facts are not complete enough for me to come to the conclusion.
Okay. How about minimizing, denying, and blaming? What, you said that was present in 90% of the cases.
Quite a bit, yes.
Right.
Mhm.
I think you said 90.
I did.
What if the hypothetical abuser says, I was wrong. I lost control. I shouldn't have done those things, and never says it was your fault you did those things. Would you then feel like that's not minimizing, denying, and blaming?
No, I wouldn't agree with that,
Okay.
because it could
it's the
be
brunette?
that part of the strategy
Sound.
of minimizing could be that I'm sorry I didn't do it. That could just be minimizing.
I'm sorry no, not I didn't do it. I'm sorry I did it.
Right.
That's part of
That's still-
minimizing?
Yes.
Well, certainly not denying or blaming, right?
I would need more definitive
I guess
facts.
I need an explanation on if somebody takes responsibility for accusations against them, how
Right.
that is minimizing. Just to say, yes, you are correct, and I am sorry.
It could be a way to dialogue or to minimize what occurred by accepting blame for it, and that could be part of their scenario.
Could it also be the opposite?
Yes,
That person
it could
is
be.
taking credit, is taking responsibility for their actions.
Right, certainly it doesn't deny that it happened, that's for sure.
Right,
Okay.
and no blame being set forward if they say it's my fault.
Well, just because someone apologizes doesn't mean they weren't abusive.
I'm just talking about the factors on this wheel
Right.
and whether or not, if somebody, under my hypothetical, admits to responsibility for the accused abuse and apologizes for that, whether or not you would consider that denying and blaming.
I would need more information on the relationship in the scenario to decide that.
Is there a scenario? Okay. How about using emotional abuse? If there's no accusations of any name calling or telling her what to wear, this hypothetical victim, in fact, she's comfortable enough to wear a sports bra and shorts around him. There's no displaying weapons. I'm sorry, I'm looking at the wrong one. No evidence in their relationship of playing mind games or humiliating her or making her feel bad about herself. Would you agree with me that that might not be a factor?
Well, you gave me a discrete list, but emotional abuse also includes name calling,
Okay.
putting someone down, affecting them emotionally.
I guess, is there a scenario, Mr. Ferris, where you will agree with me that a relationship might not include emotional abuse? Because I don't know how to give you enough factors for you to say, no, it may not.
Yeah, I can't help you with that. I'm not asking the questions.
Oh, I was asking you one. If there was
I
a
know, I'm
scenario.
not, you are.
Would you take into account, based on, with these factors such as emotional abuse, economic abuse, male privilege, using children, all of these, if the alleged victim, or let me give you a scenario, she does not live with him. She's actually in another relationship, potentially engaged to a new man.
Okay,
She tells him that she does not want to be with him,
okay.
and she plans to move away without him. Would those be factors that you would have to take into account when deciding if that relationship?
now you say it, yeah, Mr. Ferris bringing a wheel is pretty funny.
Fit this power and control?
Well, that
Brendan, yes, it's the first hour, well, first 45 minutes is setting him up. Then it's 15 minutes of a hypothetical that is directly this case that he agrees with. And then the last 10 minutes have been cross-examination where she can't keep her own thoughts straight. They should also have been ready for this. I thought they would run him over, but she messes up big time.
that would be factors of the relationship, but I haven't heard you say anything about what their history is, what trauma she's experienced, what's going on with children in their lives, all sorts of other dimensions of their relationship.
I guess,
There is, according to I got told Friday that I was wrong. She was apparently engaged, maybe kind of. We know from her testimony, she said she had a ring on. It wasn't an engagement ring, but there is some evidence she might have been engaged to another guy. I don't know. I didn't look into it because, again, it's not presented in court. So someone says she was engaged, and she claimed on the stand she wasn't. Again, I didn't read the article stating that she was engaged to some guy who she's not engaged to anymore. It's not man bun from day one. Yeah, she's mad at Mr. Ferris's wheel.
so is there no scenario where there can be abuse in a relationship and then there no longer is abuse, where they are no longer in this wheel? Because the way you're answering your questions, that's the impression I'm getting.
So there, I have come across situations where there's an emotional abuse or a physical abuse, but it's not a pattern or behavior. It doesn't go on over a period of time in an attempt to control someone. So, if I may, if someone pushes down their girlfriend on a night out and he gets arrested for domestic violence because they live together, it's a battery, that's domestic violence. But that's it. She's not appeasing, she's not put an emotion, the whole power control dynamic isn't happening. That is domestic violence under criminal law, but it isn't domestic violence in the sense of a pattern or behavior to try to get the appeasement or this sort of consensus out of a victim where they're afraid to poke the bear, all the things I've already talked about. So if that answers your question.
It didn't. Is it your testimony that once a relationship has these power and control aspects, that is forever, even if there's no continued allegations of abuse for years, no continued allegations of abuse, no continued allegations of emotional abuse, never any allegations of sexual abuse? The parties are living apart. They're independently, I keep saying independently wealthy. That's not what I mean. Independent, economically independent. They are, the female is telling him she doesn't want to be with him and has moved on to a new relationship. Is there no scenario, in your opinion, where people can get off this power and control wheel, even if they were on it at some point in their relationship?
I think it's possible, but it's not likely, and it's not the typical thing that I see. Usually there's still a dynamic of emotional abuse.
So even under my facts,
Yes.
with no allegations of emotional abuse in years,
Yeah.
it's your opinion that not good enough. They're still on this power
Well,
control.
all I can speak from my critical learning and studying this, and also my practice. And I have custody issue couples where they're domestic violence, and 10 years later, there's still abuse taking place, even though they're remarried and don't live together. So by example, I see continued
Don't laugh
abuse.
when you say
Could there be a
domestic
couple
violence.
that don't? I'll say it's possible.
Thank you. I don't have anything else.
Redirect.
No, don't.
Nothing further, Your Honor.
Can this
Thank
witness be released?
Yes, sir.
Yes.
Sir, you are released from your subpoena. You're free to go.
Thank
Hey,
you
Miss
for all your help.
B. Yeah, she was making a relevant point and then she stopped. I think it was a good line of questioning she was getting into, that the abuse wheel, in his opinion, always goes on. But we know that you can move on with counseling, living apart, that you can learn how to say no. That because that happens all the time. He seems like a guy who all and his job is to counsel people who are stuck in bad situations. So of course, it's kind of like a personal trainer. They will never teach you how to get by without them. His job is to have, or his livelihood is to have people consulting him constantly. So of course, his power wheel will always keep you inside of it. I think they attacked it the wrong way. I think it was actually a good thing they got into in the end, and then she just left it because she mumbled up her hypotheticals. That you will always be a victim if you were in a bad relationship. I think she should have used that line of attack instead, saying, "Well, that's just not true." Uh, she is released. He is released. Yeah, but she got in the right what I would have gone with in the end, but she tried to do hypotheticals that she didn't think through. And as Bo Pete said, this persecution has been horrible. I think th- they are helping Ashley with the line of questions. They did it with their own witnesses as well.
All right, Mr. Taylor, call your next witness.
Gina Torsha, Your Honor.
Judge, I think we're gonna have to approach whoever comes in first. Thank you.
Yes, but also you can still have you can still have custody battles. You can still have a shared child and still put up some defenses. Because you can't get away from abuse. I know it's hard. I know it takes a lot of prep, a lot of time. It probably takes some counseling to get out of it, because it's if you have lived in it for long enough, you think, well, this is normal. Him beating me every Thursday, Friday, Saturday when he's drunk, I mouthed off. I didn't put enough mayo on the sandwich. It's my fault. I know that you can get into that mindset, but I think awareness and help can make you get out of the wheel. And that's what he said. You can never ever break the cycle, and that's just not true. The Dolores lawyer, the investigator, and the prosecution all came across like this is personal. Yes, especially Murphy. I didn't like her testimony. She was way too much into this case. Was he paying support? I don't think so. He had no money. I don't know if I haven't gone back. I don't do deep dives on stuff like that. It's not mentioned in trial. Why didn't the prosecution bring up reverse manipulation? She strung him along for years and could have simply gotten a divorce and allowed his child to see him. Bo Pete, I think you and I should be prosecutors in Florida instead of these two. Yes, there was allegations about CA. Of course, there's a lot of things that could, but you can also, by being apart, by getting a support network, by realizing it's not okay that he does this or she does this, you can break the cycle. I was just saying he's a guy who will for perpetuity keep you in the wheel, and I don't believe that's true. I believe that you will be able to break the bad cycle if you get the correct help. Did she have the support network? Did she have the possibility to get it? I don't know.
Defense Corp, Gina Torsia.
Police officer affirm testimony about to give
Jamie said that because you made so much fun of her on the Discord server, she won't be here today.
I do.
Actually, she's sitting down. Attorney, come back one more time.
I don't. Not Jody. Do we have a picture of the wheel? I don't know the wheel. I'm not a specialist. But it's also one of those things where I believe that
I'm Judge White. I'm presiding over this case.
most of these evaluation things, you could probably put 95% of all relationships into that. Because there is always an internal power dynamic in a relationship. And it's just how you look at it that makes it look like abuse. So I am pretty sure if we go through it, we can make it match how she acted to and how I was in my marriage and how my ex-wife was in her marriage, how my parents' marriage was, even though they were together for 42 years. Because it's so generalized.
Make yourself comfortable in that chair. You want to be about 12 to 15 inches from that microphone. You can adjust it up,
No,
down,
because
left,
then the
right,
T
however
was
you
green.
need. And if you just speak in a loud, clear voice, we should hear you just fine.
Yes, Your Honor.
Good morning.
Good morning.
Would you tell us your full name, spell your last name, please?
Gina Torsia, Torchia.
Ms. Torsia, did you at one time work for an attorney by the name of Stephanie Murphy?
Yes, sir.
Back in June of 2018, would you have been employed under Ms. Murphy's guidance?
Yes, sir.
Do you recall exchanging an email with Detective Gillum on June 5th, 2018?
Yes, sir.
Did you have an opportunity to review it?
Yes, sir.
I'm going to pass to you, Ms. Torsia, what I've marked as defendant's exhibit number 25. And ask you if you can identify it for us.
Yes, sir.
What is it?
It's an email from Detective Gillum.
And does it include a response from you? Or is it a response to your initial email to him?
It's a response from my initial email to him.
Okay, and is it a true and accurate copy of your email to him and Detective Gillum's response?
Yes, sir.
Move to introduce it into evidence at this point, Your Honor, Defense Exhibit 25.
Same objection?
Yes.
Oh,
All right, now,
defendant exhibit 25 will be received.
Ms. Torsia, did you on this day send Detective Gillum a copy of the South Carolina Domestic Violence Restraining Order?
No, because we were not aware of one.
Okay. Does he send you a copy of the order?
He does send me a copy of the order, but there was never an order entered into the Charleston County Clerk's or the Sheriff's Office.
Yeah.
So we had no proof of an order at the time.
Would you please read for us, Ms. Torsia, Detective Gillum's response to you on Tuesday, June 5th, 2018,
Gina,
6:19 p.m.?
I noticed something that you both need to be aware of, unless there's something I'm missing. If you read that section just before the judge's signature, it states the order will be in place 6 months of the day of the hearing, which was May.
Can you slow down just a little bit?
Oh, I'm so sorry. I'm a fast reader.
Okay. well,
sorry about
slow
that.
down a little bit for us.
Evelyn Wood School.
Humble brag.
Where do you want me?
You're good.
Okay,
6 months of the date of the hearing.
which was May, November, which was May, November 3rd.
Ms. Torsia,
Yes,
I'm sorry. Would you start over, please?
yes, sir. Gina, I noticed something that you both need to be aware of, unless there's something I am missing. If you read that section just before the judge's signature, it states the order will be placed for 6 months of the day of the hearing, which was May, November 3rd, not November 27th, and sets it to expire May 3rd, which would be 6 months from November 3rd. Again, it's not something I would have made a physical arrest on, but the SAO will at some point make a filing decision. If I am reading something wrong here, let me know.
Okay, we can agree that SAO would be state attorney.
Yes, sir.
So Lastly, Ms. Torsia, this is Detective Gillum telling you that the order was in effect, the stay away order,
Objection.
as of November 3rd, 2017, correct?
Objection.
Sustained.
That eye roll.
This is Detective Gillum explaining to you,
Objection, asked and answered. Did you read the email?
Sustained.
just a moment, Your Honor. This is for sending Ms. Torsia, let me pass to you what I've marked as Defendant's Exhibit 26.
Can I see it, please? Can we approach this?
I told you so. It's gonna be side by side by side by all day long. When I look up the power and control wheel, it is gendered, which I feel is wrong. And this is the National Center of Domestic and Sexual Bad Stuff. They should put up a gender neutral one. There's a reason a lot of guys don't report stuff like this. I don't know what's wrong with them. The pre-trial hearing, the stand your ground hearing, I felt they were better. I believe, didn't they do it in the Travis Rudolph case as well? But it's to keep the defendant doesn't have to go up there all the time. And actually, that's a good idea if she is not, because she's out on bond, but some defendants might have a little jewelry from the state around their legs in court. So not to prejudice the jury against them, it could be a good solution.
So, Ms. Torsia, let me pass this to you. I want to see if this refreshes your recollection as to whether or not you sent a copy of the South Carolina order to Detective Gillum.
Yes, sir.
It was the first thing that popped up when I got it. Yes, but I think that's because they were in a really bad courtroom, and Massachusetts, it's one of the lowest tax bracket tax percentages in the U.S., and it's practically a third world country. They are not moved that far along, so she had to walk up there. But maybe if they ever get their tax rate just a little bit higher, they will have proper audio in courtrooms in Massachusetts, because it's practically free to pay taxes in Massachusetts. Oh, you practically don't pay taxes in Massachusetts, I believe, after watching how bad their courtrooms are.
Yes, this is the order.
Yeah, without referring to it, my question is only, did you, in fact, now that your recollection has been refreshed, send a copy of the order to Detective Gillum?
Yes, sir.
And then he responds to you a couple hours later with the email.
With, yes, and there's also
No further questions, Your Honor. Thank you, Mr. Bush.
Any cross?
Can you finish your answer, please?
yes. There's also a predicament where Detective Gillum, there was no order entered in to the clerk system in Charleston, and there was no order entered into the Charleston Sheriff's Office. So he had no bounds to make an arrest just based on this when it wasn't entered.
Sustained.
Ask to
Further
disregard, Your Honor.
Members of the jury, Testimony regarding an opinions witness about violation of criminal law is inappropriate, and you should disregard those last comments. Anything else?
That's sufficient. Thank you, Judge.
Rita Rep, can the witness be released?
Yes.
Yes.
Thank you, Your Honor.
Thank you, ma'am. You're released from your subpoena.
Would you like to? Thank you.
Sencat, it was irony. I know, isn't Massachusetts the fourth highest state tax in the US? But they used 300,000 to make a kitchen and a police station.
I wonder if we could publish. the exhibit that we have.
I believe it's the fourth highest income tax. No, 14th highest. Well, then they can't buy anything. I'm not.
Okay, I'm not going to go very far with that.
Are we resting? Are we resting? Are we resting? Oh, do they get to get that judge's clerk in there? Oh yeah, let's look at the poll result. Guilty 25%, that's up from, I believe, was it 12% Friday? So yes, that's up with 178 votes.
Okay, go.
No predictions on deliberation times. I want to hear the closing before we do that poll. They don't call it Taxachusetts for no reason. Don't they have something like that in northern Italy, that you can buy a house for €1, but you will have to invest? Is it 25 or 50 grand into renovating it to try and make people move into more rural areas? I think they have that in Italy. Because my sister is looking at maybe when they retire moving to Italy, not to buy and renovate a house like that. But I remember, I think I looked it up that you could buy a house for like €1, but then you have to live there for X amount of years and you have to invest X amount of euros into it. But I think it's in the northern part of Italy. Beautiful place if you want to buy a cheap house and live in a rural area where the food is great, the weather is way better than Denmark. Go look at that. Spaceship K was the name of my sister in a movie with that name 40 years ago, and I didn't think you were that old. You saw that on TV not too long ago.
All right, members of the jury, I think it's a great time for our mid-morning break.
It's the southern.
So I'm going to send you
Oh,
out.
don't go south of
About
home.
10 minutes or so. Feel free to use the facilities. You can use your phones if you need to send or receive text messages, emails, phone calls, anything like that. Please don't begin any sort of deliberations or discussions amongst yourselves about the case. Don't discuss the case with anybody outside the jury. And don't do any research on the people, places, things, or legal topics we've heard anything about. And 10 minutes, 15 minutes, because I also want to give everybody else a break as well.
In my opinion, I would think I am as unbiased with the gender because I don't give a F about who it's about what's presented in court. It's not who it's presented about. But some people might be swayed. The Karen Tyler case, I didn't find her guilty, and she unalived her wife. This case, I don't think that the state have proven her guilty. So I think I don't know if it's been a gay couple. I don't think I would have thought any other way.
See you back in a few minutes.
We just did a poll. 45% says not guilty. I think, don't you have that where doctors have to stay after a degree? They have to stay in the rural area too for a period of time to get their degree or something like that.
Y'all can have a seat. All right, so the issue is a police report that I haven't seen, but it's my understanding what it says is that Miss Benefield went physically to the telephone reporting unit of the Manatee County Sheriff's Office. I'm going to summarize, you can correct me.
It's the same with Denmark. I think all of us move when we get out of high school, and then we move back when we're in our late 30s.
All right, so this isn't marked. Is it, did you seek to admit it as an exhibit or just testimony?
No, just testimony.
All right, so you expect the testimony would be from a deputy with the sheriff's office that Miss Benefield went to the telephone reporting unit. On December 6, 2019.
Phone call.
That Miss Benefield wanted to document the fact that her estranged husband admitted in a text message that he placed a tracking device on her vehicle in the past. That she has observed him driving behind her on multiple occasions, which concerns her. And she wanted this information documented. She brought her vehicle to a local auto dealer, but a tracker could not be found. Due to the fact a tracking device was never observed on the vehicle, an information report was completed.
Do you want to know how much I pay? I pay 42% in taxes and a 25% value added tax on any purchase I make.
All right, any objection?
The objection, Judge, is that anything contained in this report, which the nature of this report, according to it, is information. But anything contained in this report is hearsay other than that Ms. Benefield physically appeared at TRU on December 6th, 2019, because everything that Mr. Deputy Lindsay wrote down was told to him by Ms. Benefield. And so the state would object to his being able to testify to anything other than she appeared at TRU on that date, which seems irrelevant, if you remember.
Yeah, she testified about that part, so.
Proponent, defense?
Yes, so it clearly goes to her state of mind at the time, and it also corroborates her defense.
Well, it is a he said, she said case, just he can't respond. So all her evidence will most likely be what she said. So all of this comes down to, who do you believe? do you believe Ashley or don't you believe Ashley? Because if you believe Ashley, he did all this stuff. If you don't believe her, he didn't do it. So yes, all her evidence is what she says.
I do not plan to ask the deputy to read it.
My income tax is 42%, and everything I buy in a store will have a 25%. We call it MOMS. It's the value added tax. So everything we buy, we don't do like America where you buy something and then you add tax. The price I see will have included 25% of that price will be the value added tax. So if I buy something from the US, for example, over a certain amount of money, I will have to pay. No, I watched. I used to have WWE network, the wrestling's network. That cost $9.99. But because I bought it in Denmark, I had to add $2.50 to that because there's a 25% value added tax on all purchases in Denmark. I believe 83% of my water bill is taxes and green. I don't know what you call it, like subsidizing green stuff as well. The pleasures of living in a socialist country.
I'm going to ask him if he took a report from Miss Benefield, what the date was, and whether or not it was her reporting about a tracker being placed on her vehicle. That's all.
Well, only one side has to convince you.
That's hearsay.
That's the state.
Judge, because it's self-serving hearsay. It's actually hearsay within hearsay, I think. That if he wrote something and asking him what he wrote in a report about somebody else told him. But
I don't
it's at
think
least
we
one
heard
level.
about it.
All right, thank you both very much. The purported reason for the introduction of this testimony, according to the defense, is to show the defendant's state of mind and that it corroborates her defense. Both of those sound to me like the
Well, it sounds really, really good until you have to wait. I had my brother-in-law's dad had to wait more than a year to have. He had some fluids in his brain, and he had to wait more than a year to get an operation. On paper, we have universal health care and everything is hunky-dory, but in reality, that's a lot of waiting times. There's a lot of the hospital just want to skip you out as quick as possible. So a lot of people in Denmark are actually buying extra health care because our system is buckling.
introduction of this report to the sheriff's office regarding a tracker is being offered for the truth of the matter asserted that a tracker was placed. That would obviously make this hearsay. It's the introduction of an out-of-court statement to prove the truth of the matter asserted. That being that a tracker was placed on her vehicle, thereby corroborating the testimony that has already been provided. My notes are that it's already been testified to that the tracker was placed on the defendant's vehicle. And my notes are that she testified, or it's been established, that the victim in this particular case admitted that he placed it on her vehicle.
Yes.
So that's already in. And I think I said this the other day, and it bears repeating. So this is self-serving hearsay. It's clearly excluded. I will just note a secondary reason would be the relevance of this report. The issue is not whether or not she reported it to the authorities. The issue is not whether it's true or it's not true. The case law is very clear on this. It's not relevant whether law enforcement believed her or didn't believe her. The purpose of allowing these prior bad acts, and I say prior bad acts instead of going into all the different ways that can be done, but in a self-defense case, once the defendant has established there was an overt act, prior incidents of violence and intimidation and threats can come into evidence. The case law is very clear. They may be true, they may not be true. The issue is, what did the defendant know on the day that the force was used? And so those prior acts of the specific incidences of prior bad acts or prior violence don't have to have happened to her. She just has to know about them. And the tracker issue, while not necessarily violence,
Well, if the jury don't believe either side, they must find her not guilty because it's beyond a reasonable doubt. And if the state haven't proven that, she is factually to be found innocent. So I feel Father Time has done a lot of bad stuff too. Yes, I don't feel these are good lawyers.
certainly it's intimidating, and I allowed it. I don't remember if the state objected or not, but I allowed that in. The testimony is in. Whether she reported it to law enforcement is of no moment. Whether it's true or not, because put it this way, the tracker wasn't found, so it was just an information report. It doesn't matter if it was found or not. It doesn't matter if this officer believed her or not. The issue is, it's something she's aware of. She testified to an overt act. It's already in evidence. So at this point, this is not marked. What was who was the next person? What was his name or her name?
Lindsay.
That was Deputy Lindell.
Lindsay. Scott
Lindsay.
It's on
Scott.
top of the report.
Scott Lindsay, I'm sorry. Lindsey.
So, I mean, you could call him, but the substance of her walking in, him taking a report, again, none of that is relevant to the issue of her knowledge of prior incidents.
That's all I was calling him for, so. Yeah.
Well, they can do that,
All right, I do want to give you
All
all
the
a break,
time.
though.
but
I know
you
we
have to
started at
convince
9,
the
it's about
jury that
10:30.
you
I
were
think
in
it's reasonable to
fear.
go ahead and take a break. So why don't you guys take 10 minutes?
Thank you, Judge.
Court will be at recess in 10 minutes.
Language, Venus. This is a good Christian channel. I like this, Judge. Firm but fair, you are right. Especially because Father Time has a really slippy concept of what he's doing. But someone asked me to pull this one up. The power and control wheel. Intimidation, making afraid by using looks, actions, or gestures, smashing things, destroying property, abusing pets, displaying pew-pews. I don't know if we can say she did any of the intimidation. Not that we've been told. Emotional abuse, putting people down, making people feel bad about themselves, calling them names, making them think they're crazy, playing mind games, humiliating them, making them feel guilty. Yes, you could say that that letter. No, that letter was never brought in. We read that letter she left at the house where she talked about how he lied to her that he didn't have the physical means that she claimed, that his house was falling apart. That could be a humiliation thing. Isolation, controlling what they do, who they see and talks to, what they read and where they go, limiting outside involvement, using jealousy to justify actions. I haven't heard that about any of them, other than that if you want to use that he saw a ring and that's why he wanted a divorce, but I don't think any of this applies to this case. Minimizing, denying, and blaming, making light of the ears and not taking their concerns about it seriously, saying that didn't happen, shifting responsibility for behavior, saying they caused it. Don't think we have heard anything about this from either side in this. Making them feel guilty about the children, using the children to relay messages, using visitation to harass, threatening to take children away. Well, you could say the move to Florida and not telling about when they gave birth, is that making them feel guilty about the children? We know she was nagging about Ava, using the children to relay messages. I don't know if Ava was used as a messenger, but a lot of conflict seems to have been about Ava, and she was a teenager. Teenagers are weird. Preventing them from getting or keeping a job. She claimed that happened. We don't know them. Make them ask for money, giving an allowance, taking money, not letting them know about or have access to family income. Well, it's don't think you could use this on any of them. Male privilege, I hate that. Where's the female privilege? Treating her like a servant, making all the big decisions, acting like the master of the castle, being the one to define men's and women's roles. I hate that it's gendered, because there's a big undisclosed problem with men suffering it for abuse too. And with this being the official power and control wheel, shows there's a problem. But I don't believe he wanted a ballet institute, so you could say she might have used her male privilege to making him pay for and taking out a big chunk of money to make that ballet thing for her, and then when it tanked, she ran away. Coercion and threats, making and or carrying out threats to do something to hurt them, threatening to leave, commit unaliving, self-unaliving, or report them to welfare, making them drop charges, making them do illegal things. I don't know about threats to hurt, but threatening to leave, well, she did leave. Report to welfare. We know there was the report to the pediatrician and to the police, making them drop charges. We know they were talking about dropping the divorce and some charges. So that is both ways, making them do illegal things. Don't think that applies to this trial. So yeah, you could, but that's the problem with these tools, is they are so broad that any relationship, because the male privilege, is it a male privilege when you look at your husband and next time you're going to church and he has his best Under Armour t-shirt on and you say you are not going to church in that? Is that you using your privilege, or is it that just, hey buddy, we're going to church? Is it male privilege when he says the truck's busted, we need to buy a new truck, and she says, I don't know about
All
trucks,
right,
and he says,
welcome
well,
back,
we're getting a
everybody.
150.
We are back on the record.
I don't know.
Please have your seat, please.
All right, Mr. Taylor, do you have your next witness?
Possibly we haven't heard
Defense
anything
calls
about that in trial.
Vincent Vizicaro.
You ready?
Yes.
Okay. Yeah, let's go ahead and bring him in.
Yes, that's what I'm saying. You could claim she did economic abuse. Yes, it's because it's very demasculizing for a man to admit a little woman could do things to him. That's one of those things. We see that more and more now, and I hate it. We also see it here in Denmark. I've had a few cases where we had women just walking up, sucker punching a guy in the street. Because we men are taught you never touch a woman. Of course, some men do it, but if this lady came up, punched me in the face, I would probably just drop the cookies and think, what the F am I going to do right now? Because if I swung back, I could send her through a wall. But it's so ingrained in me that you don't ever, ever touch a woman. But now we see it more and more when out drinking, people are getting so aggressive that women start punching men. And isn't it, if you want equal rights, you should also get equal lefts. That's a big problem, that we have this societal stigma that men should just suffer being punched because, well, it's just a woman doing it. No, violence is violence. And I think no, I'm going to get in trouble now. Psychologically, it's worse for a man to get punched in the face by a girl than it is being punched in the face by a man, because we are indoctrinated not to do anything. Even grabbing their arms and say, stop, because I am physically stronger than this girl. If I grabbed her by the arms and said, calm down, I would probably in a court of law be found guilty in assault, even though she smacked me in the face right before that. And I didn't do anything to physical restrain her so she couldn't hurt me again. And I think that's a big problem. And psychologically, men who's suffering from physical abuse, I think it actually hurts their feelings, their brain, their psychology more than the punch hurts them.
Make sure you have him spell that. Do you need the,
Please.
but we'll wait till turn the lights down until you give us the high sign and purple front of now.
I haven't seen Donut in a long time. Yeah.
Welcome back, everybody. Hope you guys stretch a little bit. Maybe run a jogging place, warm up a little. So we've got the defense going to call the next witness. But before we do that, I did want to ask anybody to get deliberations amongst yourself, speak with anybody outside the jury about the case, or doing research on those topics we talked about. Mr. Taylor, call your next witness, please.
Thank you. Vincent Vizzacaro.
Can you tell us the from the testimony about the jury, the whole truth, and the truth?
So, sir, as the exhibit, make yourself comfortable in that chair. My name is Judge White. I'm going to be presiding over the case. You can adjust that microphone up, down, left, right, as you need, about 12 to 15 inches away. Speak in a loud, clear voice so they'll pick up everything.
Sounds good.
Good morning.
Morning.
Would you tell us your full name and spell your last name for us, please?
Vincent Vizzacaro, Vizzaccaro.
All right, Mr. Vizzacaro, I'd like you to try to keep your voice up if you could.
Will do.
What do you do for a living, sir?
I'm in real estate.
And where are you a realtor?
Lakewood Ranch, Bradenton, and Sarasota areas.
Do you have any particular specialty?
Residential homes in Lakewood Ranch.
How long have you been doing that?
About 8 years now.
I want to ask you whether or not back in 2018, you had occasion to deal with an individual by the name of Douglas Benefield.
Yes, I did.
Yeah, Lunsburg did said, sometimes you just have to take a beating. Wasn't that a saying in a Texas trial too? Sometimes some people need a little unaliving. It's such a stupid thing to say. Yeah, well, maybe you deserve getting. That's what happened when someone broke my nose. Was, well, you're a soldier, you should be able to defend yourself. Yeah, and I was drunk, and I couldn't walk straight without closing an eye, and he jumped me. There were 8 guys, and I wasn't talking to that guy who broke my nose. But in court, he was found not guilty because I should have been able to defend myself because I was a soldier. Did I use self-defense techniques I learned as a soldier? I would have been punished because you're not allowed to use techniques like that in a fight, because he should have been allowed to hit me before I can use those techniques. And I was never taught any of those techniques in the military. So it was a crap judgment, but some judges are a-holes.
Would you tell us the circumstances under which that relationship took place?
Yes, he contacted me looking for a home.
I'll overrule at this point.
Thank you, Judge. Contacted you looking for a home?
Looking for a home he was trying to acquire through a business that he said he owned in Liquid Ranch.
All right. And back in 2018, Mr. Vizzacaro, did you use emails to communicate with him?
I did.
And did he communicate with you in the same fashion?
Yes, he did.
Were emails back then a normal and customary part of your business?
Very much so, yes.
Did you preserve the emails as they related to each client's files?
I do that, yes.
And were the emails under your care and custody?
Yes.
Mr. Vizzacaro, I'm going to pass to you what we've marked as defense exhibit number 27.
Can we approach them?
Yes.
Well, I'm sorry, Fedorowski. You were saying the last 3 times I bought my grasses is it's been Oakley because they have that flat. So when you put on a helmet and ride with a helmet on, you can just slide it under. Not that I used to ride my moped. I don't have a bike because I would kill myself. So yeah, I like Oakleys, but I don't use I'm a middle-aged man in lycra, so I wear those biking glasses. Yeah. Thank you for spilling the beans of why we wear Oakleys, Marissa. Always here to rain on my parade.
The jury, I do need a few minutes to resolve a legal issue. It's my responsibility. So you could close up your notes and leave there on your chair, and I'm going to switch you back into the jury room for a couple of minutes. I will get you back out here as soon as I can. Don't get deliberations. Don't talk to anybody outside the jury, and no research on any of the issues. Thank you.
Oh, I'm so bad now. I need to have those bifocals because I can't see my phone with glasses on.
All right, okay, have a seat. Mr. Carl, what I'm going to do is at this point, I need to do some research and speak with the attorneys. So I'm going to excuse you to the hallway. So there's a thing called the rule of sequestration that has been requested by both parties. And that means that you cannot discuss your testimony or questions asked of you with anyone else. You can't discuss other witnesses' testimony or what questions they were asked or testimony they gave while you report. We're doing research on the case, watch it for anything else. We'll call you back as soon as we can. Thank you.
Well, the good thing is we can catch up a lot today because there's a lot of downtime.
All right, I'm just going to ask before I start doing my research. Do you have any cases you want me to know about right now?
No, Your
All
Honor.
right, so I'm sorry.
We're traveling under the words in the statute, specifically 9803(6).
Understood. All right, so I'm thinking it's going to, I need about 10 minutes or so. So we're going to take a 10-minute recess, maybe 15-minute recess. I will look this up as well because I want to find a case that gives me some direction.
Sure.
Okay, yes, sir. Thank you.
Well, now he has to look up case law to see if they can put in.
Of course, that means you can too when we go back on the record.
Yes.
If he can talk about looking for a house, which I don't understand what, but enlighten me, please. So, yeah. I wear clicks, go through 1 pair a year. What's clicks? Is it those snap-on sunglasses? My mom used to wear those, and she always forgot them. I just didn't buy her testimony, even though the prosecution wasn't great. And I'm perfectly. I don't want to say you're right, you're wrong. I think everyone should have that because it's a feeling you get when you hear someone testify. If you believe them, and you can't explain feelings, it's the same as why do birds always appear when you're near? You can't explain it. It's just a feeling you get. That was a bad one. Ultra wide. Well, my eyesight was perfect, and then I was stupid enough to put an iron rod in one of my eyes, and then that started going bad, and the other one just followed it. So it get worse and worse. I'm probably going blind someday. I don't think you need 2020 to be a pilot anymore. You can have correcting glasses. Sweet Tooth Fairy, so good to see you. Yeah, Sean Bird is the only bird that doesn't appear unless Jamie's here. Exactly. An iron rod. Well, my brother lived in an apartment in Copenhagen. Really old, really crappy apartment that didn't have room for a shower in the bathroom. The bathroom was just a toilet. So in his kitchen, he had, we call them like a shower column, which basically is like you have the shower head on top, and then you have some round bars going through that you can, where the shower curtain goes all the way through, and then you just close it in the middle when you're taking a shower. And one of those round bars, I was turning around, and I slipped that in the corner of my eye, and I really damaged my retina. It hurt like hell. And since then, my eyesight's been going bad. So I don't like those shower columns anymore. They should put some. It's just like a piece of iron. Probably should have had like a block on the end to make sure you didn't poke it in your eye, but I did. That wasn't too fun. I was supposed to go out drinking that day, so no drinky drink. And I had to take the train home the next day, and it just hurt. And I went to the hospital, and they shot me full of everything and put a patch on and tried to put something in to relax it. And the next day, when I was sitting in the train, my head just felt like it was exploding, and I couldn't think, I couldn't talk, I couldn't do anything. Everything was just killing me because it felt like this side of my head had just blown up. And there was this sweet old lady, probably in her 80s. She was sitting across from me, and I don't know, I was probably crying or something. I can't remember anything, but just my entire face felt like it's been blown off. And at some point, she just reached over and put 4 painkiller on the table and said, "I think you need this." And I just chucked it down, and yeah, that helped a bit, but that wasn't too good. That was probably stupid. Well, we don't. Well, yeah, I probably could do that. No, I like Copenhagen. I used to live there. I just don't think that people should only stay in Copenhagen. They should go out and see the real Denmark. Hey, truth and transparency. Nothing much. Another sidebar, another witness. They have to look up the law to see if he can come in and testify. So I'm just talking about how stupid I am sticking iron in my eyes. It hurt a bit. Who knows, Diane G? I have beautiful eyes. Well, I'm so lucky I'm born with 2 recessive genes. So I had, well, it's not that blonde anymore. Now it's more gray. So I have blonde hair and blue eyes, which it shouldn't be possible because my mom had brown hair. All my siblings had brown hair. But My dad's gene won that one. Yeah, my brother was really not fond of me saying, I need to go to the hospital. I thought I lost my eye. I couldn't open it. I had to pry it open at the hospital and had the worst. She was Swedish. I had a Swedish doctor looking at me. That's why I hate the Swedes even more. And she got at me. I might have been drunk, but not that drunk. And my buddy was making fun and said, "Hey, get out here. The cab is waiting outside. We need to go out dancing." And she flipped the script. I didn't go out drinking. Yeah. Yeah. Sidebar the movie. Him, that wasn't what happened. That was on purpose. I didn't slip. We covered that last Monday. So no, yeah, last Karen Reed was last. No, maybe last Friday. Yeah, we covered the stand your ground hearings last week. So if you don't want to see it on Grizzlies, you can go back and watch me and Jamie watch it. I didn't went out drinking. It hurt like crap. Ladies love a pirate. Yeah. It can happen, but it shouldn't. Statistically, it shouldn't happen, but it do happen sometimes. Snake Plissken was a cool guy. And there's only one escape movie. I never played Solid Snake. Arr. It's yeah, but that was a stupid mistake I made. But then I got to wear glasses. I had round Harry Potter glasses once. Wasn't a good look. Bum, bum, bum. Now I need Jamie to talk to because, again, nothing's happening. I used to, but I don't like getting them out of my eyes again because I'm not fond of things touching my eyes. So I used to wear contacts, but I don't like it. But I can see, well, I'm having a little trouble watching. I have my control panel open over here. The chat in that, have a little problem watching that one. But I can see fine on. Well, I have how I'm sitting 75 centimeters from my screen. I can see that clearly and read what's going on, but I can't watch my phone when I have my glasses on. Then I have to take my glasses off. And I was driving once with my sister. I had to pick her up from the train station, and she was like, "What the F are you doing?" I said, "Well, I didn't see. I was a person on the side of the road. I couldn't really see it was a person." I said, "Probably you should start having sunglasses with the corrective lenses into because you're blind as a bat." So I need them when I drive now. I don't need them. I could drive without my glasses, but I don't like to do it because distances and stuff like that gets a little blurry. Yeah, I need Coke bottle glasses like him. There was supposed to be a third movie called Escape from Planet Earth. Luckily, they didn't do it. Don't get the measuring tape in your eye. Don't tell me where I put my measuring tape. I've only hit myself once or twice with it. course I do, because you never know when you have to measure something, and I just need to have one with inches and feet on it, because I can't convert it in my head. But it's nice to know when they talked about in the Karen Reed case that it was either a foot from him, and I believe that's 30 centimeters, or it was 3 feet from him. Then I can do this and visualize to myself and say, yeah, that's a big difference. Well, jeg havde det ikke, men min kammerat havde en Puch 3G, der kunne løbe 110 km/t. Problemet var, at bremserne er ikke skabt til det. I can see clearly now the rod is gone. Yeah. 75 centimeters is 47 feet in freedom units. Probably. Hey, Ralphie. No LASIK or LASIK. Well, that's the funny thing about the healthcare system. I would have to pay for it if I wanted, but it's not that bad that I need it. And I had a friend who, because he was blind as a bat, so he could get it paid by the government, but I would have to pay for it myself. I can only say very little I can say kebab. Thank you, Watch Out Trials. Ghost of Mars, is that the one with Ice Cube? Great, bad movie. No longer see the obstacles in my way. Exactly. No, everyone should always have a tape measuring device. It wasn't French, it was Danish. My buddy, he got it. Well, he got it in his 30s, but he was really happy because he's always worn glasses. Really annoying when he had to play sports. Yeah, but it's just so people don't think universal healthcare covers everything. Measure twice, cut once. Yes. That's such a male thing to say. No, it's a good. Imagine if all the ladies too had a tape measurement, then they would know. Oh, 14 centimeters. That's 6 inches. Nah, buddy, not buying that. Well, you need it in. This is a highly professional YouTube stream, so you need a tape measuring device. Carla, I don't think you have missed a lot, other than if you are in a bad relationship, you will always be in a bad relationship. You can't break it. Oh, that's not good. I've never seen the Addams Family. Say what? Yeah, I would love to wear contacts because I like having contacts in, because I always forget my glasses everywhere. And I have a pair of glasses that I wear, then I have a pair of glasses when I don't feel good, and I have near my TV. It's an old prescription, so they're not as good as the normal one, but it's good for watching TV. Then I have a pair of glasses in my gym bag.
All right, you guys ready to go back on the record?
But I would love to have
Yes.
contacts, but I just don't like
Printing something.
poking them out again.
All right, the objection is hearsay. Any other objections?
Judge, also, I would like to make a relevance argument that the fact that he's going back and forth.
Well, it's apparently a big deal. I've heard that 666 story. It's not a problem for us Europeans because we are on average 7 inches. Just telling you, ladies, I might be back in the US at some point.
In this email about a specific property, there's no relevance to it.
All right, proponent, go ahead, sir.
Well, I think it's admissible, one as a business record, which we've already qualified. Business records traditionally contain hearsay, and under the statute, Your Honor, specifically subsection C, we got this email from the state. However, we then gave it back to the state in its isolated form. They have not filed any objection to it, so they've waived that objection according to the business records exception. We also believe that it shows Doug Benefield's state of mind that he was in the process of buying a home directly behind Ashley Benefield's home during the time period when the South Carolina injunction was in full force and effect.
All right, anything else, sir?
That's right.
State?
Judge, I found a case I would like to put on the record, Thomas v. State, 993 Southern 2nd, 105 from 2008. It is specifically addressing an email that was put in as a business record. I didn't have long to read this, but it was an email that was sent to an apartment complex manager of some sort. And it appears as though it was not qualifying as a business record. And additionally, the hearsay within the email was not admissible. There is a yellow flag, and I'm trying to look at it now.
Finally, you got out of bed, douche. No, I said it in the beginning. It'll be sidebar, sidebar, sidebar. And well, then where have you been? Have you been out drinking again, fooling around with all them boys? Well, yeah. What now? I can tell you what now. Jamie's here. Welcome to Sidebar Heaven.
Aw,
All right. Did you review
Mm-hmm.
Thomas B. State?
Have you been watching, Jamie?
Yes, sir.
All right. Do you want to make any argument?
most of it.
Yes, sir.
So no.
So Thomas V. State is helpful. So 993 Southern 2nd 105 First DCA. Although it was the state introducing the email against the defendant, the state sought to introduce an email that was prepared by
I think
an
there's a waste of time.
employee of the apartment complex where the victim lived and was murdered regarding statements made by the victim that she had someone living with her that was not on a lease for a year and she wanted that person out. And obviously the state was introducing that to prove that that was the defendant and that the victim was trying to evict him, and that was part of the reason why he then murdered her. And the first DCA found that even if the email from the employee's side qualified as a business record, and it seemed to, I don't see where they actually found and held that the email was a business record, which was my original question, but ultimately concluded that the statements that were made and then by the employee and then communicated through that business record, those statements were not, well, first they're hearsay, but they were not part of the records and the data compilations of the business itself. And that although hearsay may exist within exhibits that fall within an exception, such as business records, those hearsay statements must still qualify under a separate exception to the hearsay rule. And in this particular situation, if I'm understanding correctly, what the defense is asking is to introduce Defendant's Exhibit 27 through Mr. Vizzacaro as his business record that he keeps. But according to Thomas, and then they also cited a prior case of theirs, Van Sant v. State, VANZANT, 372 Southern 2nd 502, Florida 1st DCA 1979. Even if this qualifies as a business record, which again, I have not found a single case that says it does or doesn't, and I don't see in my review of Thomas where it says it is or isn't. But the statements of Mr. Benefield are being offered to prove the truth of the matter that he's looking to buy a house in Lakewood Ranch are hearsay without exception.
But the exception, Your Honor, is his state of mind. It clearly shows Mr. Benefield, let's not forget what the defense is here. The court's allowed me now to bring in evidence of domestic violence. And here is Mr. Benefield, Judge White, negotiating with the Realtor to buy the house directly behind the home where Ashley Benefield lives. And he's doing it at the time in South Carolina domestic violence injunction prohibits that. He would not be able to buy that house directly behind Ashley Benefield's home. It's like 200 feet away, 100 feet away. And it's a continued pattern and practice. That cooperates with the sentence.
Do you want to be heard on 90.8033, then existing mental, emotional, or physical condition?
Judge, his emotional, mental state, that still has to be material to a material fact. And his state of mind at that time is not a material fact. Also, I think the defense is misrepresenting some of what's in the email. Mr. Benefield never said he wanted to buy the house. He said he wanted to rent the house, and he said, I'll have to check with Ashley first. So I think some of the misrepresentation that's going on, we should probably just read the email. But I don't think it has anything to do with his state of mind. His state of mind at this point in time is not relevant.
Well, no stippling on him. So that's more than 3 feet. And 3 feet is
All right, as I
this
said
much.
before, are you going
That's pretty
to
close.
establish the location of the home through Visicaro,
Yes, sir.
where it was
Yes, sir.
in relation to the house where Miss Benefield lived?
Yes, sir.
And then are you going to then just argue during closing? I would assume.
Yes.
All right, so there's going to be no more witnesses. This is the end of this road to establish
Yes. This is just,
witness-wise.
this is an isolated act of DV. Yes.
All right,
Judge, if she didn't actually know about this, then I don't know that it's relevant.
well, and that's what I was thinking, because, hold on, it's not an act of violence, though.
Right.
Or threat. But under 9803 subsection 3, a statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, design, when it's offered to prove the declarant's state of mind, emotion, or physical sensation at the time or any other time, or prove or explain acts of subsequent conduct of the declarant.
Then, Judge, I would just ask that this witness be asked questions if he is allowed to testify. I don't know why we even have to speak about an email. Just, were you helping Doug Benefield and were you looking at a certain house?
I think that would obviate some of the evidentiary concerns I have, that you asked if he was assisting him in finding a location. Did you find one? Where was that location at that you were talking about putting an offer on?
Indeed, and if the court rules against the admissibility of the email, that would be my intention. On behalf of Ms. Benefield, though, I would like to present the best defense that I can. And I think that the email,
I believe the common thing, the common gunshot residue stippling is dependent on who the expert is, either 3 or 4 feet. So 3 or 4 feet is what? Launching distance? And what's the correct self-defense distance?
Yeah.
We know it's always too many shots. It's always the wrong type of gun. It's always the wrong bullet. What's the correct distance you are allowed to defend yourself? That's one of those things that it's always wrong when you're charged with a crime. But I believe that police officers would never ever let someone be within 4 feet of them if they were threatening. They would always already be deploying protective measures. Nudge, nudge, wink, wink. At that distance, because you can cover 4 feet in a split of a second. So would 4 feet be too much? Is 2 feet enough? How long is your arm? Mine is
You got your tape measure?
mine is 55 centimeters. So how much should I move and how fast can I cover 4 feet?
Pretty quick.
We all have questions, but the problem is the prosecution didn't ask them. Yes. Doesn't the saying go that if you're within 10 feet, you're more dangerous with a knife than with a gun?
Oh, yeah.
Yeah, but Ruby, you know how it is when the prosecution says, well, he was 4 feet away. Why did you need to do it? But they couldn't say, well, if he was 3 feet away, then it was okay. Because it's always the wrong gun, it's always the wrong bullet, it's always the wrong measure, it's always because you're charged with a crime.
Clearly is something the jurors can have, read, see. It's tangible. It has the same kind of impact, Judge, that the prior inconsistent statement of Gillum or the emails involving Stephanie Murphy does. And in the absence of a reason why it should be kept out, I would like to admit it.
All right. Thank you both very much. I'll allow the admission of Defendant's Exhibit 27 under 90.803(6) for the Realtor's portion and 98.03(3) for the Benefield portion. With the understanding that, again, this is a relatively collateral matter.
In and out, Judge.
All right, can you bring the witness back in, Mr. Vizzacaro?
She didn't shoot him 4 times. She shot him 2 times. Is 3 times okay? Is 1 time okay? That's the question I always ask when people. We saw a case where a guy got. They put 7 holes in him and 8. Number 8 went past. It took roughly 2 seconds. Would it have been okay if it was only 5 holes? 2 holes, 1 hole. The thing is, it doesn't matter if she was afraid of her life, then she is allowed to do it in the state of Florida. Did she have other options? Could she have jumped out a window? Could she have? I don't know. The prosecution haven't shown me that she could just have locked the door. She could just have walked out the house. What they have shown me was, well, sometimes you just need to get punched in the face.
Yeah, they've been.
That's kind of what they said on their cross-examination is it that bad to be punched in the face? I don't understand the number of bullets. What does that mean? One of them were deadly. So if she didn't put that in there and he was as angry and violent as she said, and he would be on trial now for beating the crabiola out of her, would you have said, well, she could just have used 1 more bullet? The amount of bullets, the type of bullets is always wrong when you are charged with a crime. It doesn't matter. What matters in this case is, was she so afraid for her life that day she didn't see any other option to do this? Doesn't matter how many times she did it. The position of them, I think the leg wound is a problem to me. I don't understand it. But front shot. It's not in the back of the head. It's not in the back. So it doesn't seem like she snuck up on him and did it. But the prosecution haven't shown me beyond a reasonable doubt that she wasn't so afraid that she felt it was necessary to do it. Then 1, 2, 3, 4, 5, 25 doesn't matter. Because I used to have a job where I wore green clothes and was given a pew-pew. I was told you keep squeezing that little thing to people lay down and stop pew-pewing back at you. We weren't told that you can only use 3 bullets per person or 1 bullet. So we want to make this about everything else. Oh, she used dum-dums. She used the 45. She could use the 22. That doesn't matter. Was she afraid of her life in that moment? The prosecution's job is to prove to me she wasn't. She had planned this because it's second degree. She wanted him dead. That's what they have to prove to me. And I don't feel they have done it. Do I believe her 100%? Nah, I have my doubts. But they haven't proven to me that she lured him over there, sent her kid away, and then took 4 shots at him, only hitting twice.
Yep.
So that's the problem. We want to make this case about everything else. But what counts is those 2 seconds where she did this. What was her state of mind when she did it? Was it premeditated, or was it because he, according to him, was making her scared? That's all it's about. I'm just saying that the prosecution always will make you say it's wrong because he was so far away, you could have jumped out a window. Oh, why didn't you just shoot once? It's the same with police shootings. Why don't you just shoot the gun out of the perpetrator's hand? Because that's almost impossible to do. You always go center mass. So that's, I know a lot of people want to make this about everything else. A lot of people want to put in stuff he did, she did. It doesn't matter. It matters what happened the last 5 minutes on that night. How was her mind? And I don't feel the prosecution had shown me she wasn't afraid of her life. Well, I can invite you over, and if you attack me, well, I can't do it in Denmark, but I can invite you over and say, hey, you want to come over and watch my stamp collection? And then you come over and you say, yeah, but now I'm going to beat you. I'm allowed to invite you over, and then you can change your mind and be violent.
Exactly.
All right, welcome back, sir. Just take your spot back there.
Exactly.
In that chair, we're going to get the
You
jury
said it
back
correctly.
in and we'll give your testimony.
Sounds good. Thank you.
We'll bring them in.
Yes, but it's for the prosecution to tell us if that's what happened, and they haven't. I hope this case is over today so we don't have to be here on that hellish stage. I'm going to roll down the blinds and stay inside all day.
Gosh, is it coming this way? It's up to you.
Wasn't that what I said? The state haven't proven to me that she wasn't allowed to do it. But that's, I agree. not me. I would like to have, right now, I could eat some chocolate cake. Oh,
Some what?
chocolate cake. It's a cake with chocolate flavor. I have
All right, y'all can have a seat. Welcome back, everybody.
I have
You're ready to
licorice
begin
ice cream in the
deliberations.
freezer.
Talk to anybody outside the jury about the case or do any research.
Licorice apple.
Everybody say no. Mr. Taylor, you may resume your direct examination.
Thank you, Judge White. Mr. Fisicaro, when we last broke, you told us you were a realtor and that Douglas Benefield had contacted you relative to a house in Lakewood Ranch.
That's correct.
All right, I'm going to pass to you, Mr. Fisicaro, what I've had marked as defendants exhibit number 27. That would be the email messages that you referred to before when we were last in front of the jury, correct?
Correct.
Is that a true and accurate copy of the email exchange between you and Douglas Benefield?
Yes.
What is the date of that exchange?
The last email I see here was March 12th of 2018.
March 12th, 2018. Your Honor, at this time, I would move to introduce that into evidence on behalf of Ms. Benefield.
All right, same objections, overruled. Defendant's exhibit 27 will be received.
Now, Mr. Fisicaro, I know you've told us that the home, do you recall the address of the home?
Yes.
What was it?
5060 Newport News Circle.
All right, I'd like, with the court's permission, to dim the lights, and we're going to put a diagram up there for you.
They can, even though closing isn't testimony, but yes, they can connect the dots. I'm just saying, so far, they haven't proven to me that she wasn't in fear of her life. And that's why I would have to say not guilty if I was voting right now, because in the great country of America, the benefit of the doubt always goes to the defendant. And because I'm not 100% sure she didn't act in fear of her life, I must vote not guilty if I am to do what the jury is told to do.
Yes.
I could look into what happened 5 years before, but that's not what the jury is told. On the basis of what I have seen this last week, I would have at this moment, before closing, the way the prosecution have presented their case, I would have to vote not guilty. Even though I'm not 100% convinced of her testimony, I felt she was believable, but I didn't feel they presented a counter case strong enough to sway me to say she must be guilty. Remember, we start the case not guilty. Any case not guilty. Even the worst predators must be afforded the right to be presumed innocent. Then the state have to bring it to guilty, and then the defense have to batter it back to not guilty. If I'm sitting here and I can't decide by the rules stated, I should vote not guilty. Yes, the Dean Cummings case is actually quite like this one.
You have the, what's it? Okay, so this will give you
The beam?
Okay. Would you please show
It's a
us
realtor.
on that
One of those in
diagram
the Travis Rudolph
where the
case.
house was that Mr. Benefield contacted you about purchasing?
This one right here.
Right there. Now, that house, is it directly behind the house in front of it with a red dot on it?
Yes. Yes, it is.
Okay.
She could have. But if they had a good, cordial relationship up until that day and everything had been working great, but he just flipped. We don't know that because the state haven't proven it that everything was fine. There's a lot of things that could have, would have, should have. But this case is not about could have, would have, should have. It is about she was not afraid when she pulled the trigger, or she was afraid when she pulled the trigger.
Do you know, Mr. Vizzacaro, who was living in the house with the red dot at 11331 White Rock?
And just to be perfectly clear, I can understand why Boomer can get to another conclusion than me. I don't run a channel where we have to agree. I'm just telling my perspective. Everyone here can make their own judgment on the call, because that's what this channel is about. Discuss it with people. Put in what you have experienced. This is what we want to do. I don't want an echo chamber. I think everyone has a right to their own opinion. Just like I have an opinion that this realtor seems like a guy who stands at bars with their 20-year-old girls and says, "Did you know I'm a realtor?"
Harris.
No, I don't.
And do you know whether or not, if I may, you know whether or not you don't know who was living in this house?
No.
This is the house that Mr. Benefield was interested in purchasing.
Correct.
Do you know whether or not Mr. John Samp lived in that house?
I don't know.
Give me just a moment, Your Honor. I don't believe I have anything further. Okay. Should I continue? Mr. Vaccaro, my oversight. I'm going to pass to you what I've marked as defendant's exhibit number 28 and ask you if you can identify it.
Yes, that's the house.
That's the house that Douglas Benefield had contacted you about purchasing.
Correct.
And is that in exhibit 28 a true and accurate reflection of the locale?
Yes,
Does it have a dot on it?
it does.
Does it have an address?
It does.
What is the address?
5060 Newport Circle. Newport New Circle.
On behalf of Ms. Benefield, we want to move to introduce that as defendant exhibit 28.
No objection.
Receive.
That's all. Thank you very much, Mr. Vizzacaro.
Gotcha.
Cross.
So you've had the opportunity to review the email, correct?
Yes, I have.
If I could just grab it real quick. And for the record, this is State's Exhibit 27. And it appears as though you're speaking with Mr. Benefield about potentially this house coming up, or the price being lowered on this house, correct?
That's correct. Yes.
All right. So you were contacting Mr. Benefield?
I reached out to him about that.
Okay. And he actually said he may just want to rent. Isn't that correct?
That is correct.
And he also said he didn't want to do anything without speaking to Ashley first.
That was a comment that was later in the conversation. Yes.
Okay. And if I could show you State's Exhibit 27, it's very small type at the top, so you might be able to.
That's why.
Record defense exhibit.
I'm sorry, Defense Exhibit 27. Does he say there that he needs to speak with Ashley first?
It appears that way. Yes.
Okay. Thank you. No further questions.
Can you redirect?
No.
Can the witness be released?
Yes, sir.
Ma'am?
Yes.
All right, sir, you're released from your subpoena. You're free to go.
Thank you.
Jamie, do you think Molly is dead? She's been lying
Mr. Taylor,
on
can
the
you
side for the
state
last
defense
hour.
and approach real quick?
What'd you say?
Do you think Molly is dead? She's been lying like this on the side for the last hour.
No. She is just loving life right now.
She's totally soaked up.
Oh.
It's
Sorry, call your next witness. Defense would call, Your Honor, Dr. Jason Quintel.
Jamie, do you think all these witnesses are necessary?
No, honestly,
I don't feel they prove anything.
they're not really making anything more clear.
Oh, that guy.
Welcome back. Thank you. Thank you. My name is Judge White. I'm presiding over the case. Same rules as last time. Just make yourself comfortable. Adjust that microphone as you need. Speak in a loud, clear voice.
You heard her bark earlier. Yeah, rest the case.
Good afternoon, Dr. Kim.
Hi there.
Welcome back.
Thank you.
As a result of the counseling sessions that you had with Douglas Benefield, did you reach any conclusions with respect to Doug?
Objection. Improper testimony. Opinion testimony.
You go ahead and approach.
Oh,
Oh my God, come on. The papers and the microphone. Oh, it's giving me the heebie-jeebies. Are you muted? Oh,
no,
you're
I'm
muted.
not saying anything. That's why I'm not.
I thought I looked up and your mouth was moving. I couldn't hear anything.
Well, I'm typing, so I might be sitting here saying A, B, C to figure out what letter I'm using. I feel this has been a totally wasted day.
Yeah.
I still think they should have ended right after her testimony. Her on the stand crying would have been really, really hard on the prosecution to get by. And now they're putting all of these nonsensical witnesses up there. I think, and they did he want to rent a house? Yeah. Did he said he want to talk to Ashley about it? Yeah. Why? What does that prove other than, oh, he wanted to live close by his daughter and he was talking to Ashley about it? That's not that stalkerish to me. That's just,
No.
oh, I want to make it easy for you to drop off, not Ashley, drop off. I've forgotten her name. Our daughter, when you need me to help take care of her, and because the restraining order wasn't in place because she went away with him. So I think Father Time is really wasting a good state defense case with all of this nonsense.
Mm-hmm.
Yeah, keep it to her testimony. Turn the page by Bob Sager. I think she's listening to "It's Raining Men." Hallelujah, it's raining men. No, I don't think she has anything. I think because the way he acts, he seems befuddled by his own questions. And his arguing is such a weird argument. Emerson, that's the name. Yes, exactly. After that embarrassment, boom, ended there, and then the state was going on and do their closing. Said, "Yeah, we are really sorry we met the defendant cry, but she's a mean person. We were mean to her, but she's meaner." Well, that Hulk movie was really bad, so no one knows it's the Nick Nolte haircut. I am wrong. Well, it wouldn't be the first time. State really messed up this case. They had to prove guilt for murder too. I don't believe the defense has sufficient proven self-defense, but I couldn't find it guilty for murder too either. Exactly, Olivia. That's where I'm standing.
Mm-hmm.
No, it's not invalidated legally, but they had daily contact and they were in contact. So I bet you no police officer would say, "Oh, I'm going to charge you with this because you kept contact." And was it in place? We know it was in place when he was in South Carolina, but he was in Florida now. We haven't heard anything about that restraining order because they were in daily contact. They were out eating. The defense never talked about the restraining order in connection to that. And we know that they had withdrawn something in court. So I don't know. Oh, she's got a big old sit right there. And Florida doesn't enforce out-of-state POs. So it wasn't in place. You're wrong is always the best argument. I use it all the time. I'm saying, Jamie, you're wrong. I did stream today. No, Jamie, the check is in the mail.
Paper tells me
That's
I'm wrong all the time.
no, because there's no delays in this chat. Holly Mac could be, but I just think it touched me. But I'm a blubbering softy.
Okay, Dr. Cattell, so a couple of questions about your practice.
Yes, sir.
I think you told us your specialty was trauma.
Correct.
And for purposes of practicing your profession, various clients come to you and relate their backgrounds, correct?
Various people come to me and they've had traumatic experiences in their background. Some may be upfront in presenting them, some may not. But purpose of treatment is to get now to work better, and sometimes that requires unplugging and healing emotional wounds from the past.
And as part of your art and science, you are trained in picking up and diagnosing various cues in your effort to reach conclusions to try and help them.
I'm not following the question.
As part of your practice, you're trained in being able to observe and detect various cues from these patients, are you not?
What do you mean by cues?
Indications of areas of trouble. For example, you don't always have patients that come out and say, oh, I am traumatized because of this. Rather, they may speak in obtuse terms.
So now he wants him to read a client's or a patient's mind. I would object to that.
And you are charged with, among other things, trying to figure out where the trauma lies and why.
I would answer that slightly different than the way that you're framing the question. So when somebody comes in to see me, my job is to understand what's not working and really what's not working in their life today.
Okay.
If that leads us to unplugging earlier trauma, which frequently it does, great. But that's the purpose when they first come in, is me understanding what's going on with them today that's not working, and hopefully saying it back to them in a way that they're getting it, that I understand.
And in that process, you rely upon various statistical manuals and things that are reflective of your profession, do you not?
I don't do specifically a lot of diagnosing, so I'm not going to use the DSM frequently. I'm going to understand the background of why trauma sticks and how to get that better.
And to understand the background of trauma, have you in the past, or do you periodically consult learned treatises and periodicals, things that help you to reach that understanding?
If you're asking, do I go to continued ongoing training and development? Yes.
All right. Now, in this particular case, did you reach some conclusions about Douglas Benefield?
Objection. Qualifications.
Sustained.
Did you counsel Douglas Benefield?
I did, yes. Both Ashley and Doug.
All right. And in counseling Douglas Benefield, did you listen and absorb the various points that he was making to you?
Yes, both when they came in as a couple, and then when I did individual therapy with them separately.
And when they were in there as a couple, was part of your process observing the dynamics between the two of them?
Yeah, I wanted to understand why they were seeing me and what stuff we wanted to get better.
This was a prosecution witness, and now the state the defense has called him back because they want him to testify about the dynamics when they were in the room separate and together.
So certainly I'm paying attention to what they're telling me, how they're communicating, what they're communicating, and such.
Okay. And part of that included how they acted when they were together and how they acted when you saw them separately.
Yes, I would say so.
Okay. Now, in making those observations and questioning them and listening to them, in your effort to try and identify the objective, did you reach some conclusions about Douglas Benefield?
Objection. Foundation.
Would you approach, please?
Jeepers Cripus.
Come back to a sidebar. Great.
Yeah.
What happened?
And it's the same sidebar we had before. Did you reach a conclusion on Douglas Benefield? Why didn't they argue that when they were up there the last time?
Right?
Because the state clearly don't want him to talk about any conclusions on Douglas Benefield.
Brief deviation, Dr. Patel. Tell us what degrees you hold.
So I have a bachelor's in psychology, a master's in social work, and a PhD in clinical sexology.
How long have you been practicing as a psychologist?
I got my master's in 98 and started working in the public school system. So since 98, 2006, I started a private practice.
And since you've been in private practice, Dr. Patel, can you give us an idea of the number of patients that you've seen in counsel?
Thousands.
And your specialty in
where
counseling patients runs to all three of those fields that you have degrees in?
Yes, I have a background in all of that, but my specialty is in trauma resolution.
Okay. And when we speak of trauma resolution, explain to us what that is.
So I think the first thing that somebody has to understand is trauma, or what we go through, isn't troubling because it happened, which is the conventional wisdom, is that because it was awful, it still hurts. But we're not troubled because it was bad. We're troubled because when it happened, emotionally, the brain short-circuited and doesn't know that particular experience ever ended. So where therapy missed the boat is we felt that people buried and repressed, and we have to help them process and get it out of them. Where the methodology that I use is the reverse. It's about getting the good news in to the emotional part of the brain that doesn't know it's over. Think of it more like unplugging the memory, so emotionally the brain can read it as data about something that happened versus where it's been stuck as happening, which explains why when somebody frequently either talks about it, is reminded of it, or is in something similar to it, emotionally they're transported back to that awful moment, right? If you have a friend telling you about something that was troubling them, and as they're telling you about it, it's almost as if they go back there to that troubling moment. Mm-hmm. So our goal is to keep the person more emotionally present as we unplug the emotional effect that the past has had.
And in that process, do you typically employ listening to patients?
Yes.
Do you typically employ making suggestions to patients?
I don't know if I would say it's making suggestions versus more kind of having a mutual outcome of how we want them to be in mind. So if I'm kind of creating a future self or an outcome, it's got to be something that they're good with, or if it shows up as conflictual, we're never going to be able to reach the outcome.
Mm-hmm. Okay. Now,
so more instead of a suggestion, it's more of kind of a mutual outcome.
All right. And you went through this process with both Doug and Ashley Benefield?
I did, yes.
Your Honor, I would tender Dr. Quintel as an expert in the field of psychology.
Do you want to voir dire the witness?
Objection.
Do you want to voir dire the witness as to experience, training, and knowledge?
Yes.
You didn't sound too certain about that.
You do most of your work now in trauma resolution, correct?
I do, yes.
Okay. And how long have you done trauma resolution?
Since 2006, October.
So for many years. And you said you don't do diagnoses anymore, correct?
I don't look at diagnoses with people. I look at people, because the notion of the diagnosis will help in understanding maybe some of the background of why somebody acts, but you're really working with the person. So if somebody says to me, do you treat OCD or, bipolar? I would say I work with people, not the disorder.
Okay. So when you're dealing with, for instance, Doug and Ashley Benefield, you're not doing so in order to create a diagnosis or evaluate. I guess what I'm trying to
just
get at
eat
is
a Happy
there's
Meal.
difference between therapy and a diagnostic evaluation.
Yes, ma'am.
Okay. And so your relationship with them was what?
They were referred to me by another therapist, and my job was to do trauma resolution. What I was told is that both had their own trauma, and there was some stuff within the relationship, and that I was tasked with unplugging the emotional effect of those experiences.
Okay, thank you for the question.
Maybe you have a question?
So treating people, not the disorder. You still, though, do you not have the capacity and the training and experience to understand if a disorder is present?
Yes, sir.
At this point, Your Honor, I would now tender Dr. Quintel as an expert.
And I
We
would
heard
object.
Same objections?
Same objection.
All right, I will rule the objections goes to weight, not admissibility. Go ahead, sir.
Thank you. So, Dr. Quintel, all right, we're rolling.
Okay.
Did you reach any conclusions with respect to Douglas Benefield?
Yes.
Would you tell us what those were?
Based on the conversations with both Ashley and Doug occurred as someone who was domineering, and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work.
Is the jury not there?
I thought they were.
I think they are.
I didn't hear him like excuse anyone.
Yeah. Yeah, they did the voir dire in front of the jury. Yeah.
That is odd. But okay.
I'm officially the worst TV show ever made. Lost.
He was very interested, despite conversations with some of the disparaging things that Ashley had said to him. He was very much still wanting this to work, and their plans were to move to Maryland.
All right. Did you reach any conclusions with respect to him being a real alpha male? Do you recall?
I would say that Doug occurred as somebody who was very built and well put together. And yes, I would say that he would fit the stereotype of an alpha male, in my opinion.
Did you conclude whether there was an intimidation issue present?
Ashley stated that she was scared of Doug.
Did you reach any conclusion, Dr. Quintel, about whether Doug's depiction of himself as being godly was reliable?
Objection outside of expertise?
Oh,
You can answer.
Can you?
Yeah,
say that
because
again, please?
voir dire is done.
Did you
We're
reach any
rolling.
conclusion with respect to Doug's presentation of himself as being particularly godly?
Yes, I think it was over the top.
All right, and did you reach any conclusion as to whether it was genuine?
I did not think it was fully genuine, no.
Did there come a time when you inquired of Doug why he would want to remain in this relationship?
Yes, I did.
Why did you do that?
Ashley had a lot of disparaging comments, stuff with CPS, claims of abusing their child. And I was concerned and curious why, with all of that negative stuff that may even negative affect his job and career with government, why he wanted to stay.
And was it true that you felt he was hell-bent on being together?
I know that he really wanted the relationship to work.
Did you conclude that he was never going to let her get away?
I don't know whether that's true, whether or not. I don't recall that.
All right, let me pass this to you and see
Please.
if it refreshes your recollection, if I may.
Thank you.
Does that refresh your recollection, Dr. Quintel, as to Doug's perception of letting Ashley get away from him?
Yes, I said that to the detective. I said it seemed more like I'm not going to let her get away from me.
Referring to Doug.
Yes, sir.
All right, and lastly, Dr. Quintel. Did Ashley have anything to say to you about Doug's interest in Emerson and whether or not it was just as
Objection, hearsay.
Sustained.
We don't know.
Did you reach any conclusions, Dr. Quintel, about Doug's interest in the child as opposed to Ashley?
Objection, Judge.
I'm going to sustain this to the opinion.
Was there an incident on one of these occasions when Doug was in your office that you thought was very strange as it related to the child?
Objection, relevance.
Overruled as long as it's factual.
Yes.
Can you say that question again, please? Thank you.
Was there an incident that you observed that you found particularly puzzling between Doug Benefield and the child, Emerson?
Yes, at the time that I spoke with the detective, I had an appointment and Doug had waited in the reception area, and it was a couples counseling, and Ashley was out in the car with the child. And I thought it was unusual that he didn't go out and see her. Given that they had the relationship they had, it may not be as unusual as I thought, but I was coming from having two little girls and what would be in my mind to do.
And how long was Doug sitting in your office at the time? Do you recall?
Well, it would have been at least an hour. I don't know how long I was in the appointment before.
And in that hour, from what you observed, with Emerson, the child, outside in the car, Doug Benefield never once went out to say.
I wouldn't have been able to observe that because I would have been in session. I just knew that he was waiting in the lobby. I don't know whether anything other than that.
That's all, Your Honor.
And
Cross.
So you mentioned that it bothered you, or at least you noticed.
Salomon, you missed 45 sidebars. And this witness is the only one that has been any meat on the bone of today, because he testified that Doug was an alpha male. He probably bought that course from Andrew Tate. And he was controlling and wanted to make it work. And now we get on to the state, who will try and pick that apart.
When he didn't go out to see the child, how long did you observe Doug Benefield in the waiting room?
I would have seen him when I first went out to grab the client, and then would have seen him when I came back out of my office.
And because of that, you came to the conclusion that he never went out and saw his child?
Yes, I did.
Okay. And I believe, and correct me if I'm wrong, in your direct examination, you said you met with Ashley Benefield alone 5 times.
Yes, ma'am.
And you met with Doug Benefield alone twice.
Yes, ma'am.
And you met with them together twice.
Yes, ma'am.
So the majority of the time you met with Ashley Benefield. Over half of the times you met with her.
To do trauma resolution. Yes, ma'am.
And her discussions with you and her recitations of things played into your decision about this opinion that Doug was being domineering and super controlling, did it not?
Yes, they were comments that she made and frustrations that she had within the system.
Okay. So it was not solely based on things that you were observing in Doug Benefield.
No, ma'am.
Thank you. No further questions.
Redirect.
Nothing further.
Can this witness be released?
Yes.
State.
Yes.
All right, sir, you're releasing your subpoena. Thank you very much. Here you go.
Thank you.
We published the couple of exhibits that we put in through Mr. Mizikaro. And then I think 4 months break for lunch. I don't think that's.
Oh, that's not, yeah. Oh, you have 27?
Yes, those gray strands are
One photograph
real.
was already in,
One.
and then one we added together with the.
He didn't.
Yes,
He
so
didn't
we're
buy a
jury-
cruise
we're
for
gonna-
her. She had
Actually,
bought a
I'm
cruise,
publishing.
and he paid
I'm
for
not
her
rushing you, but
friend.
I'm going to talk while we're
But she also bought a reverse vasectomy for him. The small gifts you give your lovely partner.
Yeah.
I would never, ever in a million years but that's because I have the children I need.
doing that. I think at this point,
I think the last witness helped them by stating that dog was controlling and controlling. Wasn't that the word he used? And perceived himself as a alpha male.
it's a good time for our lunch break. It's about 10 minutes after 12.
Oh.
So take your time. I want you to look through all of this, look through these exhibits, and I'll excuse you.
Exhibits 26 and 27.
Those 27 and 28, and they'll be marked on them. There's a little sticker on each,
Yeah, you can just get the turkey baster.
which should say 27, 28, and I think the other one is Defense Exhibit 1.
That would be Jamie.
What?
It's you slurping on your juice box.
I don't have a juice box. I wish I did.
No, Letitia Stark was short and fat, wasn't she?
Who?
Letitia Stark. Wasn't she a little short, fatty?
No. She was short. I think she was just normal though.
Maybe it's just because all the ninja stories I just didn't really watch it. I think that was the first trial I watched on Dave's.
Yeah. She was hard to watch though.
And she was an absolute idiot.
She's an absolute psycho.
But this is in Florida, so she might know the burial site where Tupac got resurrected.
Yeah. I mean, maybe Ashley could have just,
Well, sorry, Luna. You know it slips out sometimes.
All right, so it's 12:15. If I could have you back down in the jury assembly room where you began everything this morning and last week at 1:30. Should give you plenty of time if you want to go somewhere, if you just want to walk downtown. Be in the jury jury assembly room at 1:30. We'll get you back up here as soon as we can to get started for the afternoon. Remember the admonishments, don't talk amongst yourselves with anyone outside of the jury, or do any research on the people, places, things, the legal topics we've heard anything about. Thank you. All right, y'all can have a seat. I would assume, before I let you all go, that the request for an exhibit list from the defense of the items that they expect to introduce has been provided,
Yes.
right? And certainly a list of witnesses that are expected to be called.
Yes.
We still calling witnesses?
I didn't get a copy of that. If it's been amended from the witness list that I received, it looks like it was filed June 21st of 2024. So I'll just mark, but who do we have on tap for this afternoon?
So we
I don't need to
have-
know the order, but just who?
We have Jason Alexander, Michael Haig, Haag, Dr.
Hold
Emma
on one second. I'm sorry. I got it. My list is, okay. Michael Haig,
Michael Haig, Dr. Emma Lou,
all right.
and Warren Justin.
Warren,
Justin, the lead homicide detective.
Oh my God,
all right.
why?
None of these, have all these folks been deposed?
Yes.
All right. Are there any objections or anything I need to hear before, before we get a jury in and get them seated and make them sit there for 5 or 10 minutes while I hear arguments at the bench? I would
Thank you,
much,
Judge.
much rather have the objection made. Let's talk about it, and then let's call the jury in so it's a little bit smoother.
With Detective Warren, I may have objections, but I don't know what's going to be asked. So without asking what they're going to ask, I don't think we can have that conversation. And additionally, if Detective Gillum is set to testify, I would have similar objections.
You didn't say that name.
No, they've been keeping him here, so.
Okay. You think just 1, 2, 3, 4 witnesses are going to take us the whole afternoon?
Yes, I think there's a reasonable good chance we rest today.
Okay. Oh, is this the bulk of what you're calling at this point?
Yes, sir.
Okay. Well, that would be fine, because then we could do a preliminary charge instruction this evening. Then you guys can decide if you want to do any rebuttal. Okay.
So the one request I do have, Your Honor, is for Mike Haig, who's our ballistics expert.
Mike,
We need
Mike
Mike Haig,
Haig, yes.
J-A-G.
Okay.
We need the HDMI cable to run to the witness stand so he can plug his laptop.
To where? Here? I don't understand.
Yeah. Project it. Yeah, so it'll be up on the projector.
So he's going to use his laptop to project here.
His testimony, yes, sir.
I know that's.
I don't
This is the
understand,
one
Father
we
Time.
use.
He's making
I don't know
so
if
many
is that
stupid mistakes.
stretch to here?
We'll inquire and we'll check it out.
Oh, you know what? IT has got to come and fix my computer anyway. So can you tell them that we also need that a witness this afternoon is going to have to run to that?
Yes, sir.
Thank you so much. And then that'll take care of both, because my goblins, just, you know how it goes.
Okay,
All right.
thank you, Judge.
I guess the only other questions they would have is there were
And
other
then
witnesses that
what's the
were held
problem?
by the defense. If these are the remainder of their witnesses, are those witnesses being released?
What
They're asking
what
the
is
state.
Pascal trying to do?
We don't know what they're
missed
presenting.
it.
to rebuttal.
Okay.
Well, he's been going long. I don't get to bed till midnight because of this a-hole. I miss Bev getting off. It's 9:30. I think we're done for the day. White Claw.
White Claw.
Oh, okay. Gracias, Marisa. I didn't watch the Rust trial, so I don't know who Mike Haig is. Well, they should have rested Friday.
Yeah.
It was a joke on Judge Bev.
Yeah, she had a hard
Because
cutoff time. That
because I
was
have to
probably
get
the
up
best
at
thing.
5:30 in the morning, make videos, or Jamie yells at me, and then I have prepare for next day's streaming, or Jamie yells at me, and then I have to walk Molly.
Yep. He needs to get his views. Or we're gonna have words.
I just read Dutch and asked a question, and no one was impressed that I could read Dutch.
No one was impressed.
What time was the jury? I forgot. 1:15.
Yeah, 115 is what he said. No,
Oh shit! I should
yeah,
put this up where you can see all my backend stuff.
130. That's what he said, 130.
Yes, 1:30. That's what we heard. Let's see if it works today. You can. No, you can't spell turd. No. I can read it. I can't speak it.
Yeah,
No,
it's working.
I think they fixed the water Thursday, but we still don't know if anyone brought in any coolers.
I know.
That's what we were really wondering about, because we wanted to figure out if what the hell did I do? But as always, I will walk Molly and get some dinner. Jamie will go rattle up the birds because they haven't been singing, so she'll yell at them to make them sing.
No, it's gonna be 85 today. I got my window shut. Sorry, people.
And if you want to go and get your lunch, I will notify on X and on Discord when we are back again. Putad. I think
Bye.
that's a bad word in some language.
Like Pishka? Pishka.
No, I said putad. I think that's a bad.
Oh.
I think that's a bad word in French or something. I don't know. Everyone, enjoy your lunch if you're getting one. Enjoy your game if you're sitting here making sure Boost doesn't win. And we'll see you in roughly an hour.
Okay. Bye.
Bye. Bye bye. Bye bye bye. Hola, everyone. We seem to be about to be back, and pray to whatever deity you believe in that we will get testimony, not sidebars, for the rest of the day, because this is annoying. But Medita, I got my hot water bottle, so I should be less irritated in a while when when my muscle stops cramping. We had a walk and a poo. I'm so sorry, RJ. I'll just let it run and do the recap for all y'all in the morning. It'll be a sidebar, objection, sidebar, objection. No, it's my hot water bottle. It's really nice to sit in 70-something degrees weather and have a hot water bottle, but it helps with the muscle. It makes them relax. So it doesn't hurt that much. Well, Molly didn't even want to eat her ice cube when she got home. She seems like she's really hot, but she don't want to eat her ice cream. Her ice. Oh, the competition is fierce for lunch break.
All right, welcome back, everyone. It's after lunch in 2020 CF 3014. Is the jury up? All right, jury's being brought up. Anything we need to talk about before the defense calls their next witness? Oh, I'm so sorry. I was looking right over top. Oh, it's a good point.
Yeah, but it doesn't heat it up enough. So boiling water in a hot water bottle and just keep it on, and it'll loosen up my muscles.
I can see if this thing's working
It
again.
should be.
I got this from FD Food Fairy. It says, pew pew, motherfucker. Good evening, Dean. Thursday. I believe that is how I do.
All right, looks like my real-time viewer is working again. All right, welcome back, everybody. It's after lunch now. We're all back in 2020 CF 3014. Is there anything we need to talk about before the defense calls its next witness?
No.
All right. As soon as the jury comes up, let me know and we'll bring them on in.
Yeah.
Justin Warren.
His PC wasn't working in the morning.
All right, y'all can sit down. Welcome back, everybody. As we were breaking, I saw some folks got new pads of paper, and everybody's pen is still doing okay? All right, just let us know if not. I hope you had a good lunch. Did anybody discuss the case amongst yourselves? Talk about the case with anybody outside?
Hi.
Or do any research?
Hey, Joe has a birthday. Happy birthday. Hey, Joe. Happy birthday. Hey, Joe. Happy birthday. Hey, Joe. 25 years, never looked this young.
On people, places, things, or legal topics
topics or get any information about the case?
No, sir.
Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Judge White. That's called Justin Warren.
Yes, Solitaire was down.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Close surgery. Just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. Just up, down, left, right. You need loud, clear voice, and we'll hear everything.
Yes, sir.
Your Honor, with court's permission, permission to treat as adverse.
You can go ahead and approach.
Already.
He just asked, is there anything before I bring them back up? And I said, nope. And the first thing is, can we approach? And he just, no. Oh. Even he hates it now.
Oh,
So
man.
sweet.
I mean, his head's on his head in his hands tells it all.
Yeah.
Come on.
Felices Mahanietas to everyone. You're killing me, Smalls.
Come on. Do some lawyering.
Bum, 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 bum.
Bless you.
Detective Warren, good afternoon.
Good afternoon, sir.
You were the lead on this case, were you not?
Yes, sir.
Will you tell ladies and gentlemen of the jury, what does that mean, the lead detective?
The way that our unit works, the Manatee Homicide Investigative Unit, the lead essentially during a homicide investigation is elevated to essentially almost the rank, not a sergeant, but basically has some of the same responsibilities as far as handing out assignments and then collecting the information at the end.
And is amongst the ones with the most knowledge of the case. Would you agree?
We do collect everything at the end, but we do have meetings, so everybody's pretty much aware of what's going on.
All right. Does the lead detective develop the theory of the case?
We work as a group, so like I said, it's pretty much a group effort.
Come on.
All he wants from him is one thing. You saw
Yeah.
it already.
Do you recall being asked the following question on May 16, 2023 at a deposition? Question, okay, so part of your responsibility as the lead detective, you would develop a theory of the case, would you not? Answer, sure.
The answer is still sure. Yes, sir.
You want your investigation, especially for homicide case, do you not, Detective Warren, to be objective and fair,
Yes, sir.
with conclusions supported by evidence,
Absolutely. Yes, sir.
not speculation.
That's correct.
It's not something, given the nature of what a homicide investigation entails, that you want to jump to conclusions.
That's correct.
Did you submit an arrest affidavit for Ms.
Objection.
Benefield?
Pre-trial rule.
Just asking the question.
Just
At this point.
Did you submit an arrest affidavit for Ms. Benefield?
Yes, sir.
Did you represent that?
Objection, pre-trial rule.
Sustained.
Why did you call this witness? I think you had like 3 or 4 more.
Did you describe,
Objection, pre-trial.
Go ahead and ask a question.
let me ask you this. Was it your position that based on the entry wounds to Douglas Benefield, that it did not appear he was facing Ashley Benefield when he was shot?
Based on what I knew, yes.
And as it related to the chest wound, what did you base that on?
Well, whenever we have a homicide investigation, one of our detectives will go to the medical examiner's office for the examination and obtain a preliminary finding. We don't actually receive the medical examiner's report for several months to maybe even a year in some cases.
You're aware that the medical examiner's finding here was that he was shot from the front.
Hearsay.
Sustained.
As it related to the wound to the leg, Detective Warren, what was the basis for your conclusion?
I'm sorry.
As it related to the wound to Douglas Benefield's leg, what was the basis for your conclusion?
It appeared that he was shot from the right side of his body.
Can we agree that you got both of those wrong?
I wouldn't say so, but I'm not a doctor. I would ask the doctor.
Okay, so it's your position as you sit here today that Mr. Benefield was not shot from the front?
That's not the way that it appeared when we did our preliminary investigation with the medical examiner and then later on.
And it's your position today as you sit here that
Objection, Judge, can we approach?
And what he just wanted him to say is, yeah, I based my arrest warrant on something misleading,
Yeah.
but we know the ME testified from the front, from the side front. Yes, and the picture showed more like in the side, but he showed us round the nipple and to the back. It's, I don't know. It's,
I know. And he was the one that said he believes homicide and murder are the same thing or something like that,
yeah.
I think. And he was like going on about that too. So
It's,
does it really matter to you? Because I don't feel like it really matters to me.
we would die if we did a sidebar drinking game. Why call this guy? Because Mr. Defense believes it's important that he testified that he wrote a search warrant that might have been biased. That he claimed that it wasn't self-defense in the arrest warrant, but it doesn't matter because the jury it won't change his mind. He believed at that time that she did it illegally. Again, you should have ended Friday. No, it makes absolutely no. Even if you came in and said, "Yeah, Jesus, was I wrong?" The impact was 3 centimeters further to the front, but I still don't think she was allowed to do it. Then you lose this one. Then he would say objection, speculation, or legal conclusion. Again, Father Time, I don't understand your trial strategy.
No. I do not.
Well, the ME said it could have maybe be possible the way they describe it. I don't know. I haven't unalived people in a long time. If I knew what Father Time was going for, I would tell you, but I just don't understand. Skal du op og snakke? Vil du op og snakke? Nej.
All right, members of the jury, I'm going to need a couple extra minutes to handle this one. If I could ask you to step out, close up your notes, step back in the jury room. We'll get you back as soon as we can. Remember, don't begin deliberations, talk to anybody about the case, or do any research on the people, places, things, or legal topics you've heard anything about. Thank you.
Tim, why do you always choose these trials?
I don't know.
We're going to need to address some legal matters about your testimony, so I'm going to ask you to step out into the hallway. The rule of sequestration has been invoked, so you're not to discuss questions asked of you or your testimony with anyone. You're not to talk with other witnesses about their testimony, the questions asked of them. You're not supposed to do any research about the case or watch anything.
Yes, sir.
All right, the witness is out. So as I understand it, there's going to be several areas of cross-examination regarding Detective Warren. And the state has objected on the longstanding doctrine that you can't call a witness solely to impeach that witness. So that's where we're at. And the line of question where we stopped was going to involve statements made by the detective in his probable cause affidavit or arrest affidavit. All right, so these issues were addressed, and I seem to recall that I allowed these at the stand your ground hearing, and this may have been the footnote where I said rulings at trial may be different. And there's also been a pretrial motion regarding impeachment of Detective Warren and what is relevant and material and admissible. And I said, I believe my ruling was that it would have to be shown at the time of the cross or the direct and the attempted impeachment to show that those criteria are met. So, State, what else did you want to put on the record?
Judge, only that this keeps happening, and we did hours of litigation about these issues so we would not have this problem in the middle of trial. Now, almost every sentence that comes out of Mr. Taylor's mouth, I have to object because he is not following your rules or the rules of evidence. So I would ask that we try to get this ironed out now so we don't have to call the witness back and I have to object 5 more times. He has clearly only called this witness for impeachment purposes. That is the A#1 first objection that I have.
Sure.
All right, I called this witness to establish substantive evidence. I asked him, what does being the lead detective on a case mean? Is that the one who has the most knowledge of the case? Do you develop a theory of the case? He resisted that. I impeached him with a prior acknowledgement. He then also said and confirmed that he would want his investigation to be objective, fair, with conclusions supported by evidence, not speculation, and that it's not something that you would jump to conclusions on. Now, that is my substantive evidence predicate. And based on that alone, if nothing else, I am now allowed to argue to the jury, don't you think it's strange that the lead detective on a homicide case would not be called as a witness on behalf of the state? So that's my substantive position. Along the way, I should be also likewise entitled to impeach him. For example, he has testified that you would not want to jump to conclusions on a murder case. You'd want it to be objective, fair, conclusions supported by evidence, not speculation. All right, fine. Is it not true that within an hour and a half of this shooting, you referred to this as murder? I then want to ask him, do you believe all homicides are murders? If he says yes, good. If he says no, then I plan to impeach him because he made that statement in his deposition. I then want to ask him, and do you believe that all people who kill are murderers? If he says yes, fine. If he denies it, then I plan to impeach him because he made that statement in his deposition. I don't see why.
I think every courtroom should have a super chat shock collar. I know certain sites have. Don't talk about that now. And if you reach the threshold, you can shock either side. Just make it entertaining, and it could help pay for the audio equipment.
That is not fair game, respectfully. The only other question I had of him was he had authored a supplemental report on November 16th of 20. And in that supplemental report, there is a provision on the report for bias, referring to the subject, Ashley Benefield, and he checked the box, or either checked the box or wrote in no bias. I plan to ask him about that.
What report is that?
That is a report that he authored, a supplemental on November 16th of 2020, and referring to Ashley Benefield as it relates to the victim, Douglas Benefield. He wrote or checked the box that says no bias.
What are the other options?
But the other options are hate, spite, ill will. And
on that form?
No, the form is, it's an open form. It's for him to put it in there. Here, I'll show the court the form.
It's because they're talking about the witness. He's not in the courtroom while they talk about him.
Which?
But if
It
it's
says bias motivation, he types in none, no bias. The next block says bias target, it's blank, and the box after that says bias circumstances. That too is left blank. Want me to show you?
First, I don't think I filled that out.
Now, I will tell the court in deposition, Detective Warren questioned whether or not he had filled that form out, despite the fact that it's got his name typed on it. That's going to be a question of fact for the jurors. It goes to its credibility, not its admissibility, respectfully.
Thank you, Special K. And thank you for being here watching my coverage.
All right, the line, thank you. The line of questioning that you seem to be starting
You did
with
testify.
was the line of questioning at the stand your ground hearing where a narrative was established. And then I believe it was shared with the state, and then there were some amendments, and then it was shared with the state, and then there were some amendments, I think, to final form.
All I proposed to ask him here was, did you write a witness, hit Ms. Benefield with a box? And I want to ask him if he knew who that witness was. And he's going to tell me it was Doug Benefield. And I'm going to ask him why he didn't say that. Give us a reason why you would not have disclosed that rather than put a witness.
Judge, I feel like we litigated all of this. And this was supposed to be shown to the court outside of the presence of the jury so you could make a predetermination before the jury came out. I would like to know the relevance of what is in his arrest affidavit. He cannot call a witness to the stand and say, do you do a thorough and fair investigation just so he can impeach him with this stuff that he's trying to get in. He calls him and says these questions and calls them substantive evidence. It's not substantive evidence. It is setting him up so he can get in all of these items that he thinks are impeachment. We have gone over this before, that what is in this arrest affidavit is irrelevant. What the judge signed the arrest affidavit. You said in your pretrial order that the use of the word murder versus homicide, my motion was granted unless this defendant can establish to the court why this is relevant. And the defense did not say anything different than what they said before when we argued this. Also, any edits of a warrant or search warrant or anything in the warrant, same thing. So I really don't understand why we're back here arguing this again. The arguments are exactly the same. He calls this witness, asks a few questions to set up impeachment. It is disingenuous to say that this witness is called for anything substantive other than attacking his credibility. He was never a witness. Why is he attacking the credibility of a witness that never testified?
So as I understood the court's ruling, until such time as I could demonstrate the relevance of it, it was not admissible. I think the relevance of the lead detective believing that all homicides are murders is overwhelmingly relevant.
Please explain. I understand, and you said that multiple times in multiple hearings. Relevant to prove what?
Bias. This guy executes a search warrant within 45 minutes of the shooting, referring to it not as a homicide, but as a murder. We've already had testimony from at least two deputies, and in particular, I'll remind the court of Lieutenant, I believe it was Dickens. Who? Dickerman. Who testified that not all homicides are murders, that the reason you have to take time to investigate a homicide is to determine whether or not there has been criminality. So here's the lead detective who initiates the theory of the case. Within 45 minutes, he's calling it a murder rather than a homicide. And he makes the statement that all homicides are murders and anybody who kills is a murderer. And the court is going to instruct the jurors.
I believe that the medical examiner said that all non-natural unalivings are homicide in their perception. What the hell is she eating now? I'll be on Molly Patrol.
If you feel her action was justified, then she's not guilty, because not all homicides are crimes. How could that not be relevant?
This witness never testified.
Any further thoughts?
No.
All right. Yeah, these we've already covered this ground. So it answered a question just a moment ago about what was the purpose for calling this witness, and the law is very clear. And I think both sides know this area of the law. You cannot call a witness solely to impeach that witness. Asking if that person is the lead detective, is it important to be fair and objective? Is it important to rely on facts? Is it important not to engage in speculation or jump to conclusions? Those are not substantive questions regarding the investigation. Those are just general questions to someone about being objective and fair. In this particular situation, and I'm skipping over the part about any argument about the state not calling the lead detective in a case. I'll leave that to whenever it's presented. I think we all know the law on that as well. But the answer I got is, what is the relevance of him referring to, in a search warrant within an hour and a half, a murder? What's the relevance of his opinion? This is an opinion. Are all homicides murders? That's an opinion. It doesn't matter what he thinks. If he thinks that all homicides are murders or all murders are homicides, or there's some mix of the two of them, that's a jury question that the jury is going to have to answer. I can't think of any witness I would let speculate or testify as to whether this case is a homicide or a justifiable homicide or an excusable homicide. That's the province of the jury.
Judge, can I ask?
I tried to give both sides as much time as they wanted to put information on the record. The question, are all people who kill murderers? Again, what I'm asking is, what's the relevance of that to show his bias? There hasn't been anything established that he was particularly.
I must have made a boo-boo. I thought he had testified, but I think that was in the
It was in
stand your
the,
ground hearing.
yeah, yes.
Particularly
That's where
biased
he
in any
testified.
way, or how that would be relevant to this particular case when it's an opinion whether people are kill or murderers. That's going to be a jury question to decide whether the state has proven beyond a reasonable doubt its allegations of murder in the second degree with a firearm, or if the facts and evidence support a lesser included offense, or if the state has not met its burden and the defendant is not guilty, whether they haven't met their burden or because the jury believes and finds that the defendant has acted in lawful self-defense. The other issue about the statements made in the probable cause affidavit, it's my understanding that's going to be asked is, did you know who that witness is? And again, I'm struggling to understand how that is relevant into any particular issues in this case.
How about this, Your Honor? Does the court think if, as the lead homicide detective, Justin Warren would have said,
No, it's a stand your ground
I'm
hearing.
not going to seek a search warrant because I think Ashley Benefield was abused and I think her actions were justified. That would be his opinion. But if that was his opinion, she might not be sitting there right now. That's why I think it's relevant. He initiated the prosecution. And you were hearing from somebody who initiated the prosecution who is overwhelmingly biased. He acted impetuously. He acted without evidence. He got both of the entry wounds wrong. He completely speculated that Mr. Benefield was not facing her when she was shot. Their own medical examiner said he was facing her.
State, anything else?
No, Judge.
Mr. Taylor, I am certainly giving you as much room as I can to cross and impeach on relevant and material issues. But from what I've heard so far, and I will just say that the impeachment from earlier regarding theory of the case, that was not materially different. But so far, the questions you have asked and the questions that I've heard you represent to me and issues that you intend to represent and question this witness on are all impeachment issues.
All right, I have two questions remaining. Will the court allow me to ask them? One question is, I want to ask him if he spoke with the medical examiner before he submitted the arrest warrant. And the last question is, did you fill out this supplemental report and indicate no bias? That's it. Then the only thing left is I want to show him the DNA report and have him read the section that's applicable. We gave them business records notice.
I have,
Well, hold on.
okay.
The two questions that have been stated at this point, the two questions, just to try and get objections out of the way and get them ruled on so we can get this going, is one, two is this supplemental report, nothing regarding bias. And the first thing again?
And the first one was, did you speak with the medical examiner before you submitted the arrest warrant? I think he's already testified to
I
that.
think he did.
None of it is relevant, Judge.
All right.
And I will be asking for a curative instruction depending on the court's ruling.
All right. And then you wanted to show him
The DNA,
DNA report.
yeah, he submitted the exemplars and he got the report back.
All right. I don't know if I've seen that.
You may not have. We'll be happy to show it to you if you like.
But what is the relevance of showing a detective a DNA?
Hold on. Yeah. Plus it's a report. It's not been authenticated.
We gave them the notice of the business record. They did not file an objection to it. And it shows that the court may recall crime scene swab, both of Miss Benefield's hands and wrists and forearms. And the DNA came back as Douglas Benefield was one of 3 potential contributors out of 740 million or whatever the figure is. And the court may recall Ms. Benefield testified on the stand that she attempted to flee the house. Mr. Benefield ran after her, grabbed her, spun her around, and blocked the door so she couldn't get out.
Yeah, but it's, okay, go ahead.
My objections are not to the business record certification, Judge. My objection is the contents of the report have not, they're
Gil, no. The only thing that's been interesting all day was that guy who did the report on them, testifying that Doug was an alpha male, kind of possessive, and in his opinion. And she was just stringing him along, and he didn't care for his kid because he didn't go out and check on her for an hour or something like that. It was something stupid. And then another guy just rambling along for 2 hours. And then sidebar.
There has not been a foundation laid to make that report relevant. There has not been a witness that testified that swabs were taken and then turned over. There's not a witness that said, I'm speaking. There's not a witness who says that those swabs were taken from Ashley Benefield and then those swabs were sent to DNA labs. So anything contained in that report that says there's DNA from Doug Benefield or Ashley Benefield is hearsay. There is not a person at DNA labs that can say where those swabs came from. They all they know is they got them from the sheriff's office and somebody told them where they came from. And I think that the probative value is outweighed by the prejudice because it's going to confuse the jury. It's a packet with bench notes and the report. And the report, there's no witness here to testify to explain a very complicated report. This isn't, even ballistics is somewhat simple. This is DNA. It's extremely complicated. And I think that the danger is that it will confuse the jury and that the proper foundation has not been laid. So my objections are not to the business records, which is why we did not file an objection. It is to the contents being hearsay. There's an insufficient foundation to enter this and that there's a unfair prejudice.
I'm quite comfortable relying on the court's notes, and if the court checks its notes under Megan Dorvac, the court will see that Megan Dorvac testified after being called by the state that she swabbed at the sheriff's office that evening Ashley Benefield's hands, arms, and forearms for DNA evidence. And I even specifically asked her if the purpose of that was to be able to determine who may have touched her on that occasion. She agreed. Now, Warren submitted those DNA samples to the lab. The lab returned those DNA samples to Warren. Now, I'm going to ask him what the result was. And I have the DNA report for the court if it would like to see it along with the business certification records of the custodian.
I've seen plenty of them. All right, anything else?
No, Judge, that's not how any of this works. There's been no swabs. There was no witness that said, these are the swabs I took from Ashley Benefield. There's been no witness that said, these are the same swabs that were sent to DNA labs. There's been no witness that said, those are the swabs I received. There's been no establishment that anything in that report is related to this case based on anything other than hearsay, which, I'm sorry, Judge, I already said all those things, but it's just frustrating because they're all the steps to get that reported under certified business records have been skipped. And so although I don't object to that portion of it, it's the contents being.
There's a sidebar because they want to ask the lead investigator about DNA evidence that they haven't laid the foundation for.
Yeah.
Who is Jamie is not the right question. The right question is, why is Jamie? Jamie is my good luck charm.
Hearsay and improper.
As the proponent, I'll give you the final word, and I need to make a ruling.
Well, just say the state never filed any objection. We gave them notice plenty of time.
Yeah, this is a really easy call. That lab report is not admissible. You could call the DNA analyst who could come in under 9702 and establish the foundation and the bases to admit DNA evidence after the chain of custody has been established. There's been no evidence. I haven't heard anything at all about the I heard about swabs. I don't recall seeing the swabs. I heard about swabbing being done, but then the chain of custody, getting them to whatever lab did the testing to ensure the integrity of the evidence. Then at the lab, what are the testing processes, procedures, known error rates, all of the foundations you would need under 90.702 and 703, 704, 705 about how this all happens. And then, of course, we need the analyst to explain what these results are. So that lab report doesn't come in. In addition, it's prepared in anticipation of litigation. I mean, that's the whole reason it's done. So that one, that was an easy one. That is going to be prohibited, crossing Warren on the DNA report. The other two, though, the state objects. I think it's fair to ask Detective Warren if he spoke with the medical examiner before he sought an arrest warrant. And you can ask him, I think, if that's his supplemental report. I think it's close, but I'll let you ask him, here in this box regarding bias, nothing is there. But out of everything I've heard, those are the only two questions that I think are relevant and material and appropriate of everything we've talked about and aren't solely to impeach. So,
yes.
All right,
And Judge, I would just ask to establish the without bias part without speaking it out loud to the jury first.
I don't understand what that means.
He's leading this witness and speaking what's on the report before the witness even says he wrote it or anything. So
Right.
I would
So
prefer that he not.
establish if it's his report. Establish that down on right here. There's a box that says a bias. What does that mean to you? And he left it blank. And is there anything in particular that why he did that? But that's the extent of what I've heard relevant. So let's bring it back in.
Oh, Jamie, this is worse than I thought it would be.
Father time exhausts me, and the
Yeah.
prosecution exhausts me. It's just so much.
All right, sir. Did you speak with anybody about your testimony or anybody approached you speaking to you about the witnesses about their testimony? No question asked of them?
No, sir.
Any research on the case about you at all?
No, sir.
Put it in the room.
Sorry, okay, welcome back, everybody. Did you begin delivering amongst yourselves? Talk to anybody outside the about the case. We're doing research on people, places, things, or so recess notes, maybe you let you can.
Thank you, Detective Warren. Did you speak with the medical examiner yourself before you submitted your arrest warrant in this case?
Well, like I said earlier, we have a detective that will go to the scene or to the medical examiner's office to get the preliminary findings.
Let me repeat my question, Detective. Did you personally speak with the medical examiner before you submitted your arrest warrant in this case?
Not that I can recall.
Oh. What are we doing? Come on.
All right, let me pass this to you and see if this refreshes your recollection.
Sure. Okay. Yes, sir. Yeah, so I spoke to him on October 29th in reference to stippling.
You documented in your report, did you not?
Yes, sir.
All right, my last question, Detective. Do you recall filling out a supplemental report on November 16th of 2020?
I filled out a lot of reports, sir. May I look at it just to verify? Okay.
Is that your report?
It appears to be. Yes, sir.
All right, can you tell us the date of the report?
November 16th at 15:10 hours.
November 16th of 2020?
Yes, sir.
All right. Let me ask you if there is a provision in this report for you to note whether or not any bias or motivation is demonstrated by the offender towards the victim.
It's a program that's got a lot of different stuff, so there could be possibly, sure.
All right, let me ask you this. Under bias and motivation,
okay,
did you put in none?
Well, it would have just been not filled out. It auto-populates. Like I said, it's a program, and I'm not a programmer, so I apologize.
So if you had been aware of bias on behalf of Ashley Benefield towards Doug Benefield, such as ill will, spite, evil intent, things of that nature, you would have noted it, would you not?
Honestly, it probably would have been just documented in the report.
No further questions.
Oh my God, that was so pointless.
Sit down, Cross.
This section that says bias, isn't this for hate crimes?
Yes, ma'am. When we fill out certain areas for certain crimes, it's required for statistical reporting and things, and a lot of things that I'm not even aware of. I don't typically pay attention to that box. Okay. But
so this box is for those kind of statistics, not for any kind of bias that may be going on in this case.
Correct.
Thank you.
Redirect.
Well, are you redirecting? Come on.
Do you think it odd that you're the lead detective in this case and
Objection
you weren't called
beyond
by
the
the
scope.
state?
Sustained.
That's such a silly. You know you can't ask that.
He knows he can't do that.
Can this witness be released?
Yes.
No.
You remain under subpoena, sir. The instructions.
No?
do I need to stay in the building, or can I leave?
No, sir, you can go, but you need to be available in case somebody calls you.
Yes, sir. They have my email. Thank you.
Call your next witness.
Try to come back to it. We call Dr. We call Michael Hay.
raise your right hand as well.
You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
I do. Thanks, sir.
Yes, sir.
Appreciate it.
My name is Judge White, presiding. Make yourself comfortable in that chair. Get about 12 or 15 inches from that microphone. You're just up, down, left, right. There you go. And just speaking a loud, clear voice, it'll pick up everything.
Thanks, sir.
Good afternoon. Will you tell us your full name, spell your last name?
My name is Michael Haag, Haag.
What type of work do you do, Mr. Haag?
I'm involved in forensics. Specifically, a typical job title would be forensic scientist.
Let's talk about your educational background. Where'd you go to school?
My formal education is as a chemist. I have a bachelor's of science degree in chemistry from the University of Arizona in Tucson with a math physics minor.
When you speak of forensics, what are we referring to?
Forensics in the broad scope simply means the junction or the joining of science and the law. So it's where somebody who is particularly interested in or has been trained to examine physical evidence brings findings or an interpretation of that physical evidence into the courtroom.
Could you describe your forensic career history for us?
My background and training is fairly unique in that I grew up in this field. My dad, Luke Haag, also does this kind of work. So even in grade school, I'd go out and assist him with both casework and research, and I got the bug. So after I went to college and got my degree, I went and worked for a private consulting firm that he ran for about 2 years or so, followed by an application and employment with the Albuquerque Police Department Crime Laboratory, starting in about 1998. With APD, I worked for about 25 years and got to the retirement point and was able to retire. But during that same time frame, I also ran my own private company, specializing in my sort of primary area of interest in forensics, which is shooting incident reconstruction. The study of the physical evidence relating to shootings, the interpretation of that physical evidence, and the reporting on it, of course. With the Police Department Crime Laboratory, I wore quite a few hats. Primarily, I worked as a firearm and tool mark examiner, which someone in that role particularly focuses on the physical evidence relating to those things. But I also worked in drug chemistry as well as blood and breath alcohol, and was a supervisor of those units for about 12 years as well.
Any additional training and or classes that you have taken in order to be skilled at your job?
The list is fairly long. Honestly, I don't remember everything that I list on my CV. But as far as training and expertise, I've been trained and taken classes from everything from the FBI at Quantico to doing cross trainings with the San Diego Police Department, in-house training with the Albuquerque Police Department. I regularly attend conferences and seminars. I worked for the German Bundeskriminalamt. If you spell it, Bundeskriminalamt, which is
That's their state police.
like their FBI. So I interned with them for a while before I came to the Albuquerque Crime Laboratory, and a wide variety of other trainings I received over the almost 30 years now.
Are you a member of any professional organizations having to do with your specialty?
I am. The ones that are particularly relevant to what I do would be the Association of Firearm and Tool Mark Examiners, or AFTE, the American Academy of Forensic Sciences. EMFC is one that I've been a member of for about 2 or 3 years. That's the European Network of Forensic Science Institutes. They actually have some very, very interesting perspectives on forensics, among others, including the Association for Crime Scene Reconstruction. But that's another bug I got from my dad, is being very active in the field, seeing how other units do things, as well as participating in those conferences.
Have you authored or published any scientific papers?
Quite a few. Another bug I got from my dad. I publish very regularly in scientifically peer-reviewed journals, such as the Journal of Forensic Sciences, the Association of Firearm and Tool Mark Examiners Journal, amongst others.
Written any textbooks?
Luke, my dad, and I wrote a textbook, one of the few on shooting incident reconstruction. It's in its 3rd edition now. And I'm also the author of a chapter in the Encyclopedia of Forensic Sciences on shooting incident reconstruction.
And how about, Mr. Haig, any forensic presentations of note?
I very regularly present both at conferences as well as for organizations on this area of work.
Can you tell us what certifications are offered in the area of firearms identification and comparison work?
The primary certifications, which certification applies to an individual and accreditation applies to a laboratory. So those are terms you'll often hear mixed, but certifications.
No, there was a high likelihood that they would be resting today, was what he said.
Available and that are relevant to what I do include 3 from the Association of Firearm and Toolmark Examiners, 1 in gunshot residue and distance determination, 1 in firearm identification, that's the examination of microscopic tool marks.
I believe he mentioned that she had his DNA on her wrist. Hvad så, lille skat? Pew pew. Hvad er der? Sorry, my sweetheart needs my attention. I'll be right back.
As well as tool mark identification, the examination of microscopic tool marks from other things besides guns, like screwdrivers and hammers and things like that. And then when the International Association for Identification had a certification, they've discontinued it, for crime scene reconstruction as a whole, I applied for and took that. All these tests involve both the knowledge test as well as a practical examination. And the AFTI ones, which are still active, of course, require recurrent training and testing.
Have you been recognized and testified as an expert before in a court of law?
I have.
Approximately how many times?
At last count, I think I'm getting close to 100.
And where have you so testified?
Primarily in the area where I worked for most of my 30 years in New Mexico, in Albuquerque. But in addition to that, all across the country, to include states like California and Texas and Rhode Island. And I'm not sure if I've been to Florida before, but many, many states across the country, and courts ranging from district or regional courts, state courts, to federal courts and military court martials.
Mr. Haig, have you given your opinions in high-profile cases before?
I have.
Give us an example.
The cases that come to mind would be Aaron Hernandez in Boston. That was a high-profile homicide trial. I've been involved in the examination of physical evidence in places like Taiwan, even for presidential assassination attempts. I worked cases from Iraq and many other places that I lose track of.
Are you an instructor in any areas of forensics?
I am.
You've written on the subject as well?
I have.
And you provide regular training in shooting reconstruction?
One of the areas that I actually gain a lot of pleasure from is instruction in shooting incident reconstruction. So this is the examination, as I said, an evaluation of any physical evidence when a shooting takes place. That can involve the crime scene itself. It could involve trajectories. It can involve a wide variety of things within that sort of umbrella title. But I've taught a shooting incident reconstruction course for almost the entire last 25, 26 years of my career. They're week-long live fire shooting courses. So this isn't just a thought process. I go out and shoot things so that people that do what I do, crime scene investigators, forensic scientists, even pathologists, can come and see how these shootings take place and understand what they're looking at when they go into a scene. So I do that very regularly, especially now that I'm retired. I'm able to do about 4 to 8 of those a year, it seems like.
Is the assessment of bullet trajectories taught in your SIR courses?
It is.
Can you describe for us what a 3D laser scanner is?
This is a tool that I actually feel very lucky to have helped brought into the crime scene realm. It's an engineering tool, technically. But if you think of a laser rangefinder, a very simple one that you might aim at something, push the button, it shoots out a bullet of light. Light travels at a very consistent speed. So when that light is reflected back to the sensor, time is measured, and we then can calculate a distance because of that time and the known speed of the light. That's one bullet of light. A 3D laser scanner is an engineering tool that sits on a tripod and has such a thing inside of it, but spins in a 360-degree azimuth, left and right, and also is able to shoot out the laser beam in a vertical path as well. So imagine in this room shooting out millions of bullets of light and collecting individual data points on a very accurate scale, and then blending all those individual data points together. You get a representation of reality. You get a computer takeaway of your scene. And then you move that system from one place to the next. So you can move around corners, and you can blend all of these data sets together so that you really take the crime scene with you. So I was lucky enough with my police department to help start this theft of this technology into crime scene back in about 2005. And since then, many departments have also seen the value of it, particularly with trajectories, in my opinion. And it's become a very common tool across the country and internationally as well for crime scene investigation and shooting reconstruction.
Mr. Hay, can you define for us what exactly a trajectory is?
When I'm describing a trajectory, I like to think of it or describe it or liken it to a snapshot in time. If you imagine yourself in a dark room, completely dark, and things are moving, and you set off a strobe from a camera, let's say 3 times in that dark room while things are moving around, then you've really frozen things in place for that brief instant while the strobe was going off, or in our case, when a shot is going off, because bullets move to our perception of reality in a very fast manner, of course. And so if a bullet, say, goes through something and then strikes something else, it can help us orient those objects that are struck, and indeed then where the firearm is as well. So snapshot in time is how I tend to think of it, but it's a way of understanding where things were, including potentially the firearm itself, as well as objects that are struck.
All right, so you come upon an investigation, if you will, of a shooting incident, and you reconstruct it, correct?
I try to.
All right, now would you tell us the significance, the importance of trajectory as it relates to that reconstruction?
In forensic science, you in very many ways have to throw out what you may have seen with regard to TV. Most of the things that TV puts out are completely false. But the beauty or interesting thing about trajectories with regard to shooting scenes is that fact that it gives us a way of assessing where things were in those moments of time. A person in my role may not be able to say exactly what happened in between them sometimes. Sometimes there's a logical progression of what might have happened given the physical evidence that we do have. But in my job, I basically lay the pieces of the puzzle on the table, meaning what physical evidence I have to look at from a shooting scene. And that could be the projectiles, the cartridge casings, the firearm itself, or trajectories, the room, and then try and see what snapshots in time we may have available to rebuild.
Is there a distinction between what you've been referring to as trajectory and wound path?
Wound path is sort of a subset of trajectory. Wound path refers to, indeed, just that, the path the bullet took or created when it goes through a body part in specific, or a body. But in each case, the accuracy and the meaning of those trajectories can be evaluated, because bullets, for the most part, there are exceptions, tend to travel in more or less straight paths. Like I said, there are absolutely exceptions to that, particularly with, we're not dealing with, in this case, non-expanding rifle bullets. But we look at these paths as relatively linear. Every measurement taken by human beings is an approximation, though. So an understanding of how much accuracy to place on those measurements and that documentation is absolutely, of course, important as well. With trajectories into things like walls, when I have good points to work with, or data from somebody's scan of a trajectory rod in place, for example, typically about plus or minus 5 degrees is what I've found from my work, and what I would call a industry standard in my work around a measured trajectory, around a straight line, if you will, that was created by something like a trajectory rod. With wound paths, it can be a little more difficult, and this is something I've lectured on to not only the pathologists in my area, who I worked closely and well with and helped train when they'd come in as fellows, and then I've lectured on at the Swiss Wound Ballistics Workshop 2 years ago, I think, and was asked to lecture on, is the idea that not only are trajectories in bodies a little bit more inaccurate because the way they're measured and how bodies move, we're not walls, we're not rigid. So we have to indeed look at those as a little bit more of an approximation. But for the most part, with things like we're looking at here, expanding handgun bullets, that category, we can describe them or think of them as relatively straight lines as documented. They give us an idea of where a firearm may have been at the time a shot was fired based on that path. So wound ballistics is a subset of just trajectory. They're related.
You may have alluded to this. If you did, my apologies. What is the degree of accuracy of trajectory reconstruction?
With regard to common things that I typically deal with in crime scenes, like walls, sheet metal in cars, desks, almost anything you can think of, I shoot in my classes to demonstrate this and basically check ourselves and see how accurate we are. About plus or minus 5 degrees with in crime scenes, like walls, sheet metal in cars, desks, almost anything you can think of. I shoot in my classes to demonstrate this and basically check ourselves and see how accurate we are. About plus or minus 5 degrees. So I'm motioning with my hands to make sort of an arc. So if my primary line of measurement, we're going right down the center of my wedge here, I'm making a visual representation of approximately plus and minus 5 degrees, a 10-degree cone overall if you rotate that into 3 dimensions. But I think I can show you that later.
What steps did you take in preparation for your testimony here today?
When I do a case review such as this, there are materials that I typically would like to see in order to help inform myself on what evidence, what pieces of that puzzle are on the table to include, particularly documents, things like crime scene images, autopsy reports, lab reports, all the documentation that goes around a typical investigation, as well as 3D laser scan data, if it's available, amongst other things.
And in this case, did you examine all the evidence that was available to you?
I actually forgot to mention that. In addition to that, in this case, I did examine the actual physical evidence, meaning the projectiles, cartridge casings, etc.
And when you say projectiles, we're referring to the bullets?
Correct.
All right. And this information that was provided to you by the county, correct? By the sheriff's office crime scene?
Which information were you talking about?
That you were able to review in preparation for your testimony here today.
I think technically I received it through you, with the exception of the 3D laser scan data, meaning the documentation, the crime scene of photographs and autopsy reports.
Do you recall whether or not you actually came to the sheriff's office to do a review of the evidence?
Absolutely.
All right. Let me ask you, with that preface, to tell us, please, about the projectiles in this case.
The examination of the projectiles helped me understand in a way where they'd been. This is sort of one of my main areas of interest, is the damage to projectiles. Sometimes, depending on their condition, when they finally come to rest, can tell us something about where they've been and what they've hit, especially if we're dealing with particular types of projectiles, such as we're dealing with in this case, which are expanding handgun bullets. This basically means that we're dealing with a construction that is designed to change shape if that projectile strikes something that is liquidy, and we are mostly liquid, so that would include tissue. A hollow point projectile is typically designed such that it has an external jacket made of copper. So my hands here are representing copper, and then that goes around it in 360-degree rotation. So in this demonstration, my finger's pointing up. That's the way the bullet would travel. A hollow point projectile has just indeed that, a hollow point cavity in the nose of the bullet. And it is designed that way such that if it's traveling stably, nose forward, and that hollow point cavity encounters something liquid, could be a gallon of milk sitting on a countertop, doesn't matter, or tissue. The liquid actually goes into that hollow point cavity, and because the bullet is traveling forward, you build up hydraulic pressure, liquid pressure, just like the brake lines in your car, inside that hollow point cavity. And so pressure inside that hollow point pushes the sides of the bullet open, and it comes open like this. So if I take my hands and make the model bigger for you, the jacketing material, the copper jacketing material that's facing forward as the bullet travels, when it encounters something liquid and expands, some people like the term mushroom, I don't prefer that term, but when it expands or encounters soft damage, the pressure builds up, and so that jacketing that was facing forward actually peels backwards, down and around, but it leaves you with a forward-facing area of the projectile that's greater than the original caliber. In mushrooms, you get greater surface area presented to the way it's going. And when you do that, you increase drag. And when you increase drag, you decelerate or slow that bullet down more quickly. And so these bullets undergo, or created through intense engineering by people at the companies such that they go a preferred depth in tissue or tissue simulant. So the main reason for hollow points in handgun in particular, whether that's somebody in law enforcement or somebody interested in protecting themselves, as opposed to going to say the range, would be to control penetration depth. So this bullet will stay in one body and you don't over penetrate and go through further. When I work cases that have non-expanding bullets, often called full metal jackets, typically you can see over penetration. You can go clean through one person and on into another. So that's the hollow point cavity mechanism.
Where were the bullets in this case, Mr. Haig, recovered?
From my review, there were 4 fired cartridge casings and 4 projectiles and 1 small lead fragment that were recovered. And we can kind of go through these because this brings into play a term called the limited universe, meaning we limit our options. We take pieces of that puzzle off the table and put them in their place. So for example, 1 bullet was recovered at autopsy. The entrance gunshot wound was listed as over here on the right chest, as I recall, and the bullet was recovered in the back of the decedent. That bullet, in my examination, shows soft damage, expansion, just as I would expect from bullets of this type. That bullet's wound path in the torso is well documented, and so we can kind of take 1 of 4 off the table in that the entrance hole, primarily for me in the shirt, is a nice round hole indicating that it was not unstable tumbling before it got there. This is basically a nice stable bullet entry, and that bullet was recovered there. So that's 1 of 4. Another bullet was recovered after going through one of the walls of the bedroom and through several cabinets into a bathroom area. And under examination, when I looked at that bullet, it initially looked mushroomed, which is why I'm not a fan of that term, because it had the visual appearance of it, but it was just deformed. Instead of the jacketing material unfolding as I described before, how bullets do in tissue, it was just collapsed. So if you see pictures of this bullet, which as I recall, this is bullet number 11 in the crime scene images, I believe. While it looks fairly mushroomed, it does not demonstrate soft damage. And the hole going into the bedroom wall is again a nice round hole, indicating that that bullet was stable when it struck the wall, had not struck something else first. So that's 2 of our 4 bullets that are sort of off the table, and we kind of know somewhat what their story is. A third bullet was recovered down a hallway from the bedroom and in a wall. And other crime scene images indicate that it had gone through things like a book, I believe a part of a mattress, and maybe a book holder before it got to the wall where it was recovered. Examination of this bullet was very interesting in that it shows no signs of any sort of soft damage or even mushrooming in the nose. The nose is in its basically initial condition, but it has a very classic and typical characteristic to it that I demonstrate in my recon class when I ricochet bullets off materials at shallow angles. So when I say ricochet, I mean the bullet came in at a shallow angle and continued on along its path. It's a flat spot on the ogive is the part of the bullet we're going to talk about. It's the rounded part from the nose down towards what's called the bearing surface or the cylindrical portion of the bullet. So it's a big flat spot because things like tile, what we describe as unyielding surfaces, meaning they don't give, the bullet takes up the damage, create those flat spots. In addition to that, when you look at the flat spot, you see scratches or stria on it from dynamic interaction with the surface. And those lines go straight from the nose to the base. That tells me this bullet, when it struck tile, is the likely thing in this scenario, the floor, it was stable. It was going nose first to get that flat spot and be scratched.
Probably to tell that the trajectory of the bullets is consistent with self-defense.
Maybe.
Why are we talking about a hard surface in a hallway? We just need to know, was she scared when she pulled the trigger? I'm not sure this guy can tell me. Jesus.
Maybe where he was
Directly from the nose
standing.
to the base, it then continued on downrange and was stuck in the
Yeah,
wall.
maybe to tell us if she
that
was
bullet
down,
gives us some idea of some trajectory, even though it's stuck in a wall, just barely. You can, in the crime scene, you just see it stuck in the soft drywall, because It's downrange from the bedroom where all of the fired cartridge casings, biological matter on the floor is, but that hallway gives us sort of a path, a trough that the bullet had to have passed through. There were no other documented impact sites in that area, so we have what's called ballistic accessibility. It creates a path into the bedroom area. If we assume that's where the firearm was, which is a logical assumption in my opinion, based on the cartridge casings, the biological material, that doesn't overlap with another trajectory. I'll come back to that in a second. Our fourth bullet is found on the floor in the bedroom, in the middle of the floor. Its position to me does not really mean much because it's laying there just on the floor where it could have been kicked, could have been moved slightly. So we don't know where else it might have struck in that room. But the key thing about this bullet, this is bullet number 5, as I recall, is that it does show soft damage. It is expanded. In the images you would see the jacketing material is peeled directly back and is facing rearward. The damage to this bullet tells me it went through tissue, something soft and liquidy, not things like wood and drywall or glass, but rather tissue. In this case is our limited universe option. So this bullet, number 5, would have had to have gone through the gunshot wound to the leg, which as I recall, enters on the interior left portion of the leg, and exits out to the right side of the leg itself. So those 4 bullets, and each one has a story to tell about what it did or did not strike.
When you speak of tissue, we're speaking about tissue of the human body.
I am.
Okay, just so we're clear. Now, did you bring with you today any slides or any type of diagrams that will assist you in your explanations?
I have 2 things that fit that bill. I have the Manatee County's 3D scan data with trajectories for one shot that I could show, as well as images I took of the 4 projectiles that I just mentioned that would help illustrate my points if you need me to.
All right. Before we get to that, let me just finish up the wound path. I'd like to ask you about the wound path to the shot in the chest. Are you able to say, based upon your training, experience, and education, whether or not that wound, where the shooter was relative to that wound?
Of course, I wasn't there for the autopsy, but experts rely on each other's reports in order to formulate opinions. The entrance is generally on the right, front side of the chest here. The bullets were covered in the back left area. Because bullets of this type, expanding handgun bullets, travel in relatively straight lines when they go into tissue. If you simply extrapolate those lines from the autopsy report, it gives you an idea of where the firearm was. I typically speak in terms of the firearm itself as opposed to a person. Of course, a firearm is just a machine, so it typically has an operator. So how that person is directly placed with the firearm is beyond my physical evidence examination ability. But the firearm, if you put a line straight back from where the bullet entered to where it went, it gives us our best approximation of where then a firearm would have been at the time the shot was fired. Again, that snapshot in time.
Are you able to reach any conclusion with respect to the order of the shots?
There's nothing in this from the physical evidence standpoint that allows me to sequence these shots 1 through 4. If one starts to make assumptions, which some people recoil at the word assumption, as long as you have a legitimate reason for saying the word assumption or are willing to describe its validity, we make assumptions in science all the time. It allows us to make further steps. So for example, we have 2 trajectories through the body. We have 2 trajectories into objects in the crime scene. If I look at the trajectories just within the crime scene, one that has to go through that long hallway and one that we actually do have some data for to figure out where the firearm was that just goes into the wall within the bedroom. And we look at those 2 trajectories, they don't overlap, meaning there's not a physical possibility for the firearm to have been stationary between just those 2 shots. I can't tell you with regard to sequencing which one was first, but if you make an assumption that the firearm, if you're the firearm, I mentioned right to left, moved from right to left, then the one down the hallway would have to have been before the one into the wall, if that's the hypothesis. If we take the opposite hypothesis, it's opposite left to right, that's where witness statements come into play to evaluate whether or not the physical evidence supports or refutes a witness statement. You never take a witness statement, and in my line of work, believe it. You look into what the physical evidence supports and then cross-compare them. So if you have information or an opinion or a statement that the firearm was indeed in motion from right to left, the physical evidence for those 2 trajectories would support that. As far as the body, for me, this case doesn't help too much because I focus more on the scene in this case. Others have focused on the body. But with regard to the scene itself, with the body itself, certainly we have an idea of where the firearm was relative to that body. But because those bullets don't then continue on to hit other things within the scene, I don't particularly have an opinion there that would lead me to allow me to then say sequence those in order.
Do you have an opinion as to whether or not the deceased was stationary or moving?
If we assume that the firearm was relatively stationary, and by that I don't mean a matter of 3 or 4 feet, I mean the firearm is not circling about the room, going out in the hallway of this incident, or otherwise. If we take the position that the firearm is generally just in the bedroom and is pointed in the same relative direction as the 2 trajectories that I've described for you, then it would have to be that the decedent was in motion, because we have trajectories in the decedent's body that are almost opposing. We have one that goes from, as described in the autopsy report, and this is how it's commonly described in such things, front to back, right to left, and as I recall, relatively flat. I think it was maybe slightly downward, but I've forgotten the vertical component. But the key factor is that one goes this way, and as I read the autopsy report, the other gunshot wound enters the inside of the right leg and comes out the exterior outside of the right leg. These are basically 2 relatively opposing trajectories on an object that undeniably, in my work, objects, bodies regularly move in between shots for one reason or another. So given that, to me, those trajectories in the body indicate to me that the body was in motion.
All right, and with respect to the firearm itself, are you able to draw any conclusion whether or not that was in motion as well?
Certainly within the degree I've described before, with the 2 trajectories that I can show you, the one that goes in the wall, for those that I can demonstrate by physical evidence, there was some motion. And as I recall from my measurements in the 3D scan data, it's something like 4 or 5 feet, at least, from one position of one trajectory's area over into the area of the other. As an approximation, again, because again, trajectories are approximations. Otherwise, beyond that, no.
So would it be safe to say that your conclusions support the fact that
Stop showing the
both
family.
the deceased as well as Miss Benefield would have been moving from right to left?
I can't tell you that the firearm moved from right to left of those shots. A statement of such would be supported by those 2 trajectories that I mentioned.
All right, would you please demonstrate for us now from the slides that you brought how you reached the conclusions that you did?
Sure, it'll take me just a minute to set up the laptop.
Yes.
Yes, please, Your Honor.
Oh, fine. Yeah. It's been 84 years.
It has felt like it.
I've been out throwing a ball at Molly, telling her not to bark at birds. I've been sitting here in what I think might be in the Geneva Convention for war gas, because apparently she got mad, so she put herself right next to me and farted. And he's still talking. Yeah, I can do both.
Oh my goodness.
Jesus. I think we need some new feed for you.
Is she tooting over there?
Yeah, normally when a dog toots, it leaves the room. She's just laying right next to me and just...
Of course.
I think it's because I closed the door to to the courts because there was some star rows flying above, chirping, and they weren't allowed to do that.
Please.
He turned into air defense.
What I'm showing you here is the 3D scan data of the scene. So I didn't take this data. This was done by Manatee County investigators. I took the individual scan worlds and then blended them together. This is a process called registration. And I'll move you through it. Hopefully we don't get a jump between my laptop and what we
No, we're getting to the interesting part, so just stay here. He is a forensics expert who will testify about trajectories of the bullets.
see on the screen. So again, this is not a computer game. These are actually millions of individual data points.
Yeah, I'm wondering about wounds, but what does that have to do with ricocheting on hard floors? I just want to see the trajectories.
You can see in some of these places the individual spots. Each one of those is a data point collected by the scanner. And as we look down on the scene here, you're looking at the sort of wood-looking floor. You can see a tape on the floor. And now I'm going to switch perspective such that we're going to slide down to the side to allow you to get a feeling for what we're looking at. So as I move through this, you're now looking towards the doorway, exiting the bedroom, over the top of the room.
Mr. Haig, I'm sorry to interrupt.
Please.
This is the room where the shooting took place.
That's my understanding. There are certainly fired cartridge casings, 4 of them in the room, as well as a bullet hole going into the wall here.
Okay, and that would be the mattress on the right-hand side that was leaning against the wall.
That's correct. Where I'm moving my hand cursor right here in the data is a mattress.
Okay. And are you able to, from that perspective, yet see the entrance to the room?
Yes, I can swing us around so that we look into the room even, if you wish. So as I come down in the data, I can put us in the doorway.
Oh, I like this.
Okay.
So that's a view into the room, and we can then even
Okay,
come into the
that's
room in that manner and pan around and see the room.
Finally, someone who can.
Within the room, as I mentioned, we have a perforation into the wall, a nice round hole. As I recall, this is impact site 11 maybe, but if I swing around here, I can actually show you where that is. So the shadows you're seeing on the wall here are from the tools the investigators use. These are very common tools in our industry, trajectory rods. For this type of scanner, they often put a sphere over that rod, so that's why you see a round shape there as well. But the main point here is that there's an impact site in the wall right here. That's where a bullet hole exists. From that, I took 2 different approaches to create this trajectory for visualization for you. One, I simply took the scanned data, basically their trajectory rod in place, and looked at the many, many data points on that and extrapolated a line from it. If we use that method, the trajectory for that looks like this. So this is the blue line.
No, because this guy is a specialist in pew-pews. Wouldn't really have helped her. But they should have done a presentation showing why the car didn't hit the body.
That comes out of that, and I'll swing you directly above it so you can get what's called the azimuth viewpoint first. I'm going to click us back into what's called an orthogonal view. So looking at this trajectory, you see how as viewed, it has a slight left to right aspect to it, and it's traveling from the bottom of the screen as you're seeing it into the wall at the top of the screen. Now, the county investigators did a nice thing. They did 2 different ways with this trajectory, not only the trajectory rod itself, but they took the rod and then put a laser on one end and shined it across the room. So the bottom wall, as you're looking at it here, and measured where that dot was on the wall. So I simply took their data and connected the dots also. So between the perforation in the wall to their laser dot, and that line looks like that. So green and blue. In the trajectory world with walls, this is decent agreement between these 2 methods as far as the accuracy that we come to. And in fact, if I put plus or minus 5 degree cones, I talked about the error earlier, on both of these, we can see that those two cones look like that. That's actually a 10-degree cone for each of them, the green and the blue. And so from the data that I have for this case, for this one shot, I would include any area within that cone, either one of those cones, as the area where the firearm would have been at the time that shot was fired. I can also show you this from the side view to give you an idea of the vertical component. So I'm going to remove the left wall of the bedroom as you're looking at it here, and I'm going to swing you down. And from this vantage point, you can see how there is a downward component to these shots as well, going into that, I believe, again, number 11 hole within the bedroom.
Would that be consistent with Miss Benefield firing the weapon while she's standing in the upright position?
There are certainly multiple places along these cones where a shooter could be standing. So basically any hypothesis or any scenario that puts the gun in those cones, including that one, would be on the table. So we've seen the up and the down, the vertical component here. We've looked at the azimuth, the left and the right from above. What I'll demonstrate
No, they are more of a knifing people.
for you now with the data is I'm going to take you to the right.
If I may, Mr.
Please,
Hagan,
yeah.
as to that bullet, for the trajectory that you've just shown us, there was no indications that it had struck tissue. Is that correct?
That's correct. And I'll show you that picture of that bullet eventually. But this bullet, based on the damage that the bullet shows, as well as the nice round hole going into the wall, this is a miss of the decedent. This did not strike the decedent. If I take you to the side of the cone here, the far right side of the rightmost cone, our most right option, from that position directly over it, if you look down the hallway area, you actually, there, the fill in, you actually cannot see where that bullet struck the wall. This area right here is to the right of the bullet's impact site. We actually have to move, as I will now, over into this area. And I'll get us right at the edge of the wall. We have to come all the way over here in order to get to the impact site, which from my examination of the images is more in this area. So somewhere on the tile in here is a bullet impact site, a ricochet off the floor. That bullet goes on and then barely perforates the drywall or penetrates the drywall up in this area. So,
And that's another bullet, is that correct?
correct. Sorry, I'm on to bullet 19, as I recall, was its designator for those two.
Let me recap for just a minute. So one goes in the wall, and then one goes down the hallway.
That's correct.
And again, you can't say which shot was first or second.
I don't have physical evidence that would allow me to establish that, correct? But that bullet in the wall down there also expresses no soft damage. It is also one that did not strike the decedent.
A miss.
A miss.
All right.
So from the 3D laser scan data, and I don't have a good trajectory or a good impact site to look at here. I was unable to go in and examine the floor. If I'd been able to find that impact site, I might have been able to refine that trajectory into the wall a little bit better and give us a more defined trajectory. But other than the ballistic accessibility aspect of going down that hallway, I can't do that here. Just they're two separate trajectories that have some slight divergence in the lateral aspect.
Okay. Did I ask you what the degree of accuracy is for trajectory reconstruction?
I think we covered that turf, just that plus or minus 5 degrees is an industry standard. And based on having shot a lot of stuff, including walls, for a trajectory like that, assuming the trajectory rod was placed properly, about plus or minus 5 degrees is appropriate.
Did you have an opportunity, Mr. Hagan?
I know nothing about the Idaho
preparation
Fall
for
case.
your responsibilities in this case to interview Miss Benefield?
I wouldn't describe it as an interview by me. I was certainly present while she described the incident.
And with respect to her description of the incident, is there anything at all in your conclusions that was inconsistent with Ms. Benefield's description?
I can't think of anything that would necessarily be inconsistent. The key points that come to mind, where I remember her saying she stepped from her right to her left during the course of fire, that the decedent was moving rapidly in all sorts of patterns or manners, which would fit with the gunshot wounds entering the body in different angles. So from that perspective, no.
Give me just
Why,
a
what?
moment, Your Honor, please.
Oh, why? I don't know anything about the Idaho Fall. I have so many friends who cover it, so I haven't really picked up on it. The case hasn't started. I don't do these.
That's all,
Apparently,
Your
this
Honor. Thank
only
you,
one
Mr.
I
Hague.
went into for
Cross?
a long time.
I just have a couple of quick questions. So you were able to give opinions about where the trajectory would be for the two shots into the walls, correct?
That's correct.
But as for the injuries into the human, you cannot opine about that.
That's correct. I don't have any other sort of anchors to bring the decedent's body into play with the scene because of the lack of perforation.
Okay. And with reference to the chest wound, I saw you kind of turning it several times. So, and we've had terms used such as front and side. So if you could just show the jury, where was this entrance wound?
To the best of my recollection, and of course, I could refresh my memory with images if it's helpful, but to the best of my recollection, it's in this.
In this case, one person was dead. Today there was I believe, a mass stabulation in New York. Kids, I think, was involved. 8 stabulated.
Jeez.
Taking the tool away won't make the crime go away. We have some of the hardest gun laws in the world in Denmark. We have shootings, not every week, but we have them regularly. Only the criminals shoots in the street in Denmark. So gun reform isn't the thing I believe will fix any of these problems. The problems might be something very, very different. Start with mental hospitals and do something about drugs, because that's what they're normally used for, fighting over drugs or with people who are insane. So it's always easy to say, well, we just take the pew stick away. Well, then they'll take a machete. Yeah, but then they can only do that much harm. Have you seen what a machete can do? What was the guy in Britain last week? The soldier, was it 20 something times he was stabulated? It's a mess.
General area on the side of the chest, and then it goes in, is recovered just under the skin in the back. So if you're sort of the firearm location, it would place the upper
That was
body
last
in
week,
a vague
right?
general orientation like this.
So if you turned your body.
In this case, it's a
this
woman.
way.
Right, can you keep turning until you get to the point where, okay,
Could be.
so that's approximately.
Or it was
the
in Britain.
Positioning
So
of
very
the gun
highly
to the
gun
body.
regulated.
For the upper body, yes, I'd have no way of, correct, yeah.
Thank you, no further questions.
Redirect.
I believe
No,
most
sir.
crimes are either drug or
Can
mental.
this witness be released?
Yes.
Yes.
Sir, you're releasing your subpoena. You're free to go.
Thanks, sir.
Thank you. It's going to take you a minute to put that away, and it's about 10 minutes after 3, so I want to give you your afternoon break. Give you 10 minutes, go on back, stretch, get something to drink, maybe a little snack if you want it, and we'll get you back out here as soon as we can. So no deliberations, don't talk with anybody about the case, and don't do any research. All right?
You've been in the army. Oh, so you were one of those dragging around those old, good old. Did you get the Czech AKs or did you get the old Russians? They were craviola. We were out, we had, what do you call it, where you dig sand or gravel out to use in construction, a gravel pit maybe, and we use that to fool around and have fun and shoot a few pew-pews. And we went out there with some Polish guys because we wanted to drive. They had a armored personnel carrier for when they were minesweeping, and my ex-wife used to be a driver on one of those, so we were out there, and so I could try and drive one. Don't tell the army, I wasn't allowed to. And then we got to fire their AKs. Jesus, they were bad. I know they say, well, they can be in mud for a week and still fire. Yeah, but I could throw it and I would be more accurate with it. So yeah. Hey, bad dog. Quack, quack.
Hey, bad duck.
How was the defense not done yet? Because he can go all night long.
Oh, no one wants that. Father Time needs to just
Yeah.
go to sleep.
Well, you were serving along with your ex-husband. Yeah, that's probably. We have a saying about women in the military in Denmark that I shouldn't say. Do you all think Ashley is faking her sad reason? I take it as I try to not read into body language, because body language, horoscopes, and tool markings on bullets is all made up. I can't tell you if she's sad, bored, constipated. I don't know her well enough. I just watched her for a week, and I don't know what her mood is, so I don't try and read into any of that. And again, she could be putting it on. She could be sad. Without knowing people and have a good baseline, you cannot tell when they are making stuff up. So don't do that. I can only speak from a Michigan perspective, but you have generally 52 days to file an appeal in Michigan. Courtney Clenny is an Olympic level knife thrower.
She
because
is.
was it 10 feet away? She chucked a knife and it went in 6 inches to his chest.
Yeah, it was something like that, like 8-10 feet, I thought.
Yeah. Oh, that's interesting. So she would have been even further away. But I don't buy her self-defense claim. And there we have a lot of evidence about the dynamic in the relationship. Girl be cray-cray. Probably
well.
on a lot of cocoa too, but girl be cray-cray.
Oh, she was.
I was in the Navy as well. Valhalla is a Navy veteran as well. You made the executive decision to send Jamie her gifts instead of hanging on to them for any longer, but I don't think she's going to be happy with that. Just can't you forward it so she has to pay when it arrives?
Oh, David. Well, I was gonna make the trip this weekend, but I thought you said you weren't gonna be in town, mister.
I heard the Broken Baker was working on a Danish moon pie. Maybe you could. No, because it's a proprietary brand. It's not a type of cake. But it's just a chocolate-covered marshmallow on some kind of biscuit bottom, if I remember it right. Maybe you could make a moon pie at home. Maybe I should look into that, because hopefully this case ends tomorrow, and then I need some new content before we... Oh, we have Sarah Boone on Monday and Karen Reed on Friday next week. And I have something put in on Tuesday. Do you know what we have to have on Tuesday? To me, it looks like I put in Privileges. And I can't...
I have no idea what you're
I'm
writing.
not sure what Privileges is. And I want to watch the last Sarah Boone hearing as well, but the audio is really bad. A graham cracker, a marshmallow, and chocolate. I should do that. He's leaving Thursday, Jamie, so get up there tomorrow.
No, it was gonna be over the weekend, but he's gonna be gone.
No, it's because she can listen to the sidebar they have when the lawyers go to the judge. She put on her headset, then she can hear what's said up there. It's so she doesn't have to stand up and walk up there with them.
Yeah.
Because maybe sometime you have a
I'm not
bad
sure which one that was
defendant.
on. I think it was on
On the
young Mr. Galvano.
yes.
So we're fine to use him as a.
Yep.
Exhibit.
Use young Mr. Galvano as an exhibit. What is going on? No, this is absolutely truth.
I'm going to get I got eyelashes today, so I'm leaving my driveway today.
Well, I don't cover
Who's
the
this last
Delphi
witness
hearing.
gonna be?
This is Dr. Emma Lou, Your Honor, LEW.
Well, don't bring her in yet. I was just asking.
And Iris might join us for a statue day where she's up there with Jamie, if she can get up that
While
early.
we're on the subject, how long do you think she's gonna be? More than an hour?
Probably not. I would say maybe 45 minutes, my best guess.
No problem. I just versus 4 hours.
Correct.
All right.
No problem.
State, have you already deposed her?
Yes,
All right, so you know she's gonna say,
yes,
presumably what your question's gonna be.
yes.
I only ask because that will take us, assuming we start in the next, 5 or 10 minutes, 5 minutes, to 4:20. And I guess at that point,
4:20.
probably let the jury go for the evening. Well, you can announce you rest. We can let the jury go for the evening. You guys can say if you're gonna call any rebuttal or not, but then maybe one pass through the jury instructions. I'd appreciate that.
So would I.
Okay.
Judge, the last thing the state wants to bring up is that, we didn't bring it up during the question, but I think that Your Honor had clearly told Mr. Taylor at the bench what he was allowed to ask Detective Warren. And that did not include, don't you find it odd that the state did not call you as a witness? And I think we had litigated close to that issue, if not directly on point, and then you directed him not to. And I know we're down to a few witnesses left, but it's been an ongoing attempt to subvert justice by Mr. Taylor to continue to do things like that, speaking when we've objected and continuing to speak. And as to the, don't you think it's odd, it was actually Mr. O'Keefe who told Mr. Taylor, hey, you need to object to this. So that's a whole different objection I have that Mr. O'Keefe continues to practice law in this courtroom. But I just think that at this point, the state is asking for you to sanction Mr. Taylor in some capacity about disregarding your continued rulings. And I understand that that may not be something we address right now, but it seems to be an ongoing issue in the state. That last one with Detective Warren was the most outrageous.
Okay. I'm not gonna take that matter up right now.
Yes.
We got witnesses and other matters to deal with, so.
I just wanted to get it on the record before we move too far away from the witness. Thank you.
You got a tip or tip, Jamie?
Absolutely. All right, looks like we've got everybody back.
What'd you say?
Can we get a
Is
chop chip?
Dr.
Tip, tip, tip.
Lou ready? State, are you ready?
Yes, Judge. Thank you.
We'll do that right now.
All right. We'll bring him in. Do you need the?
I don't think so, Judge.
Yeah, exactly.
All right, y'all can have a seat. Welcome back, everybody. Any deliberations, contact outside the jury about the case or research? Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Your Honor. The defense calls Dr. Emma Wu.
Apparently it is. I don't know.
You saw this for partner testimony.
Was she at the Daniel Brown hearing?
I do.
No. I haven't seen her before.
Good afternoon, Doctor. My name is Judge White. I'm
Lolita, friends don't let friends go to LNC.
presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. Just speak in a loud, clear voice. It does adjust up, down, left, right if you need it.
Yes, thank you, Your Honor.
Good afternoon.
Good afternoon.
Would you tell us your full name and spell your last name, please?
Yes, my name is Emma Lew, L-E-W.
And do you hold any professional degrees?
Yes, I am a licensed physician in the state of Florida, so I have an MD degree.
All right, Dr. Liu. Let's take a moment. Let me just run you through your undergraduate education. Where
Yes.
did you receive that?
I graduated from the University of Saskatchewan College of Medicine in Saskatoon, Saskatchewan, Canada.
And following your college degree, you attended professional school?
I did a one-year rotating internship in Vancouver, British Columbia, and started my pathology training in Vancouver. I completed my pathology training in Saskatoon, Saskatchewan, worked for 3 years as a staff pathologist at the Royal University Hospital, then came down to Miami in July of 1991.
And with respect to your work experience, what brought you to Miami-Dade County, Dr. Liu?
I wanted to train in the best facility that there was for forensic pathology. And everyone in Canada and in the States said, go to Joe Davis in Miami. So I did.
And did you eventually rise to the position of the medical examiner for Miami-Dade County?
Yes, when I was in training, I was an associate medical examiner. Then Dr. Davis offered me a permanent staff position, and I was an associate for 10 years.
I want to ask you if you can tell us, if you can approximate the number of autopsies that you've performed.
In Miami-Dade County, it should be at least 5,000.
It's just an excuse because you have an opinion to begin with, and then you can say, well, she blinked her eyes twice. It's just because you already have your mind made up, so now you just want to point out to some things that you think would convince other people. It's like Plevin when he calls me a grifter. It's just because he is a grifter.
As part of your duties as a medical examiner in Miami-Dade County, Dr. Liu, did you also respond to crime scenes?
Yes, we responded to scenes of violent and suspicious deaths.
Would you tell us why? Well, first, let me ask, is it typical for the pathologist to respond to crime scenes? And depending on that issue, why you chose to do so?
Yes, in Miami-Dade County, when law enforcement needed a medical opinion, whoever was on call as the medical examiner would respond. And the purpose is twofold. Number one, so that we can provide an opinion about the circumstances of death or the types of injuries on the body. And also for our benefit, so that I can see, or we can see, the body in the context of its surroundings and be able to better interpret our findings at the time of autopsy.
Do you teach any courses?
Yes, I used to teach in the medical examiner death investigation course, and I still teach for the Carnival Cruise Line's security conference, and I will be lecturing in the Miami-Dade Police Homicide Investigations course.
And how about gunshot wounds? Have you taught courses in gunshot wounds?
Not entire courses, but I have taught the section about gunshot wounds in death investigation courses.
Let's not take anything for granted. If you'd be kind enough, would you explain to us, Dr. Liu, what is an autopsy?
An autopsy is the examination of a dead body. It consists of two parts. One we call the external examination, and that's when we look at the outside of the body and describe such things as height, weight, color of hair, eyes, scars, tattoos, any evidence of medical intervention, that is, any evidence that paramedics or doctors and nurses may have treated the decedent, and then any evidence of injury. After looking at the outside of the body, both front and back, and in the orifices, then we do the internal examination. And that's when we open up the body cavities to examine all of the organs and tissues inside the body cavities, from the brain inside the head down to the pelvic organs. That is an autopsy.
Dr. Liu, were you asked to assist in this case?
I believe I was, yes.
Would you tell us how?
I believe you contacted me.
And what did you do in preparation for your testimony here today?
I reviewed the autopsy report. I reviewed some of the autopsy photographs, and then other circumstantial evidence, as well as having spoken also with Mrs. Benefield.
Okay, I need you to try to keep your voice up. Did that include being present for Miss Benefield explaining what had happened?
Yes, I had made a previous trip to Bradenton and had met with Mrs. Benefield.
I'd like to ask you, Dr. Liu, about the gunshot wounds in this case.
Yes.
Will you tell us how many there were?
There were 3 separate gunshot wounds.
And would you please explain them?
Yes. One was a superficial gunshot wound on the right upper arm. And that we call a grazed gunshot wound. That was one of the gunshot wounds. Shall I explain the direction?
Please.
Now, you probably heard about pathways of gunshot wounds from Dr. Vega. But as a quick refresher, if, for example, a gunshot wound was from front to back and right to left, that is relative to the person shot, not to you, not to Mr. Taylor, but relative to the person shot. So if it's from front to back and right to left, it is coming in from the victim's front towards the back and from his right side towards his left side.
And was there another gunshot wound?
Yes, there was another gunshot wound on the right side of the chest, just outside of the right nipple.
Please do.
And yes, the pathway of that gunshot wound happened to be from front to back and right to left. And I'm sure Dr. Vega told you it just nicked the bottom of the right 5th rib, went through the right lower lobe of lung, then through the part of the spine, the bone of the spine, then the left lower lobe of lung, and then nicked the back of the left 10th rib.
And lastly, was there a third gunshot wound?
Yes, there was a gunshot wound. This time it was a through and through gunshot wound, or what we call a perforating gunshot wound that entered the inside back of the right thigh, went through both right lower leg bones, and came out the outside of the right lower leg just below the knee. And that pathway was from back to front, left to right, and upward through the right lower leg.
Let me, if I may, using the easel, show you picture. And have you explain to the ladies and gentlemen of the jury, you mentioned that the abrasion wound to the arm, did you tell us what the trajectory was for that?
In my opinion, the pathway of that bullet was from front to back, upward, and slightly left to right.
Okay, so how, Dr. Liu, are you able to reach a decision like that on something like an abrasion wound?
Through experience and training, having had hundreds of gunshot wound cases and seen thousands of gunshot wounds and supervised hundreds more cases.
Okay, let me show you these two demonstrative aids and ask, with court's permission, if Dr. Liu could step down. I wonder if we could have the easel so I could set these up.
Amen.
Dr. Liu, here is a pointer that will help you.
State, feel free to reposition as you need so you can see what's going on.
Thank you.
With court's permission,
Yes, ma'am,
I
you can
ask
step
Dr.
down.
Liu to
Thank
step
you.
down.
State, have you already seen these?
Yes. Not until now, but I just saw them.
Okay.
You have a preference of which one you'd like to start with? Okay, this
Yeah,
one.
Mahabika, as long as she didn't want you on the slab, lying perfectly still. I won't
All
bring
right,
it up.
would you
but,
tell us what that represents, Dr. Liu?
This is the graze or superficial gunshot wound on the outside of the right upper arm. I know there's a
Yes, a rod.
point that will draw that.
We have three.
Now, the reason I know that this is a graze gunshot wound is, from training and experience. Because it's a deeper red, I know it's a deeper part of the wound than here inside. Now, as the projectile skips across the skin, because it's so superficial, it raises skin, it causes skin tears and raises skin tags. Now, there's some skin tags here, but the best one is this one right here. See this D-shaped tag? And for simplicity, how I remember pathways of graze wounds is that the skin tags point toward the gun. So, if it's pointing in this direction, the gun is somewhere along this line here. So the bullet, therefore, is coming in this direction, going from front to back. This is the front, this is the back, going from front to back and upward. And because it's on
do you know what could be really interesting, Jamie?
What?
this part of the arm,
Watching what she's doing.
to my left, to my right. So this is from front to back, upward, and slightly left to right.
Is that how you can tell I'm not watching either?
If I may.
Yeah, wouldn't that be nice to get to the board?
This is the gunshot wound that we just spoke about. You can see how it's going front to back and upward. This is the right nipple. This is the second gunshot wound. But it's been a bit changed or altered because the back portion that's straight was an incision made by the doctors in the hospital. So the gunshot wound itself is this round part. Now this is the one that goes from front to back and right to left. The bullet was found by Dr. Vega on the left side of the back. Now, there's something special about this gunshot wound that Dr. Vega may have told you already. After going through the nicking the right fifth rib and the right lower lobe of the lung, it then hits the spine. Now, the skull closely surrounds the brain and protects the delicate brain. The spinal cord is an extension of the brain, and the spinal cord is protected by the spine, which is made up of multiple blocks of bone. When a projectile cuts across the bone of the spine, even though it doesn't touch the spinal cord, the energy that is expended by the bullet impacting the bone is transmitted to the delicate spinal cord. And what this wound will do, because the bullet went across the bone of the T10 vertebrae, it causes a spinal cord
Oh my God, that
shock.
dog is just so
And
spoiled
the
rotten.
result is paralysis of the legs. I know because I've had cases like this where a bullet not even going through the bone of the spine, just passes by the side of the spine, caused the man to fall on his back, and he was heard to say, "I can't feel my legs." So that's something that's significant and important about this country.
All right.
She fell asleep.
Nope.
I think you can probably return to your seat if you like.
But he'll fall asleep on the table. Oh, Ashley, no. I'm talking about Molly. Yeah, I'm gonna miss her.
Does it have some water in it?
It does. It's too complex for me.
Let me see if I can tell.
Not too much.
Yeah, but Jamie isn't like her. She's not cuddling on my table. Hey, David Claire,
Dr.
welcome.
Lou, did you have an opportunity prior to your testifying here today to meet and observe and listen to Miss Benefield explain the events that took place on that day?
Yes, I did. It may have been last year that I did that.
Is there anything at all with respect to your findings that is inconsistent with the explanation Miss Benefield gave?
I believe that Mrs. Benefield's account is consistent with the evidence on the body, and I can demonstrate that.
At the time that you observed Miss Benefield explain these events, did she know what the actual physical evidence was, the actual
Objection.
forensic
Here's the
evidence?
If she can answer without speculating.
I do not know. However, usually the person doing the shooting does not know about the autopsy results. And even if they got the autopsy report, they would need someone to translate the autopsy report for them. So I doubt it, but I am speculating.
Were you struck by the explanation you received in light of that?
Objection relevance?
I'll sustain.
Yeah, that was a stupid question.
One last question, Dr. Lou, if I may. How many times, if you can approximate, have you appeared as an expert pathologist and testified in court?
During my career, at least 500 times, and then maybe 20 some times more after I retired.
And the vast majority of those occasions, did you testify for the defense or for the state?
Most of those times I testified for our state attorney.
I have nothing further, Dr. Lou. Give me just a moment, Your Honor. Yeah. Dr. Lou, would it be helpful if I were to volunteer my law clerk to come up and allow you to show with the trajectory rods the wounds that were sustained by the deceased?
I believe it would add a new dimension to my testimony. Yes.
Okay. Judge, with your permission, may I?
Yes.
Come on up, Will.
May I step down, Your Honor?
Yes, ma'am, please do.
May Dr. Lou step down?
Now, I believe that the Gray's gunshot wound was the first gunshot wound because Ms. Benefield indicated that Mr. Benefield was coming towards her.
Objection, Judge.
I'm going to sustain.
Go ahead, Dr. Lou. You just can't say what Ms. Benefield told you,
Okay.
just based upon your conclusions.
I believe the first gunshot wound.
And I would object to that opinion, Judge.
I'm going to need you to approach, please.
Yeah, it's been 20 minutes since the last sidebar. Let's get back to it. But again, she's been testifying 500 times. She should know what she's allowed to do and not allowed to do.
Yeah. Yeah, but Father Time isn't the best at this stuff.
No. But again, remember Lawyer Murphy? She was also very opinionated and
Yeah.
kept talking.
Dr. Lou, without regard to anything that Ms. Benefield may have said that you've heard, based upon your expertise and your own conclusions that you've reached, do you have an opinion as to which one of these shots may have been fired first?
I believe that the right upper arm Gray's gunshot wound was the first shot.
Are you able to say why, what independent evidence exists that leads you to that conclusion?
I have based my opinions on the circumstances provided to me.
Okay. And would that be consistent, the upper right arm wound, would it be consistent with the bullet that went down the hall, for example, and lodged in a book?
Yes, it would be, because it didn't go into the body, it just went across the skin. So the bullet would be free to continue on into another room.
Okay, and because it was just a graze, it would not have any tissue effect or mushrooming, as they say, correct?
Objection, objection. Lack of knowledge.
If she can testify to that from her knowledge and experience.
Because it only grazed the skin, nothing went into the hollow point nose of the projectile to cause deformity or mushrooming of the projectile. So it would be more or less pristine.
All right.
I think it's
Now,
his
you
legal
told us,
assistant.
Dr. Lou,
That's
about
what he
the
said.
shock
It's his legal assistant.
to the spinal cord from the shot that entered the chest.
Yes, going from front to back and right to left.
Would that have, in your opinion, affected Mr. Benefield's ability to stand?
Yes, as I explained earlier, it would cause a spinal cord shock, causing paralysis of the legs and causing Mr. Benefield to fall.
And in falling, would it be consistent that his legs would go up in the air almost as if he slipped on a banana peel?
Yes, that would be consistent, and I can demonstrate.
Please.
With your right side facing the judge.
Judge, with the court's permission, could the jurors perhaps stand so that they could see this demonstration?
With your right side facing the
Judge, I'm confused as to what we're demonstrating.
We're demonstrating the shot to the leg.
Oh, the shot to the leg.
Yes, sir.
Okay, folks, if you need to stand or reposition yourself.
Now, the entrance was on the right side of the, okay. The entrance was on the right side of the back of the cab. And the exit was here. Now, you can see that the gun would be somewhere along here. So you can see how consistent this pathway would be from getting shot while he's on the ground with the gun being in this position. So it's going in here and coming out here.
Okay, so this would be, in effect, a snapshot in time.
That's sure.
Yes, it happens very quickly.
All right. And would it be consistent, Dr. Lou, with the shot to the chest, paralysis, Mr. Benefield falling backwards, his legs going up in the air, and another shot going through the leg?
Yes.
All right.
Yeah, they don't show it because of the story.
So those gunshot wounds is consistent with that.
All right, thank you very much. Thank you, Will. I have one last question for you, Dr. Lou. You can take the witness stand. Do you recall whether there was any other injury to Mr. Benefield that would be consistent with his legs going up in the air and him falling backwards so that his head would hit a tile floor?
Yes, Dr. Vega found an abraded contusion on the back of the head. A contusion is a bruise. An abraded contusion means that there's a little bit of scraping of the skin or crushing of the skin in the center of that bruise. That is entirely consistent with Mr. Benefield's back of the head striking either the wall or the floor as he fell on his back.
Thank you very much, Dr. Lou. I have no further questions, Your Honor.
It's good. It's good defense. A good
I
defense.
just want to ask you about the leg wound.
Yes.
For a moment. You're not saying that that is the only position that he could have been in, are you?
No, I am not saying that.
Okay, so there are other positions that maybe could have produced that wound path.
Yes.
Okay. The one that you are describing is just one that is consistent with it.
That is correct.
And when you said his spinal cord would be, I don't know what you said, shocked, maybe?
Yes.
Concussed? I don't know what you said. And his legs would go paralyzed.
Yes.
Does that normally mean that they stiffen, they straighten? Does it mean they crumble? What does it mean?
Different people react differently depending on the position that they're in. And paralysis usually means just not being able to move.
Okay. So depending on maybe what movement they're doing at the time, that's what they're going to continue to do.
Possibly, yes.
So if he is walking towards someone, we fall backwards with paralyzed legs?
Well,
We weren't there, so I don't know exactly his body positioning and movements.
Okay. And you spoke about the abraded contusion on the head, and that can be consistent with falling
Yes,
from a gunshot. Can it also be consistent with being drug out of the house by EMTs?
not unless that part of the head would be struck on something, because the contusion is a bruise which requires blunt force.
Right. So if, for instance, he was being drugged.
You don't drag a body out and bump it
Well,
along the way.
ma'am, I was trying to find the words. Like,
Yeah,
do you think they just dragged him out by his feet and just let his head just like smack into
especially
things?
because he wasn't unalived at that point. So
No,
yeah, they just took him by the feet and drug him.
like, oh my God.
drug out and hit the door jamb or something. Bounced his head.
Why would they have done
Could it
that?
have caused that kind of abraded contusion on the
Well,
head?
she was guessing on the other part. So
Well
you can guess
done
on
with
this
enough
one.
force, that is possible.
Okay. Thank you. No further questions.
What are we gonna do with
What?
those EMSs if that's what they're doing with them?
Dr. Lou, would the abrasion wound to the right arm of Mr. Benefield be consistent with him lunging towards Miss Benefield?
Remember, the pathway is from front to back and upward. So if he was lunging and you were the shooter, you can see how that would be consistent.
That's all. Thank you.
Do you have any questions on that?
No.
All right, can this witness be released?
This was a good witness.
Can the witness
Yes.
be released?
Yeah, I thought she was.
State? Ma'am, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Thank you very much. All right, Mr. Taylor?
We have this one issue left.
Okay. All right, members of the jury, there's a legal argument I need to take up. If you could step out for about 10 minutes for me, we'll do that, then we'll bring you right back. No deliberations, no communicating with anybody about what we've talked about the case, and don't do any research on any of the issues. We'll get you right back in a second.
And you should see Molly. She's lying on my table, sleeping.
Okay, oh, you all can have a seat. The jury's out. And was this the issue of the Richardson?
No, this is the DNA issue.
Oh, yes.
And I have the following case for the court. Ladies.
Thank you.
Yeah.
Yes, sir.
Yeah, but the state didn't say that. Bum, 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 bum.
think that was the last witness, wasn't it?
Yeah, the problem is it's way too long. Way too long. Yes, the gallery shows respect to the jury as well. Apparently, this was the last one. If they don't go into the DNA thing, rabbit is quite good. I never had catfish. I tried it when I was in Tennessee. I liked it, and I'm not a big fish eater. Because when you're abroad, try something different. So I tried McDonald's.
You've never eaten McDonald's?
I love you, Jamie, but sometimes you are a little easy.
I don't know what's happening.
No, I tried Saxby's. I don't have that at home. I tried. I think Valhalla bought me Hardee's, the Baconator. That's from, isn't that Hardee's?
Baconator's Wendy's, remember? Did you go to Wendy's?
Yeah, I had the Baconator when I arrived in Tennessee. And then we had Chick-fil-A, Saxby's.
Cheesecake Factory.
Cheesecake Factory. And then some local restaurants. No Sax, not Smecks. I had heard that catfish had a taste of mud, but I liked it. It was a nice. Well, it was deep fried. Everything's nice after being in the wishing well. They are talking about some DNA stuff. What part of it? I don't know. They want to let in that she had DNA on her wrist consistent with his DNA. But they didn't call the tech who could verify it. I absolutely never say hi. I say hey sometimes. I haven't had Dairy Queen since I was in Illinois. I think I liked it.
Dairy Queen is. Ice cream is delicious.
Zach doesn't have these, and I didn't try them. Well,
Zach doesn't.
I like the Saxby sauce. Take that any way you want to do with that. Zachary. I think you want to take it the dirty way. Yeah, it's the chain of custody issue with the DNA evidence. But I think the catfish thing, isn't that like people who says that the lamb always tastes woolly? I didn't like lamb when I was younger, but my brother-in-law makes a great rack of lamb on the grill. So I changed my position totally on lamb. Hardee's fries. Well, because we were driving to the expert and I had to talk to everyone, my Baconator got semi-cold. They're not good when they're cold. They could get the DNA person down there, but no one ever had crawdaddies. We don't really. Shellfish isn't a big thing in Denmark. Lobster is something you eat for New Year's. I'm not a fan of lobster. Lobster needs a lot of butter to be good. I did do it's a long time ago in Sweden. We were they boil a lot of shrimps and then you sit there and peel them and eat them at the table. I was too young to have the snaps you need to have it with, but I do like a good. I know Jamie hates the way we eat shrimps, but a piece of white bread with mayonnaise or with butter, and then tons of shrimps on, and then mayonnaise on top. Oh my, salt and pepper. That's great. Medina loves salmon. I don't.
Oops.
Yes, I do always eat my fries before my sandwich. I don't like soft fries.
Yeah, you gotta eat your fries first. They get cold
Well,
fast.
Brian, I know that, but I'll I'll allow it. Krispy Kreme just came to the UK. The salted caramel one is absolutely divine, but so expensive, almost $4 for a tiny donut. I tried Krispy Kreme when I was in Switzerland. I don't like it. It's too fat.
It's too
Appetizers,
fat.
potato skins. Never had that. Mozzarella stick. They're good. Mini pizza bagel. Nah.
Our day, exactly. It's all about the
All right,
apps.
go ahead, sir. I've had a chance to review shorter.
We don't eat rotten fish. Icelandic and Swedish people eat rotten fish. Who is not under the Danish crown? Icelandic and Swedish people. Who have we fought more wars with than any other nations in the history of the world? The Swedes. I'm just saying. There's a reason Sweden is weird.
Okay, so this was a DNA report, precisely what the circumstances are here.
I don't
The
accuse you.
state initially wanted to introduce it, but then changed their mind because it didn't have any.
Actually, I love to mash everything together. My mom got mad because I don't want to eat potatoes, so I mashed them up because I like mashed potatoes. I'm that weird kid.
Inculpatory conclusions for purposes of the defendant. At that point, the defense moved to introduce it because it was exculpatory. The court allowed the admissibility as a business record, distinguishing it from Crawford because since it was the defense that was seeking to admit it, the confrontation issue was not essential. And on appeal, the appellate court sustained that admission under the business record exception, which is precisely what the circumstances are here, Your Honor. So I can't imagine that the state is going to, and I would further say to the court, the chain of custody is irrelevant. We're not objecting to the chain of custody. I can't imagine that the state would object to their own chain of custody. So
pickled herring is divine.
We think that the shorter case clearly establishes that the court can admit that DNA profile, the results, as a business record.
Judge, I thought I made it abundantly clear. I'm not objecting to it being a business record certification. That's what I said 6 times. My objection is that there has been no foundation laid to then make that report relevant. That is hearsay in the report. That the fact that those swabs are identified to Ashley Benefield or Doug Benefield is hearsay to DNA labs. That means some crime scene tech who did not testify before this jury went and collected his DNA stain card. A different crime scene tech who testified she swabbed her but was not shown swabs to make sure those are the correct swabs, then swab her and put those in property evidence. That's all. We don't have any evidence that the same swabs that she was collected then went to DNA labs. And that's what you have to lay the proper foundation. And this is the case I was referring to when I didn't refer to it by name, but this is what I read when I made my objections, because my objections are what I've already stated, but also 403, just that lab report in evidence. This is very confusing. It's DNA, and it's overly prejudicial to this jury for what I think what it says is this state didn't argue, and I am arguing, how the forensic casework would be unfairly prejudicial or confusing in regards to the work of the jury. This is DNA. I don't know, they sent us the bench notes and the report, but there's no explanation of the statistics, how they came upon those statistics, where those swabs came from, all those things, and I think that will be very confusing to the jury without somebody here. So I'm not making a certified business records objection. I'm making an objection to the contents, and that there hasn't been an adequate foundation, and that they're confusing.
Sure.
Yeah, so the court recalls that Detective Warren sent the swabs to the lab. Megan Dorvac testified that she swabbed Miss Benefield. I asked her why. She said because it would show who had touched her. The court should recall, consult your notes, Your Honor. Miss Benefield testified that Douglas Benefield grabbed her by the hand and spun her around as she tried to leave the house. This report corroborates that to the extent of, I think, 720,000 times more likely. We think it's an essential component of our defense. Now, we don't have any. Chain of custody is irrelevant. Even though they've just basically undermined their own chain of custody, it's not an issue. It's the result that for our purposes and our defense is essential, Your Honor. This case allowed it to be admitted as a business record. The assistant has made eminently clear that that is not why she's challenging it as a business record. I don't seek to introduce the entire report. I will be quite happy reading these two sentences, if I may.
Thank you, because I haven't seen this. Thank you. All right, final thoughts? Is that everything?
Yes, sir.
This is, what I've been handed is not marked as an exhibit. It's a 5-page document from DNA Labs International.
That's the same one they used in the Kerry case.
It's a letter or report to Detective Justin Warren and a sergeant
I don't know what Usk is.
at the Manatee County Sheriff's Office. And it is signed by Jerome Rem, R-E-M-M, forensic DNA analyst. It lists a number of items. $14 different items that were apparently sent to DNA labs for DNA testing. And the particular section the defense says they want to admit is agency item number MRD5, which would correspond to DNA Labs International item 20-10880, swab from suspect's right hand.
They should be resting,
And it says
but I don't know
that
if they have to calling a DNA lab as guy thing.
testing was done Mixture of 2 individuals, at least 1 male contributor. And it says Doug Benefield and John Sant could not be ruled out as possible contributors to this foreign DNA profile. And it gives, based on its testing, 2 different propositions that were considered to explain the results.
That would be the ultimate twist.
One is the DNA profile obtained from the swabs is 720,000 times more probable if the sample originated from Ashley Benefield, Doug Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. So there's strong support that Ashley Benefield, Doug Benefield, and 2 unknown persons contributed to the profile rather than Ashley Benefield and 3 unknown persons.
So don't ask you to read that sentence.
I am. I'm reading it as I go.
Okay, thanks, sir.
If applicable to the case, it is recommended that reference standards from any first-degree relatives of Doug Benefield be submitted for additional comparisons. And I think this is the second proposition that DNA Labs is considering. The DNA lab profile obtained from the swabs is approximately 75 million times more probable if
Yeah,
the sample originated from Ashley
I don't know why the
Benefield
state wanted
and
to keep it
3
out. It's
unknown
really easy
persons
to disprove
than
that
if it originated
it
from
could only
Ashley
happen.
Benefield, John
They were
Sant,
moving together.
and 2 unknown persons. Therefore, there is extremely strong support that Ashley Benefield and 3 unknown persons contributed to this DNA profile rather than Ashley Benefield, John Sant, and 2 unknown persons. The DNA profiles of additional contributors to the mixture were not determined. However, there's results that are suitable for comparison.
Yeah, again, it's weird.
All right, so obviously those of us who have done a number of these cases understand what those statistics mean when you're looking at known standards versus unknown DNA samples or swabs and the comparisons. I am not sure, and I do not have the belief that interpretation of DNA results as outlined in this DNA Labs report is within the common knowledge of a lay juror, a regular juror. That's why the standard we usually see is one of the parties, whoever it is, whoever the proponent of the evidence is, calling the DNA analyst, generally after showing and evincing whoever took the sample, packaged it, where it was stored. It was then sent from the property and evidence room to the DNA lab, and the DNA lab analyst will say how they went and got it. And I'm just going to disagree that chain of custody is not important. That's why we have it, and that's why we have certain predicates to establish evidence from a crime scene to court and who touched it and how it changed and what was done to it. So I disagree that that's not important.
Isn't that when the defense contests?
In the problem, well, I gave everybody the chance to argue. So I got a chance to read the shorter case, and the shorter case supports what the court is saying. It says that they leave the issue for another day, whether it could qualify as a business record. However, there remains, and this is at
No, they are out again.
692 of the decision. However, there remains a very significant section 90.40.
That's the prosecution's job is to tell that side of the story.
3 concern about the admissibility of a DNA forensic report if the expert preparing the report does not testify. And the reason the 4th DCA, it says so in the very next paragraph, the reason the 4th DCA upheld the admission was for that very reason, that the state did not argue 403. And here they are. Here the state has argued the 403 for a jury to understand what these mean, what these findings mean. I don't find that the probative value is, I do find the probative value is substantially outweighed by the danger of the confusion of the issues, the misleading of the jury to try and understand what this report says and be subject to cross-examination from, well, this time it'd be the state, but it's usually the defense, to explain, where do you get this? How do you get 720,000 times? How many loci were matched? How did you conduct these evaluations? And then what does it mean, the very strong support?
That is.
And then it's also, you've got, the other problem is, Mr. Taylor, you're telling me you only want to read this, you said 2 sentences. Yeah, these 2 sentences that are highlighted.
Correct.
But that's only one of the 2 sets of propositions that could potentially explain this. And
He want to put in a DNA report as a business paper, but there's no foundation for it. And it's not saying what he claims it's saying. This is the 3rd time he claims that a piece of paper says something that it doesn't say.
the first proposition you want to use doesn't even mention Mr. Sant. And if I'm reading this correctly, there's also a recommendation that there should be some additional testing. There's also additional DNA profiles that are in these mixtures from Ms. Benefield's right hand that are suitable for comparison and have not been compared. So, I mean, I have significant concerns about the misleading of the jury by putting this in.
Can I make my record?
It would, if it would,
I think it has been really bad between the 2 parties, but I think the judge has been fair. I think we have had way too many sidebars, but we saw that already in the pretrial hearings. They didn't like each other. You're lucky, Nate, because we're watching
no,
at
sir.
normal speed.
Based upon the request that's before me, which is only to put in and read into evidence these 2 sentences regarding one of the propositions that was considered by DNA labs and interpreting their test results, Certainly that would be even more misleading because it doesn't get into the other proposition and the other testing that needs to be done. So based upon that, do you want to have this marked and put into evidence?
Yes,
As a
I'd
proffer?
like to proffer for the record, Your Honor.
Do you want to put a number on it? What's your next number?
29, but this is the whole record.
Well, hold on, you're handing me a stack of paper that's about, what, 1.5 inches tall?
Yes.
And the only thing you said you were going to enter was this 5-page.
Well, no, I said the only thing I wanted to enter was to read those 2 sentences. This is the full report.
All right. So it would be your intention to admit into evidence Defendant's Exhibit 29. What is this in here? Or does this go in here?
Yeah, no, that I believe is in there. This comes back. Oh, I'm sorry, Your Honor, I stand corrected. This goes in with the report.
I'll let you put it where you want it.
All right, can I make a proffer for the record?
Yes, absolutely.
All right, thank you.
Beyond, I thought you already did. This is the proffer.
Well, I'd like to make a verbal proffer as to precisely why I think it should be admissible.
Yes, sir.
Okay, so unlike a DNA report that's inculpatory, which requires a chain of custody so that justice is established in the admission of inculpatory evidence, in this instance, Judge, we believe this DNA report is exculpatory. And we believe it's exculpatory because it confirms Miss Benefield's testimony that Doug grabbed her by the hand and spun her around as she tried to flee. It's independent evidence that not only corroborates Miss Benefield's testimony, but also corroborates our defense. And because it is exculpatory, chain of custody is irrelevant. We are making no objections to chain of custody. The case law that I submitted to the court, the shorter case, clearly would allow it. And it would be my intention, which I don't think is confusing at all to the jury, to tell them the DNA, reading from the report, the DNA profile obtained from the swabs is approximately 720,000 times more probable if the sample originated from Ashley Benefield, Douglas Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. Now, maybe I misunderstand this, Your Honor, but to me, what that says is there's
Never been on kick. I don't know anything
times
about
more
kick.
probable that Doug Benefield touched Ashley Benefield's hand. That's what I believe this says, and that's what I think
Then get the
should-
tech
we
to
should be
testify
entitled to
about
get
it.
to the jury.
All right, thank you. Do you want that right after the first page?
You can put it right on top. Your Honor.
It'll cover up the exhibit number then.
It is
okay.
So I'm just putting it right
1.25.
behind it. And as I said in my ruling, I think that those questions and what that means and how it's interpreted and how the jury can use that to be relevant to its deliberations and its findings. I'm not saying it's not relevant. I'm saying the problem is 403, as the 4th DCA recognized, not having that analyst causes significant 403 problems with confusion and misleading. So that's the basis of my ruling.
What if I told the court that the actual DNA lab expert is available, but not until after 2 tomorrow? And it would have to be by Zoom.
There's motions that Florida Rule of Criminal Procedure 3.116 defines how and when that can happen. So we need to bring the jury back in, and I just need to know if your intention is to call more witnesses or if you're resting.
Well, I make a formal request that the court abate the proceedings so that we could call the analysis. If the court denies that, then we will rest.
All right, well, there's Florida Rule of Criminal Procedure 3.116 is very specific. It just came into effect, it was just substantially, I'll say substantially, amended effective July 1st of this year regarding the use of remote technology. If you want some time to look at that, I can certainly give you that.
I'm familiar with it.
So do you have
We'll rest.
okay, let me bring the jury in.
They will rest.
We can do that, then I can let them go for the evening. I'll tell them to be back tomorrow morning at 8:45, just like we've been doing with a 9 o'clock start.
Yes, sir.
Just so you know also,
No,
we
she's
had
fresh.
submitted, the court may recall, you requested copies of the proposed homicide charge. And we had submitted our version to you that we thought would be appropriate. And I did not save a copy of it, so I don't know if the court has it.
I will have to look. Did you send it by email?
No, I believe we handed it to Your Honor.
Yeah, now people pointed her out. She looks kind of like a Rocky who stands there and moves around a lot. Which design have you made in Norway?
Welcome back, everybody. Y'all can have a seat. All right, anybody do deliberations, talk with anybody outside the jury or do any research? All right, everybody says no. Mr. Taylor?
Yes, Your Honor, Ms. Benefield has no further witnesses and we rest on her behalf.
All right, so folks, at this point, it's 4:30. The attorneys and I have some work to do before we can get things going again in your realm of the case. So what I'm going to do is let you go for the evening. If you could please be back tomorrow morning at the jury assembly room around 8:45, just like today. There were probably people down there today. I don't think, was there any civil juries or do you know? There might be a smaller group tomorrow. There might be some judges in civil court picking some juries. So find your area and kind of hang out. And we'll have the deputies come down and get you as soon as we're ready and bring you up and get started. All right, remember the rules for tonight? Don't talk amongst yourselves. Don't talk about the case with anybody else, and no research about people, places, things, or legal topics.
Thank you.
Thank you. Have a good evening. Oh, you all can have a seat.
Fed, is it the A1 or the B1? That's the Norwegian one. If you know, you know. I do have both in my kitchen.
I'm going to have to give you all, let me give you guys a 5-minute break. I'm going to go upstairs and I don't have it in the pile I have with me, but I have a whole other pile. So let me run upstairs to see if I can find it. Yes.
And I have the state's proposed jury instructions and the standard for self-defense because it changed in May and I just wanted to include it.
So you got the new one?
Yes.
All right.
But I brought the standard because the instructions are very different than they used to be, so I just brought an extra copy.
I don't like
And you have an
it.
extra copy for.
Yes.
So
if
5 minutes, I'll be right back down.
It kind of drags. I like.
Thank you.
I think it's Danish design with the string. I like that more because that cuts better. I hope my back is better tomorrow. I probably won't. I should have been training back tomorrow, but I won't do that. Jamie, are we going to sit here and wait for them discussing jury instructions? Or are we just going to listen to them when they read them tomorrow?
Yeah, because I got my appointment, so I'll have to.
Yeah, you have your lashment.
My lashment.
45, I believe it was. Yeah, it's a good judge. Yeah, but I like a Havarti or something like that, and I think it kind of rips the cheese more than it cuts it.
Havarti cheese?
Yeah.
I like Havarti cheese.
That's because brown cheese is it's not it's very dry. Well, Jamie and I will end now because it's 10:30 my time, and they are gonna argue for forever, and we will hear the jury instructions anyway tomorrow. So I don't want to waste 2 hours listening to jury instructions that I'm gonna waste 45 minutes listening to again tomorrow.
Right.
Yeah, the string one is best for that one. It reminds me, I need some cheese when I have my family coming next Saturday. Jamie, I think we might be having. We probably have to do Statue Day later next Saturday.
Wait, what?
I'm thinking Statue Day later next Saturday.
Well, I'm actually going to a baseball game on Saturday, so if you do it later,
Oh,
well, then we
so
do it.
okay. That's okay, Jamie. I was planning giveaways and extra
don't be.
laugh therapy, and I had found the most perfect dear letters, but okay, then it's off again. Thank you, Jamie. I might try and see if I can find the Sarah Boone hearing then. Just do that.
Aw.
Why don't you just spit in my face and tell me you hate me?
Oh my goodness. You are so dramatic. Why are you being extra?
Because I have been off the last 2 weeks, so now I can finally blame someone else. No,
Yeah.
Jamie, we'll be back tomorrow at roughly 9:00,
Yep.
and hopefully closing won't be too bad. I might be a little afraid this could go really, really, really bad, but I'm hoping it's going to be okay. That we don't have too many objections, and yeah.
Mm-hmm. Father Time needs to get it together.
Yeah. Oh. Oh, scratchy, scratchy, scratch. Yeah, you need. She's sitting on my keyboard, so she's pulling up all kinds of windows. Thank you so much for not agreeing with. Oh, I have a poll up. I have a poll right now. 217 votes. 58% not guilty. 23% guilty, and 18% I don't know. So if we go by the standard that the jury should go by, 67% is should be voting not guilty in this case. So yeah, I never seen a baseball game. Well, I watched it on TV, but yeah,
You've never been?
we don't have baseball.
But you never went when you were in the United States ever?
No.
Oh, well, it's pretty fun.
I want to go. I looked it up when I was over there with the kids. I want to go to see the Mets play, because, as I told yesterday, I'm a Mets fan, even though I don't know anything about it. But because my brother is a Mets fan, so I've been a Mets fan since the '80s, which is weird when I'm 27 years old. But I would love to try and go and see. It looks like it's a good atmosphere, but I tried to watch it. I had on cable, I had a channel that showed baseball, and it just takes forever.
It's much better when you get to go. You'll have to do your Midwest tour and take you to a Tigers game because it's so much fun.
Well, I don't know if 23%. It's always hard with a self-defense argument because one person isn't here anymore. Yeah, but where do you see? I don't think I want to go and see one of those pro baseball. I think it's funnier to go see some local.
No, they're fun, but it's just fun. And it flies by because you're there and everybody's just the atmosphere's fun.
As long as we can get drunk. Can you start fights like we can at football?
No, they'll kick you out. And you can get drunk, but it's like $25 a beer.
What about if you grab the esky and we go to a little league game?
Go to a little league game.
Yeah. Yeah, Zach knows what it's about. We fill the esky with Yingling and go watch some. And I bet you I could get into a fight at a little league game.
Bet you could.
Well, I'm not a big fan of Indian food. Good night, dream suburb. Yeah, I don't understand those people who there's golf on TV. No offense, Tom Gillis, but whack for 6 hours, and I don't know how they keep score. I was pretty good at baseball on my Wii as well. I should go see Savannah Bananas. Cricket is another one. I scored 1,200 wickets. How? Well, I shot a ball somewhere and then I didn't run anywhere because it's just something we do. Okay. Weird sport. First of all, it's called football. Second of all, maybe it's because go on YouTube and then Google American fans versus European fans. And then you'll see why football is interesting. It's 90 minutes of people running around on the field, and then we fight about it. And then play putt-putt. That's easier. Isn't the Olympics done for today? I think it is. Well, I can't do it because of my back. Jamie, enough whining. I'm gonna take the fluff monster and put her in bed.
Okay.
And then I'm gonna lay down next to her. I might have myself a licorice ice cream. Oh, she's sleeping on my arm
Licorice
now.
ice cream?
Yeah, it's ice cream with like instead of a chocolate coating, you have a licorice flavored coating. It's good.
I don't know about you guys.
You love salty licorice.
Yeah, but I don't know if I wanted an ice cream.
You didn't like salty licorice to begin with, but all of a sudden, Heja Pernilla, vær snäll och sända mig
Vanilla,
mer
send me more
lakritz.
salted licorice, please. It was the best stuff ever in chocolate.
Yeah,
Oh,
your Swedish
guys'
accent
chocolate
is
is
as
so
good
much
as my
better.
Scottish accent. I think even the Swedes find that highly offensive, but they find everything highly offensive.
I wasn't trying to. I was kind of just like going along with what you were doing, but I'm terrible at accents anyway.
Well, now we have officially even offended the Swedes. Hasta la taco. See you in the morning.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100. Because it is 100% correct.
Objection, Your Honor. So you literally built a cannon?
Yeah, it's pretty awesome.
All
right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there-
Everybody has.